Good morning. I officially called the May 2nd, 2016 meeting of the Nevada State Board of Cosmetology to order, and the time is 9:05. The first item on today's agenda is the roll call of the board members and staff, and I'll start with the board members. Alex Leader, President, if you could please identify yourselves.
Jeanette Benaldi, board member, present.
Gwen Bramo, board member, present.
Debbie Ritchie, board member.
Our other board member, April Long, is not with us today. She's ill. Ms. Joanna Tron will be here shortly. And did we have a status update for Mr. Baltazar?
There's no status update on Mr. Baltazar.
Thank you, Mr. Landry.
I do have a status. He is actually in an Uber.
Okay, so
He's
perhaps
stuck in
he's also
traffic.
on his way, so they'll be here shortly, and we'll welcome them to the meeting. Will the board staff please identify yourself for the roll call, starting with Mr. Landry?
Gary Landry, Executive Director, present.
Adam Higginbotham, Deputy Executive Director.
Andrew Helms, Chief Financial Officer.
Mr. Mishler?
Chris Mishler, Compliance Administrator.
Ms. Bradford?
Monica Bradford, Executive Assistant.
And would the inspectors please just list yourselves, beginning with?
Delana Joseph, Inspector.
Pamela Fitzgerald, Inspector.
David Scarpelli, Inspector.
Thank you. And we have some members in the north. If you could please identify yourselves in the north. Or did I staff, rather?
Charlene Marsh, Inspector. I'm the only one here.
Thank you, Ms. Marsh. And we also have legal counsel present.
Sarah Bradley, Deputy Attorney General.
Rosemary Reynolds, Deputy Attorney General.
And then I'll just introduce Mr. Eric Nelson as our court reporter for today. We'll move on to item number 2, which is the Pledge of Allegiance. For those of you who don't mind, please standing, face the flag, and join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Agenda item 3 is the reading of the mission statement. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare through education and ensuring only qualified persons are granted licenses to perform cosmetology in the state of Nevada, and that all areas where cosmetology services are performed are kept clean, sanitary, and safe. Pursuant to Nevada Revised Statute, Chapter 644, and the Nevada Administrative Code, Chapter 644. At this time, I'd like to open up the floor to comments from the general public. Now, the board has the opportunity to listen to comments from the general public that are not published on the agenda, but is related to the business of the Nevada State Board of Cosmetology. If you'd like, anyone could please stand, but I would ask that we please limit your comments to about 3 minutes. Does anyone want to stand and address the board with any concerns, comments, or questions? Anyone in the north, Ms. Marsh? So be it. Thank you. And now we'll move to item number 5. This is the consideration and approval of the agenda and its posting. Ms. Bradford, pursuant to the Nevada State Board of Cosmetology Best Practices Guide, is today's agenda the agenda approved by the President of the State Board?
The agenda was posted in accordance with the open meeting law requirements.
Are there any discussions about the... Oh, welcome, Ms. Tran. You're quite all right. Let the record show that Ms. Tran is attending. It's 9:11. Do any board members have any questions or concerns regarding the agenda or its posting? So at this time, before we take a motion to accept the agenda, I'd like to move item number 12, which is a petition to appear regarding licensee S12422. And we'll hear that just shortly after after this item? Or should I go through the minutes first, Mr. Landry?
I would go through the minutes and the president's letter and then do it after that.
Okay, so we'll hear that first item. We're moving item number 12 to item number 8.
Mr. President, is it possible for us to also move? Are we moving agenda items at this time?
That would be great, Ms.
I'd like to move number 16 to next meeting, please. I think we need some more research on that.
Is there any member of the general public who is here specifically for item number 16, which is the removal of superfluous hair? Is there anyone in the north that is specifically here to make comments or listen to discussions regarding item 16 on the agenda regarding the removal of superfluous hair? Does anyone have any objections to moving item 16 to the next scheduled meeting of the State Board? I think it's in August. Thank you, Ms. Benaldi. So be it. Any other changes or recommendations to the agenda today? At this time, I'd like to accept a motion that the agenda has been posted according to the laws of the state of Nevada.
I'll move to approve.
Is there a second, please? Is there a second?
I'll second that. I'll second that.
I think it's a mic.
I'll second that.
Any questions, comments, or discussion? I do want to just point out, Ms. Bradford, that in the best practice guide of July 2016, it is noted very clearly that the development of the agenda, the board president or the vice president in the president's absence will review and approve the agenda. So that was the question that I had asked you. And I just want to be sure that that gets taken care of once I leave and that in future agenda items are approved by the president. Any other questions, comments, or concerns? All those in favor, please say aye.
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 Any opposed? That motion passes. The agenda is approved. It was made by Ms. Benaldi and seconded by Ms. Tran. Item number 6 is the consideration and approval of the minutes from the February 1st, 2016 board meeting. Are there any discussions by board members regarding those minutes? I'd like to accept a motion that we accept the minutes and approve them.
I'll make a motion to approve.
Is there a second? Ms. Tran?
I'll second it.
Thank you. Any questions, comments, or discussion? All those in favor, please say aye.
Aye.
Are there any opposed? That motion carries. Thank you for an outstanding job on the minutes, Mr. Nelson, repeatedly. Very nice. Item number 7 is the president's letter. You were all given a copy. It's reiterating the agenda item number 8 from 2014, moving forward with infection control and prevention policies. Mr. Landry has done an excellent job with our regulation changes and our law changes in the last legislative session to advance this new terminology, modernized terminology. Thank you, Mr. Landry. Is there any question or comments regarding the president's letter?
Yeah, I have a comment, Mr. President. I really appreciate this letter, and while I'm at it, I appreciate you, and I know this is your last meeting with us, and I want to thank you for a job well done. Really appreciate you.
Thank you, Ms. Benaldi.
I'd like to see that adopted and put on the website. I think it's appropriate and well done. Thank you.
Thank you. Is there a second?
I second that.
There has been a motion made by Ms. Bonaldi to accept and post the president's letter. It was seconded by Ms. Tran. Any questions, comments, discussion? All those in favor, please say aye.
Aye.
Any opposed? So be it. And Mr. Landry, if that could be posted at your earliest convenience. Thank you. At this time, we will be hearing agenda item number 12 in this place of agenda item 8. Do the exhibits belong with agenda item 12? This is a different one?
No, I believe that's for agenda
Okay.
8, yes.
Okay. So with agenda item number 12, is Miss Tricia Hetherington here? Hetherington? If you could please stand. And did I pronounce that correctly? Okay. And you're the owner of 2 salons with the name Pretty Kitty? Yes. And if you could come to the front, please. And if you could kindly state and spell your name for our transcriptionist, and you have a guest, and if your guest could also please state your name and spell your name for Mr. Nelson.
My name is Tricia Hetherington. It's T-I-C-I-A. Last name is Hetherington.
And my name is Dane Dishman. It's D-A-N-E. Last name D-I-S-H-M-A-N.
Thank you. Thank you very much. At this time, this is regarding license S12072 and S12422. And you are requesting a variance from NAC 644.330.2 regarding your dispensary sinks?
Yes.
So at this time, if you'd just like to present your information to us.
Sure. Do you want to go ahead?
Yeah, we're a hair removal salon. We deal exclusively with waxing, and the amount of disinfectant that we use is so minuscule. We only have 1 to 3 treatment rooms in each store, and the disinfectant that we use amounts to a capful.
Or less.
It's often, like I said, 1 or 2 treatment rooms usually being used, so the most we would ever put down any drain would be 1 to 2 capfuls. We already have a mop sink that we're required to have that that have been installed that we don't use. We're not a restaurant. We don't use grease. So we have plenty of outlets to dispose of a cap full of disinfectant per day.
Excuse me, Mr. President, before he continues on, I think both of them need to be sworn in.
And is that, I'm sorry for that logistical error. At the time that I had you introduce your names and state them, I should have also had you stand and raise your right hand to have Mr. Nelson swear that you will tell the truth in today's hearing.
You want to do it now?
If you wouldn't mind, I know it's a little retroactive, and I trust that the information that you provided was truthful, and if that is appropriate, Mr. Nelson will swear you in.
Do each of you solemnly swear the testimony you've given and testimony you will give for this Board of Cosmetology to be the truth, the whole truth, and nothing but the truth?
I do. Thank you, and thank you for that clarification, Mr. Landry.
I would like to submit something that gives a little bit more clarity to the disinfectant amounts, quantities that we are using, if that might be helpful. I have it right here. Would anybody care to?
And the cap full of disinfectant gets diluted in a jar that's approximately about a quart in size, and the only implements that are even used in this jar is a pair of tweezers and a pair of small scissors. So again, the amount of disinfectant that's going down our sink is so minute that the hand soap that we use in the bathroom probably amounts to more of a disinfectant than what we use in our implements.
And even on a busy day, the most implements that we would use would be 2 to 3 tweezers and maybe a couple pair of scissors, and that's it. That's all we're disinfecting as far as implements go.
When you opened the salon, did an inspector give you the checklist?
Yes.
And who was the inspector?
That was years ago. The first store here in Vegas that we established was in 2010, and so I don't recall at that time. And then the second location we established in 2011.
2009, 2010.
2009, 2010, so I don't recall.
And have there been subsequent inspections? I mean, generally speaking, we have inspections every 90 days.
Yes, sir, there have.
And so who's the inspector that has done the most recent inspection?
I believe it was a young lady.
Okay. And so when did we first note that there was no dispensary sink?
When I went in there, it was the first time I'd ever been in either location. So that was...
So they've been in business for 5 or 6 years. And
About
this is
7 years.
7. And this is the first opportunity that we've noticed that there's no dispensary sink?
This is the first time I've been there. I've only been with the board since October.
Okay. What did the history of the file show for the inspection reports?
That everything has passed, from what I remember.
So if everything's passing, why are they here before us now?
When I had gone in, what I had noticed is, like I said, it was my first time I'd ever been in there. The only sink that I noticed was the one in the bathroom. I asked if they had a dispensary sink, and the licensee that was there was, the first one I went into was the one on Rainbow, I believe.
Flamingo.
Flamingo, yes. She told me that she didn't have one. So what she did show me was a mop sink that was on the ground, but it was there was no way to get to it. There were boxes and stuff in the way.
Which have since been moved. Sorry, just for interrupting.
I didn't know if that counted or not, and that's when I came back to the office to ask Adam and Chris if that counted as a dispensary sink.
Mr. President?
The mop bucket.
It's a mop sink, so the sink is on the ground with a faucet up above, which I believe I have pictures of in here.
Okay.
We've been required to put a mop sink in because they treat us like a restaurant where we work with grease. We don't work with grease. We have no use for the mop sink, but we've been required to put one in.
Sir, the mop sink that you're required to use is not for grease. It's for staph infection. It's for infection control. And when you're waxing, are you a technician?
No, he's
no.
not.
When you're waxing, you're going to have bloodborne elements coming out of the follicle when you're ripping out the bulb of the hair a lot of the time. So you're releasing bloodborne allergens. It's not for grease. It's for infection. And it's important that our facilities are very clean, that we don't want to spread that. So that's what that's about. And also, and since we're having discussion, is that what we're doing now?
Please.
When you had the checklist originally for your facility, that hasn't changed. Am I correct, Monica? Or who can speak to that, Chris? Since the beginning of time, I mean, I've had salons since 1990, and we were always required a dispensary sink. So, and that is, again, for cleanliness and washing your hands and making sure every technician before and after was washing their hands, because you don't want to contaminate one to the other.
Yeah, I understand, but I'm considering it as a mop sink, which means you wash mops in it, which
For your floor.
is really anything that comes off the floor. It doesn't necessarily have to be grease, but they do call them grease traps. I mean, they've got different names for them too. So,
Yeah.
Again, it's one of those things we don't use it. We've been required to put it in, and now it seems that we're being required to put in a third sink. And
Well, what differentiates this mop sink from a dispensary sink?
I have no idea. That's why I don't understand.
Well, is it the
why
height?
That's why I don't understand.
I can send it down so you can see the picture that was taken.
But generally speaking, what is the difference? Is it the height of the sink?
It's really low to the ground.
Okay.
It's like a couple inches off the floor. It's for,
And so how come you just don't want to raise that mop sink into a dispensary sink?
Well, it's got sides on it that come up about 2 feet high. Like I said, it's a big trough.
You guys should see the photo. Okay. So it's like that.
I
My name's
guess,
Debbie
I guess
Ritchie,
we're,
board member. If I'm not mistaken, I'm trying to find it in our law book. Isn't a cosmetologist, esthetician required to have a sink in the room that you're actually doing service on?
not that we've ever been aware of.
I believe that's the law. Can you verify?
We don't have any water in the room, so then there's no need for it.
There's a law, there's a reason for that. It's for disinfection. It's for not, so people won't spread disease.
Yes, we spray our implements with soap and water, and we clean them off, and then we put them in the disinfectant. Like I said, we've had inspectors come in regularly since we've opened, and we've always passed. And so it is just interesting that now this is the first that we're hearing of this.
Well, I'm looking at your inspection report of January 25th of 2011, and item number 11 says dispensary sink installed, and it says yes by Pam Steele. That's our inspector.
Is she still with us? Debbie Ritchie, board member.
Yeah.
Yeah, that's what I thought.
But I'm just saying that, you know, I mean, it's kind of awkward for the licensee to have a form of a report for establishment that says yes, and I mean, how do you speak to that?
It is difficult, and I'm unsure not having the inspector to talk with. Our process is the checklist is done over the phone with the individual, so it is possible that this was done over the phone where we say to whoever's asking to be licensed, do you have a dispensary sink? Do you have hot and cold running water? And they just verbally say yes, and then we mark it yes.
Okay, and then the subsequent report of establishment on February 14th of the same year, 2011, says that we're going to check that because there's a question mark on the dispensary sink.
Right, and again, that makes me think whoever went out to do the first inspection saw the mop sink and was unsure. And I don't know if they ever followed up when they came back to the office, if they got busy and it just never went anywhere, or if somebody got asked and was told that was fine. I don't know. I don't have any details.
May I ask
on
what the definition of a dispensary sink is?
Can I just chime in, Debbie Ritchie, board member? Every room that is occupied by an esthetician, you have to be an esthetician to do waxing, correct?
Mm-hmm, correct.
Okay, so the law is you have to have a sink because it's controlled environment for spreading of germs. That's all it's for. I do have a solution because I'm bet with that a lot. It costs a lot of money to put a sink in a room. There is sinks that you can get online that you have to go in every night and you have to change the water out, but it's portable. So let that be an option for you, but that is the law. And I know we all want to help you, and that is a solution.
But we do waxing. We don't work with. I mean, we don't have any need for a sink in the room.
No, I understand that, sir, but it's the law.
How come with all the inspections we've had in the past, nobody's ever brought this to our attention?
Gotten very lucky.
I don't know of any waxing salons that have sinks in the room. I mean, there's dozens and dozens of waxing salons. None of them have sinks in the room.
How are you washing your hands before and after each client?
They go into, well, first they use hand sanitizer before they leave the room, and then they go down to the restroom and they wash their hands.
And we also wear natural
gloves. So
that are changed in between each client.
Yes. So they're never touching a client with bare hands.
Ms.
How
Ritchie,
does your
I'm
clients
sorry.
wash their hands and clean up? That's the reason why we need sinks out there for the public.
And I'm sorry to interrupt. I just wanted to clarify that I understand the point Ms. Ritchie is making about each room needing a sink in it for esthetician work. Unfortunately, I think there has been a change. There's only a requirement for one dispensary sink in an establishment.
Besides the restroom sink.
Besides the restroom.
Correct.
It's not required in
It's not
every
in
esthetician
every single room
anymore.
and needs to have a sink.
So if that's the case, then you'd only need to get one portable.
Pam, is that?
Actually, 2010, I did your very first opening. And if you look on the drawing, it does have a dispensary sink. I think Henderson, North Las Vegas require you to have a dispensary and a mop sink. They call it a mop sink. As inspectors in 2009, 10, 11, no, I'm sorry, 7, 8, 9, 10, 11, we were told the mop sink was okay for a dispensary sink. This is why they pass each inspection. Okay? The mop sink just sits on the ground. Literally, all they have to do is put a table, whatever they want to do, to make it be a dispensary sink. It is a dispensary sink. They just call it a mop sink. Does that clarify a little bit? I mean, just
No.
the sink sits like this. They can actually put something here, I don't know how they want to do it, but they can make it to be a dispensary.
Debbie Ritchie, board member, can they plumb in through that dispensary sink?
Probably can, yeah.
That would be a route.
It was okay, as we were told. I'm sorry, we were told as inspectors to okay the application. That's why I'm saying it passed each year, every time we went out. And then when she came in, and so now we're here today.
Sorry, my question is, the mop sink is located in the storage room, right? Okay, so I'm just trying to figure out how we can help you as a board resolve the situation. I know that it was previously licensed as, you probably thought it was a dispensary sink. It could be used for that. But if it's located in the storage room, how do you have accessibility to it?
Now, is the dispensary sink only for the employees? It's not for public, correct?
No.
Everyone, for all your clients.
Oh, so then
Everyone to right, Joanna.
why would
think there's some-
clients need a sink and the use of the bathroom?
Let me explain.
For immediate, it's going in and out, but for immediate washing and cleansing hands.
Disinfectant that we use is only disposed. I'm sorry, the disinfectant that we dispose of is only disposed of one throughout the day, and that's about 7:30 at night. All the clients are.
Well,
I'm just going to interrupt you. I'll have to speak loudly. Not quite sure what's happening. Mr. Landry, why is it that we're here today? I guess not quite understand.
The concern is that there's no.
And suggestion made to the licensees. And a problem with installing. I mean, you have the plumbing. This appears that. What's the problem?
So are you saying that it's just the height?
Well, I'm not.
Would you like?
What is the differentiation between the mop sink and the dispensary sink?
Can wash as they would normally do in.
Why aren't you guys just doing that? And then why are we? All the dispensary sinks, your existing plumbing, there wouldn't be an issue. So what's the holdup?
Used as is it?
And you have a mop sink that has been that has changed, and now it is required to have a dispensary sink, and it's always been required to have a dispensary sink. They just interpreted mop sink as a dispensary sink, if I'm not mistaken. But I understand. Now that style of sink has changed, and it does need.
So just to clarify, then I put a sink above it that's 3 feet higher than.
That's correct, Mr. Landry?
So then it's just the height of it is the issue.
Excuse me, Debbie Ritchie, board member. Several times in my lifetime. You're going to have to get a plumber, you have to go down and pull a license to do the work. You're going to have to add on, they're going to come up to the plumbing through the wall and bring it out. It's not that big of an issue, but you are going to have to pull a permit and get it done properly, where there's a sink where you can actually go in and wash your hands.
Mr. President, do we want to take a break until the mics can be fixed? I believe someone's on their way to do that.
Definitely. Well, we need to be heard from the north. At this time, the mics need to have a slight adjustment to them. So we're going to recess. It's 9:35, and we'll give them the opportunity to make those.
just, I'm just confused over this whole thing. I wish I could understand it. So, I know. I know, I get it. It's just, I can't even. What's that?
I've already submitted my paperwork for the application.
So?
I told them that we wanted to open this week, and the inspector said, told me to ask if it's going to be pending for me to get my establishment license because of the sink, because I can't get my establishment license, we're not supposed to be open. I'm not even going to break it.
I've done it.
It's just, I wonder how many, this is a shield and she's been successful.
Yeah, I'm wondering what she works for the government for.
And that one over there too. You know?
Yep. I don't know if they seem to know so much about
They
waxing.
probably don't realize that we own a lot more than the stores here.
Don't everybody put your
And her saying we have to have a sink in every room.
I know. What are all the other waxing salons doing? Does European Wax have sinks in every room?
I don't know.
Why would a permit need to be required for mounting a sink where there's already faucets? The plumbing's already in.
So, how big of a job is this?
Spend $60 on a sink, you put a sink in. But I still don't understand the reasoning behind
Right,
it.
and like we're going to have, why are the clients going to use a dispensary sink and not a
It's not for
sink
the
at the
clients.
back? No, he said that. The clients need to be able to use it. It's like, why are they going to use a dispensary sink?
Yeah, well, I'm going to try to get some clarification here.
Yeah, let me just.
She said that we need to speak one at a time because we're all pressing in the same
Okay.
messaging system. So if somebody wants to talk, just raise your hands.
I think we're ready to begin. And to help with that system not being disrupted again, I think we're going to have a little bit more of a protocol to try to only speak at one time. So this meeting of the Nevada State Board of Cosmetology is back in session at 9:43. I think when we left off, we were just maybe making the recommendation that the mop sink just simply be replaced with an upright dispensary sink. Would there be an issue with making that change?
I guess I'm still confused as what the purpose of it is. You mentioned because it was in a storage room that people couldn't get access to it. A dispensary sink to me means you're going to be pouring liquids down it.
I think,
Mr. President, can I read the law? Would that help?
Please.
Clarify?
Well, no,
Because I can
I'm
read
just
you the
trying to
law and why, and it
understand-
will clarify for you.
No, I understand that you can quote the law, but I'm trying to get an understanding of the purpose of it, because it's not for clients, as I understand it.
No, it's for technicians.
Okay,
It's for
that's- okay,
technicians
that's
to
all I'm trying-
wash their implements in between each guest. So let me just read you the law here, okay?
Could you tell us which one?
It is a NAC 64330, and that's regarding plumbing. It's required. So this is the one that's telling you it's required, right? So you've got, and I'm not going to read the whole law, but number one is telling you must have suitable permanent plumbing, and that's just to sum it up for you, which is adequate and readily available supply of hot and cold running water at all times, and is permanently connected for drainage of sewage and potable water within areas where work is performed and supplies dispensed. Then you go on to NAC 644340, and you go under 1.2, Roman numeral 1, thoroughly washed with soap and hot water. This is regarding your implements. So, and if I can ask Delaney to speak to this as far as when she was at your facility, how this is working for you currently.
When I was there, I talked to the licensee in charge, which was, let me see if I can find her name on here. Is my report in here? No. The girl that I had talked to, when I had asked her about this sink, I asked how they were cleaning their implements because I would find it hard to clean a whole bunch of stuff when the sink's on the ground. She informed me that they don't. Most of their stuff is disposable, with the exception of their tweezers and their scissors. But she told me that what they do is they just spray it with a bottle of soapy water, which, per our law, doesn't suffice for having
put it in the disinfectant.
Right, but doesn't suffice for the part of that it has to be rinsed with hot water first, and then it has to be rinsed again in water. So I was under the impression, as the way she described it, that she just sprayed it with a bottle of soapy water and then placed it in the barbicide kind of disinfectant versus actually cleaning off the hair with the hot water and rinsing it off the way that the law states that it should be.
Yeah, can I ask you who it was you spoke with? Was this a receptionist or was it actually a technician?
I believe it was a technician. I don't have my report in here. Chris, do you have it?
One of the girls.
Was it this Victoria DePaulo?
If I don't have the report from when it's not in my packet.
Or Jessica Pierce?
You don't have my report?
So again, I'm just going to come back to...
Was a technician. I do remember that because I did write her license number down.
Thank you.
Okay.
So I'm just going to get back to why don't you just install a dispensary sink and save this headache?
Well, again, I'm trying to get to the reason because we have two sets of hot cold water.
The
and we have
point of the dispensary sink is that it's required by law to wash your implements properly. You've been told by the inspector that misting them with warm soapy water is insufficient to remove debris prior to placing them in your disinfectant solution.
Well, and I understand, and we have two sets of hot and cold running water and two sinks to do this with at the end of the night. And that's why I'm confused is why we need to have a third one now that is going to do the same thing that we've already set up to do.
So I'll just turn back to the inspectors. If there's already sinks, why are we being asked? Why isn't one of their existing sinks considered a dispensary sink?
Yes, let me clarify. The two sinks that you're talking about right now, one is this mop sink and the other is the bathroom sink. Is that correct?
That is correct, and both have hot and cold running water to them.
So that is not a dispensary sink. You were just told that one is a mop sink and one is a bathroom sink. One needs to be a dispensary sink. So I'm going to ask you again, why can't you please install a dispensary sink?
Well, we can do that. I'm just...
Then I think that that's the recommendation. And I think that the staff has already indicated to you that you have about 90 days to do that. And
Okay.
would that be an appropriate amount of time for you to do that?
That's fine. Again, I was just trying to get to an understanding of the purpose for it. So basically what you're saying is it's just the height of it that's the issue. Because we can't bend over to pour stuff down a sink that's 2 feet off the ground. We have to have something 4 feet. Again, I'm trying to understand.
Not just yet.
I think to save yourself a lot of aggravation and time, I don't think it's really worth it for you to go through what you're doing. Why don't you just get a portable sink? Because otherwise you're going to have to go down and pull a permit. You can't just tap onto that.
Well,
just
the
so you
problem
know,
is
I'm
that
just letting you know.
Our salons are very small. We hardly have enough room to do what we need in there as it is. And you're talking about putting a portable sink in the treatment room, or
A portable sink wherever you can place it, because you have no other options at this point.
Okay.
Mr. Landry, could you speak to the licensee's concerns about what would need to be required to transform their mop sink to a dispensary sink?
They'd have to pull a permit and get it permitted so they could be lifted up, and that would be, I don't know if they sell additions that go up like that, or if you'd have to put a bowl at that top spot, but you'd have to do either that or get some additions that go up, and it just has to be installed. The thing that you need to do is make sure that when you pull the permits for the dispensary sink, that you install it, you get it inspected. When you're done, you call us to inspect it, and it's all done.
Okay, would a permit be required if the plumbing is already there?
I believe so.
Because the faucets are already installed in the wall. If I go and install a sink, it's nothing more than a fixture that's just being...
Debbie Ritchie, per city code, I'm letting you know that if you're going to have to pull, because this is going to want $450 just for your permit, you can get a portable sink for roughly $800 to $1,200, a really nice one for $1,200. If you can't add on to your sink, they're going to want another plumbing fee. So there's $450 right out of the gate. Now you're going to have to pay for a plumber to come and install what you need as a sink, because you're still going to need a mop sink. So I'm just trying to save you money and time.
And I do need to let you know, the regulation reads that it has to be suitable permanent plumbing and has to be permanently connected for drainage. So unfortunately, a portable is not going to work as a dispensary sink.
If you read onto that, doesn't it say... connected for drainage, sewer, and portable water within the areas where work is performed and supplies dispensed?
No, that's potable water. It's not portable.
Okay, so you're going to have to pull a permit and go that route. I was trying to help you.
I have a question, Mr. President. We don't regulate whether the city code of height or sinks or installation of sinks. We just require that there's hot and cold running water and it's suitable drainage. So wouldn't that be a call to the city for them? I mean, they could, in Henderson or where,
yeah,
maybe it varies.
Is this
maybe they
Henderson
just
that
need
you're
to-
speaking about? Because there's difference between Henderson and
That's right.
city and county.
So they should put a call into their city and
Yeah, but
find out
I
what their
can
regulations
guarantee
are.
you that they're
I'll
going to
call.
have to, put a call in, but I can almost guarantee you're going to have to pull another permit, because it's a separate, the city wants their funds, their fees, and they're going to require another connection other than using it as floor mop. Now, maybe they can, I don't know, what are the laws, is do they have to have a floor mop sink?
Yes, we do.
If that's the case, then they're going to charge for that, I'm sorry to say.
Mr. Landry, is there an opportunity to just work with these licensees to find out what their best option would be? I mean, I don't know anything about their county and city plumbing codes, but yet I'm hearing from the licensees that there's, it sounds like there's a couple of options for them. Is there just an opportunity that the board could take a look at this matter? We can give them the 90 days to make any corrective adjustments by working with staff?
We can, but we cannot go and work with the cities and ask what the cities require. That's not a job.
No, I don't mean it in such a way. I just mean in today's vote, can we just be giving them the opportunity to explore their options over these 90 days?
Yes, you can.
Do board members have concerns about providing these licensees with just the 90 days to explore their options of installing a dispensary sink?
I just think we need clarification on the whole thing. So I'm going to start from the beginning. We have laws requiring that you need a dispensary sink to wash your implements, to keep bloodborne allergens spreading from one to the other. I mean, you can't see infection, but it's there. And all it takes is blood into a cut or an open wound from one implement to somebody else. And now you've got staph. And it's that easy. And I've seen it. So these implements need to be clean per law. We have new laws on the books. You can look them up on the website. It's NRS 644-110, and it will tell you exactly what you need. But it is required by law. Now, you may have gotten away with it so far, but it was on the checklist when you opened the business. That's first. Secondly, you need to be washing those implements on a regular basis. You can't do it in the restroom because guests might be using the restroom while you've got to go take another client. Your implements need to be cleaned with hot and cold running water. Hot water, you need to have hot and cold running water present. If you want to get down on your knees and use the mop sink, I don't know. I think that varies for city to city. So I think you need to put a call into your city, Henderson, and find out what they require as far as mop sink being altered or not. That's going to be completely up to them. We do need a dispensary sink.
Okay. It just seems like everybody's across the has a different opinion on everything.
I think what the opinions are is that we've not had a salon requesting a variance for a dispensary sink. That's typically not a variance that we would give. And it doesn't sound like we're giving it in this situation. There will be a vote taken, but from what I'm hearing, while there might be differences of opinion, the variance for a dispensary sink doesn't sound plausible or possible or probable.
Do you have a lot of business owners that are going through the same thing right now?
No. Dispensary sinks, while there may have been an oversight, and we accept responsibility, and I personally accept responsibility that your salon was approved without a dispensary sink. However, at this time, a dispensary sink is required by both of your salons, and as well as any licensed establishment in school. So unless there is something else from the board members, it sounds like Mr. Landry, our executive director, is more than happy to work with you. It sounds like in the staff recommendations for the paperwork that we received, we are going to provide you up to 90 days to make this correction. We do want it to be cost effective for you. However, it is the law that a dispensary sink with hot and cold running water to and from, as Ms. Benaldi said, it is just, without that, there is just a high risk of infection. And
yeah, we have 27 locations from California and New Jersey. I understand this is Nevada, but this is the first time we've ever heard of anything like this throughout all the stores that we've got.
Again, Mr. Landry, I'm going to just direct that comment to you that, perhaps we can coincide some of our regulations with other states at your other meetings, perhaps get a feel for what other states are doing in terms of obligating licensees and licensed establishments to have dispensary sinks.
I'll check that at the NIC National Convention and find out who has. Matter of fact, I'll poll the NIC members and find out who has dispensary sink requirements.
I'd appreciate that. I mean, that'll be news to us. If other states don't require that, we could take it under advisement.
And Nevada's been such a dream to work with. We've never had any problems whatsoever. California's just been a nightmare every step that we go. And I just want to say that Nevada's been extremely gracious in their inspections that they've had with us. We've been nothing but more than happy with the way we've been treated. But this scenario is it's going to be a situation where I don't know. I'm just going to leave it right there. We'll go ahead and abide by your request and install the other sink. But again, the thing I'm trying to say is that I'm not quite sure if the sink is even going to, well, let me just leave it right there.
Thank you.
Well, there's still somewhat left. Again, I think Mr. Landry is more than happy to facilitate working with you over the next 90 days to see this out. But at this time, I'd like to ask board members if there is a motion to approve or deny the request for the variance for NAC 644.330.2 for the dispensary sink for license S12072 and S12422. Is there a motion to approve or deny the variance request?
I'll make a motion to deny the variance request.
Is there a second?
I second that.
Is there additional questions or comments or concerns? I guess the only question or comment or concern that I would have, Mr. Landry, is that I'm expecting that the licensee will still be able to stay in business during the time frame that the dispensary sink is being explored for installation.
Yes, that will be the case. They can stay in business, and they have 90 days to get a dispensary sink installed.
And so, Ms. Benaldi, in your motion to deny the variance request, after the 91st day, what would be your intention with the licensees and the dispensary sink? So we're giving them 90 days to do something about it, but what's happening on the 91st day if nothing's done?
Just, you'd be held accountable to the law. That's all.
Debbie Ritchie, board member, it's going to take probably around 40 days to obtain a permit unless you go in and pull one over the counter. You can do that as well. Just heads up.
So it sounds like there's sufficient time, and so it sounds like after the 91st day, if something hasn't been done about it, it sounds like the inspection staff will be in there to document the details of the status of the dispensary sink, and hopefully you're not before us again for violating that regulation. All those in favor, please say aye.
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 Aye. Any opposed? That motion carries. Let the official record show that the variance request was denied at this time. Please work with our staff to make this right, okay? Tough one. Tough one. I think we're coming back to agenda item 8. This is a complaint hearing. Is Min Noctran here? Did I pronounce that correctly? Mr. Tran, are you being represented by legal counsel? Or he is. And so if you could kindly raise your hand and spell and state your name for the transcriptionist. And Ms. Bradley, do we have an inspector that you're going to be calling as a witness today? And so, Mr. Mishler, I would also ask that you be prepared to take the oath of truthfulness.
Is my name Ngọc Tran?
Raise your right hand, sir. You and each of you solemnly swear the testimony you're about to give before the State Board of Cosmetology will be the truth, the whole truth, and nothing but the truth. Yes.
Yes.
And if you could also just state and spell your name and provide your license identification for Mr. Nelson.
Yes, my name is Alfonso Garcia, bar number 4994, on behalf of Mr. Tran.
And did you give your bar number?
Yes, I did.
Oh, thank you. So, Ms. Bradley, if you'd like, I'll just turn this over to you for the time.
Pardon me, I did ask. Thank you. Closed hearing on this matter. There's certain things that may be somewhat unsavory in this past that, if brought up, might cause my client embarrassment.
He's asking that the hearing be closed.
So we've not had that question
I'm going to object
before
to
us.
that.
So that would be clearing out the guests that have come to attend the meeting today?
So,
and,
with all due respect.
And our staff?
Oh, no, your staff can stay. I mean, people that you normally...
And then there's guests up in the north. There's public members up in the north as well?
It's not been agendized to be a closed hearing, so we would object.
Yeah, because
Is that just my decision?
No. Listen to Ms. Reynolds, please.
In order for this to go into closed hearing, it needs to have been agendized, and it wasn't done that way. Are you proposing to have a full hearing today?
Yes, we are.
Would you then like to postpone to another date?
We would object to that as well. We would object to the matter being continued.
With all due respect, again, to adequately represent my client and his position, again, there are certain matters here that may be somewhat unsavory and or embarrassing to him that it would probably be better if it was a closed hearing, just so that Everything can be discussed.
When did you make the request for the closed hearing?
Just now.
Just now. And so you know that the rules for the agenda to be posted timely you would have to have made that request several weeks ago, and up to about 5 days ago.
I wasn't even retained 5 days ago.
Okay. So at this time, I do have to deny your request for the closed hearing, just based on the fact that there is a process for the agenda to be posted timely, noticing that there would be open and closed sessions.
Okay, if it's duly noted, I object to that.
Thank you. Duly noted. Ms. Bradley?
I would like Bradley, before you speak, do you think we could take a 10-minute break?
Certainly. It's 10:05. We'll take a 10-minute break and resume at 10:15. This is Al. We're going to come back into session. We're waiting for our Deputy Attorney General to explore the request to have a closed session for item number 8, a complaint hearing. But in order to move on with the board meeting scheduled for today, we're going to resume into session at 10:16, beginning with agenda item 11. This is for Ms. Jennifer Richmond. Is Ms. Richmond available? Hi. You're with the Finishing Touch Salon, license S14097, and you are here to request more information regarding the apprenticeship program for your salon?
Hi, guys. No, what's going on is in January, I had set in the application to Charlene for an apprenticeship program. The 60-mile rule, my lady who I wanted to have as an apprentice, she lives 58.3 miles, I think is what Charlene said, away from the nearest school, which I think at the time was Marinello School of Cosmetology, and I believe has also closed since. So she's now able, I guess, to qualify, but Charlene had told me that I needed to come up here and petition before the board. Still, anyway.
This is a distance request, and it's to have the board approve a distance of 58 miles instead of 60 miles for the student to attend. And what I'd like to request the board is that if someone comes in and requests something with anywhere from 50 to 55 miles, whatever you deem is appropriate, that staff could go ahead and approve that on future, delegate that authority to staff to approve the future ones that come in to do that.
Thank you, Mr. Landry. Is there any reason that we should not be considering this variance for approval today?
Well, I would put on the record that you can approve for good cause shown, and the way I read it, it sounds like it's a case determination, a facts determination. I'm not sure that the board can delegate that authority. I think the intent is that it does come before the board.
And is there any objection from any school owner within that proximity that are here today? Is there anyone in the north representing a school that may have a concern about this particular petition?
Gwen Pramo speaking. I just had a question about, and I would like to see us as a board case by case. 58 miles, I think it's kind of like close to the 60. But if we start, that's the reason we have that mileage limit put in place, is just to make sure that each individual come before, because we can, if not, then there's not really a purpose for school if we're going to be actually educating in the salon.
Right.
But I do understand 58 miles is close to 60. And it was some other issues that were, in the way of this young lady being able to attend a cosmetology school here in the city. As a school owner, we have had students come from Pahrump, to our school, and there's many of schools here in Las Vegas area, and I would just kind of like to make sure that it's done on a case by case.
Well, and if I could just read the law just so that we're clear, and it's in your packet. It's NRS 644217, and then the reasons for allowing an apprentice is generally under subsection 1, and there's 2 requirements. A, that they have to travel more than 60 miles. B, that the training will be done at an establishment that's located 60 miles or more from the school, the nearest school. And then for good cause shown, the board may waive the requirements of subsection 1, and it does say for a particular applicant. So the way I read that is the case by case based on the facts and circumstances of each case. So what I would request that the board do, if they're inclined to grant this request, is make sure that they do put that good cause and why in this particular situation they believe it's appropriate to waive the requirements of the law. And I do believe that you have that authority as a board to do.
And so, Ms. Richmond?
Yes.
What is the cause for the request for this petition of a variance?
Debbie has been, she's not a young lady, she's been a nurse for years. She's been doing it for 35 years, but she has a younger child now, and so it just makes it harder with only one vehicle in her situation to go into Las Vegas to school. So she wanted to do something, not go into Vegas every day to nursing anymore. So she wanted to stay in Pahrump now, and I knew her, and I actually am an apprentice graduate and now a salon owner. And so the program worked out great for me, and I had suggested it for her to be able to stay in town and stay near her son, and only having the one vehicle while her husband drives back and forth. I had suggested it to her, and we applied, and Charlene said, it's so close, I don't see why not. You'll have to go before the board, though. So,
And that was Ms. Marsh?
yes.
Ms. Marsh, did you have any comments or questions or concerns regarding this petition for the variance? And after hearing, and has Ms. Marsh been sworn in?
No.
Ms. Marsh, could you just please be sworn in that your testimony be truthful prior to making any statements regarding this petition?
Yes.
I probably should have had you do that too. And so, Ms. Bradford, I will have to request that the scripting be modified. That includes testimony that you've given. Thank you. Ms. Marsh?
Yes.
Did you have the concerns regarding this petition since you were the one that spoke to her?
No, only that it needed to go before the board for approval. That was the only concern. A lot of people don't have the opportunity with family and other situations surrounding them, so I'm always hopeful that we're a little lenient and able to help people get their licenses in the rural areas.
Thank you, Ms. Marsh. I appreciate that. Any questions, comments, or concerns from the board? I'd be happy to accept a motion to approve or deny the petitioner's request for a variance.
I'll make a motion to approve, of course, the variance, but I'd like to also add, because of her experience being a successful apprenticeship program in the past, and of course that she's very close to her mileage allotment there.
I will second that emotion.
So there has been a motion made by Ms. Benaldi and seconded. Is there some discussion, Ms. Bradley?
Well, and I think you could include in the motion the issues that they put in the letter, in that the potential apprentice shares a car and has a student in school, and it would be a hardship for her, I think, from what they're putting forth, to drive to the school, even though it is only 58 miles. So just to kind of include that as part of the good cause.
I'll modify my motion to include that it would be a hardship for this particular person, that she's going to be apprenticing under her, that it would be a hardship to her. So.
And does the second reflect the information that was provided in the letter dated January 25th, 2016 that Ms. Benaldi referenced just now?
Yes.
It does. And I just want to remind the board that before this goes to vote, that all requests for a variance to the mileage for the NRS 644.217, the apprenticeship program, should be coming before the board on a case-by-case basis, that this is not a blanket approval for any shortcomings in that mileage that's detailed in that NRS code. Were there any other questions, comments, or concerns regarding this petition? All those in favor, please say aye.
Aye.
Aye. Any opposed? That motion carries. Let the official record show that the petitioner, Ms. Richmond, has indeed received a distance variance for your apprentice? Yes. And so all the other terms of your apprenticeship program are being met?
I believe so.
And when were you last inspected for that?
When was my last inspection? We just had one about a month ago.
And everything else is coming up fine for this particular account?
Yes, it is.
Perfect. Thank you, Mr. Landry. Ms. Richmond, good luck with your apprentice.
Oh, I want to thank you guys so much. Can I ask how long do you think it might take for paperwork to get through? Do you guys have any idea, or maybe no?
Mr. Landry, it should be available tomorrow to her, I suspect.
Yes.
Okay, alrighty, so I'll just contact the office in the morning. I appreciate you guys. Thank you.
Good luck.
Have a blessed day.
You as well. Ms. Reynolds, you have come back. Do we have additional information regarding our petition or our complaint?
Yes. Yes. Although it was not agendized as going into closed session, at his request, we can go into closed session.
And I would like to put on the record that pursuant to NRS 241.030, it's at the option of the board. A public body may hold a closed meeting. It's not required. So they are asking for that, but I don't know, at least for I would say staff's view and my view is that it's not required that the meeting be closed, but it's a decision for the board to make.
So it would be my preference to hear the other two agenda items, 9 and 10, and then we could go into a closed session for the agenda item 8, and then we could do a break for lunch. And then that way we're not holding up we're not holding up the other folks who have been here to have to leave now.
I think the board has to vote on whether or not they want to close the meeting. It's not a decision
Right.
just for you.
Right.
Okay, you were just saying you were going to have a closed session. I think it has to be decided by the full board.
I meant to imply that in the event the board were to vote for the closed session, it would still be my preference to hear the other two agenda items, 9 and 10, and then allow the public members to leave through the lunch period because I suspect this agenda item 8 will take a little bit of time. So at this time, may I have a motion to approve or deny the request for a closed session?
No, unfortunately, there's certain formal requirements that have to be done before we go into closed session as far as what the motion is going to be, which I know that you're not familiar with. So we're not ready to hear that item. I understand you wanted to hear the settlement agreements first. So when we come back and are ready to do this hearing, that will be the time at which that will be
May or
decided.
may not occur.
Yes.
That decision.
It sounds like your suggestion, which I was going to suggest from back there, pardon me, would pretty much achieve the same end, more likely than not.
So you're comfortable with us proceeding with other agenda items prior to making a decision on whether or not
Let's
to...
not muddy all up the works if everyone else can be done quickly, and
Thank you.
it'll achieve the same goal, I think.
Thank you very much. So again, we will be postponing agenda item 8.
Mr. Leader, that's me.
Oh, yes.
Chris made a good point. We are live streaming the meeting, so I'll have to make some arrangements if you decide to do closed hearing to make sure that we're not live streaming. Just because we send the audience out, we'd have to make sure that we're not having live cameras and
Thank you.
hot wire.
Thank you, Ms. Bradford. And then that would just mean that we would also potentially be just closing off the north, the telecommunications with the north. Is that what I'm to understand?
It won't be live broadcast over the web is what will need to happen. The members of the public who are attending in the north, if the meeting goes into closed session, will need to leave.
Okay.
Okay.
Okay. So we'll come back to agenda item 8. At this time, we're going to hear agenda item 9. This is a proposed settlement agreement with licensee S13713. Is that representative here with us today?
You can call them, but I don't believe anyone's here for the next two items.
Okay. Do I have a name for that person?
It's Asian Spa LLC and or Puvan Chandavong, and I'm sorry, it's hard to say.
Is that individual present today?
She's also represented by an attorney, Mr. Clyde DeWitt.
And is the attorney present today? Ms. Bradley, I'm happy to have you proceed in their absence.
Thank you. So we have a voluntary surrender in lieu of other disciplinary action. As the board is aware, because we've done these before, this is disciplinary action. It goes in their file. But what it does is it allows the board to essentially receive the license back. The person can no longer have a salon license at that location. Should they wish to be relicensed in the future, staff would deny that application, and it would have to come before the full board. That's our normal procedure on that. So the case is case number CA-2016-002, and it's the Nevada State Board of Cosmetology versus Asian Spa LLC owner and/or, I'm going to spell her name, P-H-O-U-V-A-N-H, and her last name C-H-A-N-D-A-V-O-N-G. And it's license number S-13713. And I think as we've done in the past for the education of the public, we have read the facts and violations into law. If you'd like me to do that, I will. And I would note that the agreement I have, the board has the original. We've given that to Ms. Bradford, and it's been signed by all of the parties, and we're just waiting for approval by the board and then signature by the board president, and then the matter would be, assuming you accept it, then the matter would be closed. So would you like me to read the facts into the record?
Yes, please.
So Asian Spa, fact number 1, is a licensed as a cosmetological establishment by the board under license number S-13713. Asian Spa LLC is the owner of Asian Spa, and Puvan Chandavong is the responsible person / corporate officer for Asian Spa and/or Asian Spa LLC. Asian Spa and Ms. Chandavong are therefore subject to the jurisdiction of the board and the provisions of Chapter 644 of the NRS and Chapter 644 of the NAC. Asian Spa, located at 4480 Spring Mountain Road, Suite 600, Las Vegas, Nevada 89102, previously operated as a full-service establishment under different ownership. On or about June 10, 2013, the board office received a complaint indicating that Asian Spa was under new ownership and still operating under the previous owner's license number, license S-11935. On or about June 10, 2013, Inspector Ball, B-A-A-L, called the owner of record for Asian Spa and learned that the salon had been sold a year prior. On or about June 10, 2013, Inspector Ball visited Asian Spa and observed no services being performed and one room set up for aesthetic services. On or about June 10, 2013, Inspector Ball spoke to the new owner of Asian Spa, currently unlicensed, on the telephone regarding Asian Spa's license status and indicated that the new owner would need to submit a new application for establishment licensure within 24 hours. On or about June 10, 2013, Inspector Ball removed the old and invalid establishment license from the Asian Spa location, and that was license number S-11935. Subsequently, Asian Spa was licensed on or about September 12, 2013 for skin-only services, and the new license number was S-13713. The licensee in charge, as listed on Asian Spa's skin-only salon license application, is Martha E. Prado, P-R-A-D-O. On or about August 27, 2015, Nally Villasenor was arrested for prostitution at Asian Spa, located at 4480 Spring Mountain Road, Suite 600, Las Vegas, Nevada 89102. And that's in Las Vegas Metropolitan Police Department, event number 150826-3982. On or about August 27, 2015, Puvan Chandavong was arrested for pandering at Asian Spa, and that was the same day in the same location. The event number for that is 150827-0532. Martha Prado was not present at the time of Nally Villasenor, and that's N-A-L-L-E-L-Y, V-I-L-L-A-S-E-N-O-R, and Puvan Chandavong's arrest. At the time of Villasenor's and Chandavong's arrest, Asian Spa was open for business and no licensed cosmetology professionals were present. Martha Prado was not consistently performing salon services at Asian Spa. Martha Prado sold her license to Asian Spa for a fee so it could be posted at the salon. The name and license number of Martha Prado was fraudulently used on Asian Spa's salon license application. During the course of this investigation, board staff discovered advertisements for Asian Spa on Backpage.com. These advertisements contained photographs of scantily clad women in provocative poses. These advertisements offered a new attitude, one visit to Asian Spa and you will be rejuvenated. Let our lovely Latina and Asian staff renew your energy and erase your stress. Free table shower or shower with any session. An experience you will remember. Get treated like a king at Asian Spa. Beautiful Asian and Latina staff to serve you, and get a new feeling with a new person at this new spa. The salon license for Asian Spa was obtained for unlawful purpose and or as a front to unlawful commercial sex activity. And grounds for disciplinary action exist against Asian Spa LLC owner and or Puvan Chandavong owner, license number S-13713. This conduct resulted in the following violations. First, claim for relief. By obtaining a salon license for false and or unlawful purposes and or by including information for a licensee who never worked at Asian Spa in the salon license application and or by fraudulently using the name and or license number of a licensee who never worked at Asian Spa LLC owner, and or Puvan Chandavong violated NRS 644.340, which is grounds for disciplinary action pursuant to NRS 644.430, sub 1, sub A. Second, claim for relief. By obtaining a salon license for false and or unlawful purposes and or by including information for a licensee who never worked at Asian Spa in the salon license application and or by fraudulently using the name and or license number of a licensee who never worked at Asian Spa LLC and or Puvan Chandavong obtained practice in cosmetology by fraudulent misrepresentation in violation of NRS 644.430 sub 1 sub B, which is grounds for disciplinary action. Third, claim for relief. By allowing and or engaging in unlawful activity in the cosmetology establishment, including activity that is beyond the scope of an esthetician license, Asian Spa LLC and or Puvan Chandavong owner violated NRS 644.430 sub 1 sub C, which is grounds for disciplinary action. Fourth, claim for relief. By using and or obtaining a cosmetology establishment license where the holder thereof is not personally, actively, and continuously engaged in a cosmetology business, Asian Spa LLC and or Puvan Chandavong owner violated NRS 644.430 sub 1 sub G, which is grounds for disciplinary action. Fifth, claim for relief. By allowing and or engaging in unlawful activity in the salon, including activity that is beyond the scope of an esthetician license, Asian Spa LLC owner and or Puvan Chandavong engaged in an unfair or unjust practice, method, or dealing as described in NRS 644.430 sub 1 sub K, which is grounds for disciplinary action. Sixth, claim for relief. By remaining open without a licensed person present, Asian Spa LLC and or Puvan Chandavong owner violated NRS 644.370, which is grounds for disciplinary action pursuant to NRS .430, sub 1, sub A. Seventh claim for relief. By advertising using knowingly false or deceptive statements and/or by advertising unlawful services in the salon, Asian Spa LLC, and/or Poovan Chandavong, license number S-13713, violated NRS 644.430, sub 1, sub F, which is grounds for disciplinary action. And I would note,
Ms. Bradley, I just wanted to just ask quickly, on your sixth claim, or excuse me, your fourth claim for relief, can't an owner of a licensed establishment just be like a general person? You don't have to be a licensee to own an establishment, do you?
yeah, but you can't be open for business if you don't have a licensee in charge.
But permitting a license to be used where the holder thereof is not personally, actively, and continuously in the business, but doesn't that imply that that's a licensee who owns?
Are you looking at the fourth claim? I thought you said the sixth claim. I'm sorry.
I did say sixth. I meant fourth. Pardon me. It's the NRS 644.4301G.
Well, they've already admitted to the violation. So regardless, I mean, that's why I'm reading it to you, and they signed it. So they've admitted that this is a violation. But you cannot get a cosmetology license and not use it, and use it to remain open and do unlawful activity. And that's why that's charged, and I would stand by it as being appropriate. If you get a cosmetology license for an establishment, the establishment should be open and used to just do cosmetology services. If you're getting a license for fraudulent or improper purposes or as a front to unlawful activity, I think that violates 644.4301G, which means they're not continuously and actively involved in cosmetology business. They're doing something else there with a cosmetology license on the wall to sort of appear legitimate.
Thank you.
So again, the owner of the salon, as well as, and this person's also the officer of the salon, so they both have signed this stipulation and have waived their right to a hearing, waived their right to call evidence and to appeal, assuming that the board does approve this surrender. So again, what the board gets from this, we would encourage you to approve it. They have admitted, if you look on page 1, we voluntarily and knowingly admit the following facts. So all of the facts and allegations that I read, they have admitted. They also, we get the license back. The salon can no longer be open under that establishment license number, and there will be discipline in their record. And I would request that board staff make sure that not only does the record show Asian Spa, but it also shows the owner's name, Poovan Chandavong. And again, as I said before, if this person applies for a new license of any type before the board, that would be a denied application, and that person would have to come before you and explain how things have changed or he or she has changed. So I would ask that you approve this agreement as a resolution of this case.
Ms. Bradley, was there any complaint or citation for Martha Prado?
There has not been anything yet against Prado.
Is that forthcoming?
Well, I don't know. I'd have to ask staff. We can't really talk about pending complaints.
Okay.
Because that wouldn't be appropriate. But I would say that this is what the owner has admitted. I don't know if Ms. Prado would admit the same. This is what we've put forth, and this is what they've admitted. And so we would ask that it be approved.
Was Ms. Prado notified of the meeting today at all?
Because she's not a subject of the complaint and matter, no, she was not.
Any questions, comments, or concerns from any of the members of the board? I'd be happy to accept a motion whether or not to accept or reject the voluntary surrender in lieu of other disciplinary action as read by Ms. Bradley.
I'll make a motion to accept the voluntary surrender in lieu of other disciplinary action for case number 2016-002.
And more specifically, Ms. Bradley, the voluntary surrender of license S13713.
And to add to that, the surrender of license S-13713.
Is there a second to Ms. Benaldi's motion to accept the voluntary surrender?
I actually have
There needs to be a second before discussion.
I second that motion.
And so make your points.
I just want to know, and I'm sorry if I missed this earlier, what would be the other disciplinary action that would be taken against Asian Spa?
I think that there could be up to a $2,000 fine for each of the claims of relief. So there are 7 claims of relief. So there would be up to $14,000 in and including revocation of the license.
Okay, so they would be pretty much monetary disciplinary action?
That's all that the board can do, is revoke, suspend, et cetera, a license, and then charge a financial penalty. And the benefit that we believe, and why we're submitting this to you, is we get essentially a revocation without any possibility of appeal. So because they're agreeing to this, we get essentially what we would want. We may not get a financial penalty like a fine, but we do have this clear discipline on the record, and then I don't have to defend the board should they appeal the board's decision. So we do have, for example, one pending right now where somebody appealed the board's decision. So the benefit here, I kind of consider it the best kind of discipline we can get, because we get the license back from the bad actor and they can't appeal it. There's no further disciplinary proceedings, and we have the license and we have the discipline on record. And so board staff has that in their files. So again, if we see that name, particularly the owner's name, again, they can deny license right away. And so then it would come back before the board, and the board would have this agreement in front of them again. And so you could be reminded that this is why the person is before you, and then you can talk with them about that. So I just think it's the best because we don't have to worry about it being appealed, and we do get the license back. And of course, I think our number one concern in protecting the public is getting bad actors from not having licenses. So.
Okay.
Additional disciplinary action could also be the costs of today's hearing, or the fees associated to, or the costs associated to the drafting of the proposed settlement.
I just have one comment. I wanted to comment on the licensee that licensed the establishment. If we as a board can possibly, like maybe down the line, look into the licensees licensing the actual establishments that they're not, when the inspectors are doing inspections and these licensees are just licensing these establishments with no work history there. I mean, because that's kind of basically like selling that particular license, wouldn't you think?
I mean, that's our allegation, that this license was included on the application fraudulently, and that it was perhaps hanging on the wall, and so when an inspector went to visit, it appeared to be legitimate. So that's certainly our allegation, and I know that board staff is following up on those whenever they can. And I'm not saying staff isn't going to look at this one any further, but I am saying we have possibly an admission from someone who I think is currently in jail that this is what occurred. I don't know that we have anything more, and so I'm just not sure. But I know that there have been reports of people selling their licenses, and I know that Inspector Mishler is working on those.
There's been a motion and a second made by Ms. Benaldi and Mr. Baltazar. Is there any other question or comment or concern? All those in favor of accepting the voluntary surrender, please say aye.
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 Any opposed? That motion carries. Let the official record show that license S13713 has been voluntarily surrendered.
Thank you. So I would ask, Mr. President, that you sign the agreement, and then board staff can make a copy, and we can send a copy to the attorney so that he has the fully executed copy.
Thank you. Agenda item number 10. This is a proposed settlement agreement, or do we have Flamingo Rose Day Spa here, or Terry Cook present? In light of their absence, Ms. Bradley, I'll please just ask that you continue.
Thank you. So once again, we have a voluntary surrender in lieu of other disciplinary action. It has been signed by the parties, with the exception of Mr. Landry and the board president, and I believe I need to sign it as well. This case is CA-2016-006, and it's the Nevada State Board of Cosmetology versus Flamingo Rose Day Spa, and that's owned by Flamingo Rose LLC. The officers in charge of the corporation, as listed on the Secretary of State's website, are Terry Lee Cook, manager, Poovan Chandavong, manager, and James R. King, manager. And the license number for Flamingo Rose is S-13687. So once again, we have the parties voluntarily, knowingly admitting the following facts. And if you'd like, I'll read through them again. I'll try to summarize them a little, but.
Please.
Thank you.
I just wanted to ask, are these people considered pimps? I mean, I'm just asking.
Well, I do know that Mr. Cook was arrested, I believe, or Mr. King, one of them was arrested for pandering. And I think pandering is the charge that generally a pimp would get. I'm not sure pimp's actually a technical term.
Oh.
But I don't know.
Well, I mean, again, it makes it relevant whether or not they're voluntarily providing sex services or whether they're being trafficked into sexual activity.
I agree. I mean, definitely we have concerns that at least some of what we're seeing may not be people choosing to engage in sex for money, but it may be a traffic situation. Yes.
Thank you, Ms. Bradley.
Okay. So, and once again, I would ask that the board staff make sure that the record for this case does include all of the parties' names, because my hope is that if any of them, whether it's Terry Lee Cook, James R. King, or Poovan Chandavong, applies for a license, that they would all be flagged in the system.
I just have a quick question before you begin. That Poovan Chandavong, is this the same as in the previous case?
Yes, it is. It's the same attorney representing, because that person, and I think it's a female, but it may not be, Poovan Chandavong is represented by Mr. Clyde DeWitt. So yes, same person. So the parties voluntarily and knowingly admit the following facts. Flamingo Rose Day Spa is licensed as a cosmetological establishment by the board under license number S-13687. The owner of Flamingo Rose Day Spa, as shown in the board records, is Flamingo Rose LLC. And the Secretary of State's website shows that managers of Flamingo Rose LLC are Terry Lee Cook, Poovan Chandavong, and James R. King. Flamingo Rose Day Spa and Flamingo Rose LLC are therefore subject to the jurisdiction of the board and the provisions of Chapter 644 of the NRS and Chapter 644 of the NAC. Flamingo Rose Day Spa was first licensed on or about August 24, 2013 for skin-only services. The licensee in charge, as listed on Flamingo Rose Day Spa's salon license application, is Dana Reshna, R-E-S-H-N-A. On September 27, 2015, Mayra Benitez Flores was arrested for soliciting prostitution at Flamingo Rose Day Spa, located at 1680 East Flamingo Road, Unit Number 1, Las Vegas, Nevada 89119. And that's Las Vegas Metropolitan Police Department event number 150927-3909. On September 27, 2015, James King was arrested for pandering at Flamingo Rose Day Spa, and that's event number 150927-3909. Dana Reshna was not present at the time of Mayra Benitez Flores and James King's arrest. At the time of Flores and King's arrests, Flamingo Rose Day Spa was open for business and no licensed cosmetology professionals were present. Dana Reshna was not consistently performing salon services at Flamingo Rose Day Spa. Dana Reshna sold her license to Flamingo Rose Day Spa for a fee so that it could be posted at the salon. The name and license number of Dana Reshna was fraudulently used on Flamingo Rose Day Spa's salon license application. During the course of this investigation, board staff discovered advertisements for Flamingo Rose Day Spa on Backpage.com. These advertisements contained photographs of scantily clad women in provocative poses. These advertisements offered "Get a new vibe" in Flamingo Rose Day Spa, "New ladies arriving daily," "Let our lovely Latina and Asian staff renew your energy and erase your stress," "Ultimate 1-hour relaxation package which includes table shower and body scrub," and "An experience like no other." The salon license for Flamingo Rose Day Spa was obtained for an unlawful purpose and/or as a front to unlawful commercial sex activity. Grounds for disciplinary action exist against Flamingo Rose Day Spa, owner Flamingo Rose LLC, and/or Terry Lee Cook, manager, and/or Poovan Chandavong, manager, and/or James R. King, manager, and this is license number S-13687. This conduct resulted in the following violations. First claim for relief. By obtaining a salon license for false or unlawful purposes and/or by including information for a licensee who never worked at Flamingo Rose Day Spa in the application for licensure and/or by fraudulently using the name and/or license number of a licensee who never worked at Flamingo Rose Day Spa, Flamingo Rose Day Spa owner, Flamingo Rose LLC, and/or Terry Lee Cook, Poovan Chandavong, and James R. King violated NRS 644.340, which is grounds for disciplinary action pursuant to NRS 644.430, sub 1, sub A. Second claim for relief. By obtaining a salon license for false and/or unlawful purposes and/or by including information for a licensee who never worked at Flamingo Rose Day Spa in the salon license application, and/or by fraudulently using the name and/or license number of a licensee who never worked at Flamingo Rose Day Spa, Flamingo Rose Day Spa owner, Flamingo Rose LLC, and/or Terry Lee Cook, Poovan Chandavong, and/or James R. King obtained practice in cosmetology by fraudulent misrepresentation in violation of NRS 644.430, sub 1, sub B, which is grounds for disciplinary action. Third claim for relief. By allowing and/or engaging in unlawful activity in the cosmetology establishment, including activity that is beyond the scope of an esthetician license, Flamingo Rose Day Spa owner, Flamingo Rose LLC, and/or Terry Lee Cook, Poovan Chandavong, and James R. King have violated NRS 644.430, sub 1, sub C. Fourth claim for relief. By using and/or obtaining a cosmetology establishment license where the holder thereof is not personally, actively, and continuously engaged in a cosmetology business, Flamingo Rose Day Spa owner, Flamingo Rose LLC, and/or Terry Lee Cook, manager, and/or Poovan Chandavong, and/or James R. King have violated NRS 644.430 sub 1 sub G, which is grounds for disciplinary action. By allowing and/or engaging in unlawful activity in the salon, including activity that is beyond the scope of an esthetician license, Flamingo Rose Day Spa and/or Terry Lee Cook, Poovan Chandavong, and/or James R. King engaged in an unfair or unjust practice, method, or dealing as described in NRS 644.430 sub 1 sub K, which is grounds for disciplinary action. 6, claim for relief. By remaining open without a licensed person present, Flamingo Rose Day Spa and/or Terry Lee Cook manager, Poovan Chandavong, James R. King violated NRS 644.370, which is grounds for disciplinary action pursuant to NRS 644.430 sub 1 sub A. By advertising using knowingly false or deceptive statements and/or by advertising unlawful services in the salon, Flamingo Rose Day Spa and/or Terry Lee Cook and/or Poovan Chandavong and/or James R. King violated NRS 644.430 sub 1 sub F, which is grounds for disciplinary action. And again, the 3 individuals who are officers of the LLC corporation, they have signed the agreement, and they have indicated in signing that they are aware of and understand and were advised of their rights. They are waiving their right to a hearing and are asking that the board accept this voluntary surrender. And so I would ask that the board approve this voluntary surrender.
Ms. Bradley, I just wanted to echo Board Member Balthazar's other question. When we say in lieu of other disciplinary action, that's only with our board. What other disciplinary action these individuals may receive is from law enforcement.
Well, yeah, I mean, a lot of times in a traditional case, I would file a complaint and notice of hearing, and I might ask you to revoke and fine the person and, assess costs against them. So this is a voluntary surrender. So in other words, that's the discipline. They're essentially allowing us to revoke their license because they agree. So that's what it means. It's kind of funny phrasing, and I apologize for that, but we call it a voluntary surrender. So they're giving their license back. I'd say it's an agreed to revocation, essentially. They're saying, okay, if you take our license, we'll agree to everything. But please don't charge us usually any other costs.
But under the jurisdiction of our board is the ending of their disciplinary actions, whether or not they receive disciplinary action from any other
absolutely.
Law enforcement agency
well,
or
I know that
judicial
one of these individuals is currently in jail, last I checked. So yes.
They may still receive disciplinary action from another
law
enforcement body.
And if they have other licenses, I don't know if they do or they don't, but they could be subject for discipline based on that as well. I mean, certainly, and one of the things that's included in here, this is a public document, so anybody who asks the board for it will get a copy of it. So whether they have a license in California, they have another professional license, whatever they have, we will give anybody who asks this copy. But again, what we like about it is they're giving us the license back. I'm not having to prepare for a lengthy hearing. They can't appeal. They're giving it back, and we know we're going to deny them if they come before the board again. And the board would have to approve a license for them in the future. And so, to me, it's sort of the best resolution because we get a bad actor out of the profession to help protect the public, and they can't appeal it. So I hope
Thank
that
you.
helps.
It does. Any questions or comments or discussion? I'm happy to accept a motion to either approve or reject the proposed settlement agreement.
And I'm sorry, I wasn't able to hit my button before you moved on. Actually, just a really quick question. Are there any other businesses that are owned by Mr. or Ms. Chadabang. I mean, this is the second one, so it's a little concerning.
Sure. I would ask staff, and I believe that they've had that same thought. So if it hasn't already done, I would ask staff to double check that all of the licensees mentioned today, let's check their status, what they're doing, what they're owning, and maybe that might be brought back to the board in the future. So thank you. And I think too, once we have you guys approving this, we actually have now a disciplinary record, which would kind of help us look at those other salons as well.
Thank you very much. I'm happy to again accept a motion to deny or approve the voluntary surrender of license S13687 or not.
I'll make a motion to accept the voluntary surrender in lieu of disciplinary action for case number CA-2016-006 for license number S-13687.
Is there a second?
I will second that emotion.
There's been a motion and a second to accept the voluntary surrender. Is there any other question or comment or discussion? All those in favor, please say aye.
Aye. Aye.
Any opposed? Let the official record show that the voluntary surrender in lieu of other disciplinary action was accepted for case CA 2016-006 regarding license S13687, made by Ms. Benaldi and seconded by Deborah. Great, thank you. At this time, I know that Ms. Reynolds is here. We still have another item, 12A. Is it at all possible that I could hear item 12A prior to backing up to the agenda item 8? Is that at all a possibility, or?
That is a possibility, although you have about 50 minutes before lunch, you might be able to get through number 8 before lunch, if possible. Have 12 after lunch. 12
because of Ms. Reynolds' schedule? Okay. So at this time, if we could please take a look at agenda item 8. And we have been asked to make this complaint hearing a closed hearing, which would require that the board vote for that. So prior to any members leaving, I just want to double check if there's any questions, comments, or concerns. Ms. Bradley, you had a concern?
I mean, I feel like we should probably put on the record our reasons, my reason to oppose a closed session, and Mr. Garcia's reason that he would like a closed session.
And your reason for rejecting that request is?
Well, we would oppose that because we believe, number one, NRS 241.030 allows the board to close a meeting at its option. Definitely someone can request that, but it's not required that the board do close it. The intent of the legislature in general is that the board's proceedings be done in the open. I believe in the interests of public protection, public safety, hearings should be open. We've always had open disciplinary hearings before this board. The other thing I would say is everything in this case is a matter of public record already. The complaint notice of hearing is a public document. The exhibits we will be providing to you are public records. So everything is already available to the public should they ask. And I just believe in the interest of being open about the board's business, the board should deny that request. I understand that there might be some uncomfortable elements to this case, but we've had uncomfortable elements in the past and proceeded in the open.
Can I make a motion to deny?
Well, just a moment.
Oh,
it's Mr. Garcia.
Yes, thank you. Still, which is done, it would be probably best to have a closed hearing. That way I can fully and adequately respond to any questions that the board may have, and that allows me to represent my client at the most vigorous possibility. As counsel stated, a lot of these things, a lot of these records are open, I assume, depending on how the the board decides, that would also be published. I would like to ask that the board err on the side of allowing my client and myself to be able to fully argue things without any kind of hesitation whatsoever. What comes, what may, happens, but that will be public record.
Thank you, Mr. Garcia. Ms. Reynolds, did you have a comment, please?
Yes, I want to point out to the board that under NRS 241030, sub 1, sub A, that the public body may hold a closed meeting to consider the character, alleged misconduct, professional competence, or physical or mental health of a person. When you are considering this, and if you do decide to go into closed session, your motion has to be very specific. Your motion has to specify the nature of the business to be considered, which is what I just read to you, where you are considering the character, alleged misconduct, professional competence, or physical or mental health of a person, as well as the statutory authority pursuant to which you are authorized to close the meeting. And again, that statute reference is NRS 241.030. So whatever motion the board makes, I want to be sure that you're aware of what that motion needs to contain.
Ms. Reynolds, would that also have to include sub 1, sub A? When we ask for the 241.030, is it 1A?
It's 1A, yes.
Okay. So do all the board members understand that if you're going to make a motion, you do need to include that NRS 241.030 sub 1, sub A as part of your motion? And so I'm happy to accept a motion, or I guess I should ask if there's any other discussion or questions or comments. I'm happy to accept a motion on whether to grant Mr. Garcia's request for a closed session or not. A motion to grant, approve, or deny.
I make a motion to deny.
I second that.
And is there any question or comment or discussion?
My comment would be, I think out of respect to the board and to disallow all the chaos that'll happen from people, with the cat calls or whatever's going to happen here, I think that's just going to be ineffective. And I think out of respect, I think we should have a closed session. That would be my opinion.
Are we going to be mentioning things that, because there have been board meetings where we've talked about certain things that it's just challenging if there are minors that view our live feed? Or is there anything about the viewing of our live feed in relationship with minors listening to our live feed that we need to be respectful of?
I mean, I think...
if we're live fed over the internet and there's minors listening to it, is what we are going to hear acceptable to the ears of minors?
Well, I'm not planning to say anything that wouldn't be acceptable, but I don't know. I mean,
unacceptable.
Perhaps, yeah, I'm not planning to say anything that would be unacceptable for them to hear, but I would say, perhaps parents should use due diligence if their children are watching this with them, and if they're uncomfortable, ask them to not listen in. I don't know what to say.
So we don't need to have an explicit warning on our live feed, Ms. Reynolds?
I really don't know that that's germane to this discussion here. You've got a request from the respondent to close the meeting. You have the authority under the NRS to close the meeting.
But we also have a motion denying that request. And so if we proceed with that denial through vote, are we going to be subject to anything with having our live feed of the content of the meeting?
But that's what I'm saying. That's not a reason to vote up or down on this motion.
Okay.
You're supposed to be considering the request from Mr. Garcia to close it. You've got a motion on the table to deny the request.
Yes. What comes may come.
And so
did the motion properly address the NRS 641.030 sub 1A?
4-1.
Or 241? Did the motion properly
yes,
address that?
and I believe, are the board members speaking out in favor or against the motion? I think you had one board member who spoke against the motion.
Yes.
Sorry, if I may. There seems to be some indication here that it could happen. There is information that could be unsavory, depending on.
But Ms.
an
Reynolds said
individual.
that that's not a factor in making that decision.
I think in your discretion, that can be used. I like to be able to just argue full board,
Right.
best for my client. And
I mean-
there are some things that could come up, and it appears that the Attorney General is not denying that. It can come up.
I appreciate that foresight.
I mean, the board has before it the complaint that's been filed in this action. So you know what the nature of the allegations are. I'm hopeful that all the board members have reviewed the complaint allegations, and so, let that inform your decision.
Thank you. Any other questions or comments or concerns? All those in favor of denying Mr. Tran, through his attorney, the opportunity to close the session for his complaint and notice of hearing CA 2016-012, say aye.
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 Any opposed? Nay.
Nay.
That motion carries.
Doesn't, it's 3-3.
Oh, 3 and 3?
There's only 6 people here today.
1, 2, 3, 4, 5, 6.
So the motion fails.
So the motion fails. So at this time, if somebody would like to make a motion to, again, deny or approve Mr. Tran through his attorney, Mr. Garcia's, the opportunity to have a closed session for this part of the hearing.
Also may wish to discuss it because it sounds like the board was split on the issue, and you may be split again unless you have a discussion of some kind to kind of come.
I think,
Go ahead. It has to be on public record.
all right,
No, go ahead.
that's right. Good.
Okay.
I think it needs to be denied because I think what the truth is the truth. If parents don't want their children to watch, they can leave the room. This has been a motion that's been on the table. I think we need to proceed forward.
I feel like what's happening today in the establishments need to be kind of brought to the forefront. So my motion is to deny the closed hearing.
Ms. Benaldi? No, go right ahead.
I just feel it's very uncomfortable for everybody involved, and I think it would be unsavory. But I mean, I can understand and agree that this is something that's happening and is completely unacceptable, in my opinion. But I think it would be easier to go forward in addressing questions and answers if it was quiet and closed, and we didn't have all the background noise.
And the other two? As a basis for your prior decision?
Basically, everything that you had just said. I think it'll help the process move forward if we just go along with what they're requesting.
What could be worse than with the other cases about the sexual and prostitution? I mean, it's fraudulent. I mean, I don't understand why we have to do this in closed doors.
Maybe this is time that we bring it
everybody needs
forth.
to understand what's going on.
Well,
It's-
I can tell you a couple distinctions right away. First of all, those other two were stipulations. So those people fessed up and they said, yep, I'm surrendering my license. I'm giving up. I'm not even trying to argue it. So that in this case is distinct in that if certain things come up, my client may be somewhat inhibited in presenting his case to the fullest. And I think that is a major difference.
As board members, I just feel that we've all read the information in our packet, and I think it's something that should be openly discussed. There's no reason for, I feel like there's no reason for it to be closed. We've already read this information. I have.
I'd be happy to accept another motion. If you'd like, you might just restate your prior motion and see what kind of votes we get.
Before I state my motion, I need an exact format from the AG.
Is your motion going to be, well,
yes.
If you're going to move to go into closed session, you would say that I move to go into closed session because we are going to be considering the character, alleged misconduct, professional competence, or physical or mental health of a person, and we have authority to close the session pursuant to NRS 241-030 sub 1 sub A.
And as you're reading that, you can tell that I'm going to need to read it, so I can't.
Or you could get your motion in first.
I would move to deny the motion.
So there is a motion on the table. Pardon me?
To deny? You're talking about? And that to deny.
And so there is a motion on the table to again deny the Mr. Tran through his attorney, Mr. Garcia, the opportunity to have a closed session. There has been a second. Is there additional question or comment or concerns? She preempted the motion to approve it. Any questions or comments or concerns, or I'm going to be again asking for a vote?
I'm sorry. Can I just really quickly ask something?
Yeah.
Is that?
Yeah. Now's a good time.
What is the subject matter that is sensitive that you're hoping to discuss? I mean, just.
So not used to this, I apologize. It would be there, issues may be raised concerning certain previous plea agreements that involved such.
Sorry, can you speak up, please?
Let me just do this. There exists the possibility that certain elements regarding plea agreements from 15 years ago may come up regarding potential sexual misconduct by Mr. Tran. And if we get any kind of details or stuff like that, I think that could be pretty embarrassing for him. And it just might inhibit him from just, like, if you guys have questions of him, I mean, it's one thing to answer that in front of y'all. It's another thing when there's a group of people here are here and whispering in the background. You know, I do apologize, but, you know, I think if we were to try to, I'm trying to give my client the best chance to express himself as vigorously as possible, and also have you guys have to hold back if necessary.
Are the alleged victims also present?
This happened in Maryland.
No, I mean,
Maryland? Back east.
It happened in Virginia.
Virginia, pardon me.
Yeah, and so no, there are no victims. My witness, Inspector Mishler, who will testify about how he received information from the Virginia board, and he will authenticate the documents that we're going to present as exhibits. And so I mean, at least for me, I'm not anticipating anything other than the facts that are outlined in the complaint being discussed. And again, I think we would submit that, you know, it should be an open meeting.
If I may interject, though, however, just in the discussion we had here alone, there was a lot of, maybe it could come up, I don't know, I'm not sure, from the AG's office. It could come up.
I guess our position is it doesn't matter. There's no rating of board meetings, whether it's R-rated or, you know, anything like that. So we believe that we should just, so I guess maybe there'll be things that are inappropriate, and if someone's offended, I would ask that they leave the room and not be offended.
Right.
That's my position.
Rosemary, Ms. Reynolds, did you have a question?
No.
Your light's on. Ms. Tran?
No, I agree whatever, whatever Ms. Bradley just said. I totally agree.
So we have a motion on the table to deny the request to have a closed hearing. We had a second. Pardon me, the motion was made by Ms. Ritchie, and it was seconded by Ms. Tran. Any other questions, comments, or discussion? All those in favor to deny that request for a closed session, say aye.
Aye.
Aye. Any opposed?
Nay.
And so I'm counting Ms. Benaldi and Mr. Balthazar as nays. There are just 2 out of 6. And so that motion to deny your request for a closed session, Mr. Garcia, was granted. Let the official record show that the...
Her motion was to deny the closed session.
Yeah, to deny it. So let the official record show that case number CA 201-612 will be heard in open session.
Mr. President, did you vote in favor of the motion then?
I did. I was compelling evidence to change my vote.
And Mr. President, I would ask that you remind the audience members, both in the north and in the south, that they need to be quiet and silent during this proceeding. They shouldn't be making faces or comments at all during the proceeding, whether it's staff or audience members.
And so the general public has heard Ms. Bradley's request to please be respectful to the respondent and his attorney for the content of today's hearing. I will ask that you leave if it becomes a problem. And when I say if it becomes a problem, there will be just one opportunity. It's not a 3-strikes you're out. If you don't adhere to Ms. Bradley's request, I will ask that you leave. For those of you not familiar with the complaint hearing, the process rather, I will just take a quick moment to give you an overview. The respondent is the person that represents the licensee or is the licensee or the establishment whom the complaint has been filed against. The Deputy Attorney General, Ms. Bradley, will present the board's staff's case, and she will enter exhibits into record and call witnesses to testify. After all the testimony by each of these witnesses is complete, the respondent will be allowed to ask questions of these witnesses. Then the board members may question the witnesses. The respondent will then be allowed to call any additional witnesses to testify and enter their own exhibits into the record. These additional witnesses will then present their testimony, and Ms. Bradley will then be allowed to ask questions of any of them. Finally, any board member may question those witnesses. Ms. Bradley and the respondent will both be allowed to make closing arguments, and that will close the public evidence portion of this deliberation for the case. And so the motion will be made by a board member to provide any disciplinary action or fine, and then a vote will be taken by the entire board as usual. Are there any questions from either party before we begin? Mr. Nelson, do you need a break before we begin this? Do you want just a little 5-minute hand-wringing break before we get started? Do you want a little sip of water before we get started? Okay. Do you have, Mr. Tran, have any witnesses that he'd like to be here today? And
He does not.
Okay. And so have we already been sworn in from when we were listening to this before?
I would ask that Inspector Mishler testify. I believe he's been sworn, but I would ask that he be sworn to the disciplinary hearing because it's a different portion of the meeting.
So, Mr. Mishler, although you've been sworn in earlier, we're going to have you swear in to tell the truth for this particular matter.
I actually think we were both sworn in for this case.
Okay.
Oh, I apologize. It's been so long. I apologize.
Thank you, Mr. Mishler. I appreciate it. Now that that's confirmed, I guess we can begin. And so, again, I just want to reiterate that the burden of proof is on staff and Ms. Bradley. And I guess I'll just turn that right on over to you if you wanted to present your case.
Thank you. I would waive an opening statement. I don't know if Mr. Garcia would like to make an opening statement.
I'll do likewise. I'll just save it for close.
Thank you.
I would first ask, the board has been provided with the complaint notice of hearing. It is marked as Exhibit 1, and I would ask that just officially for the record it be admitted.
So admitted.
And Ms. Bradford, please do make sure that Mr. Nelson gets a copy. I would now call Inspector Mishler. And I'm probably misspeaking. You're actually Compliance Administrator Mishler.
That's fine.
Okay. Inspector Mishler, would you please state your name and spell your last name for the record?
Christopher Mishler, Mishler.
And who is your employer?
The Nevada State Board of Cosmetology.
What is your job title?
I'm a compliance administrator.
And how long have you had that position?
That position since February. I have worked for the board since July of 2015 in investigations.
And what was your previous title then?
Chief investigator.
Okay. And as the compliance administrator for the board, is your responsibility, does that include investigations?
It does. I handle the investigations of complaints, and I delegate those to other inspectors as necessary.
How did you first become aware of the incident case?
In this case, I received an anonymous phone call on the 17th of February, which gave me Mr. Tran's name and his social security number, telling me that, well, the caller alleged that Mr. Tran had convictions, which he had not disclosed on his initial application with the State Board of Nevada, and also that he was not current on his child support.
And is it common for the board office to receive anonymous phone calls?
It is, and it sort of depends on whether we could proceed with with somebody being anonymous or not. Obviously, if we need somebody to come to a hearing and testify, they could not remain anonymous and still have the investigation proceed. But if it's something we can go out and do an on-site inspection to corroborate or, you know, have evidence, then we don't need the complainant to go on record with their name.
So what is the board policy or practice with regard to anonymous complaints?
We do always attempt to get the name of the person making the complaint, but if they're uncomfortable or just refuse to give their name, then I sort of have to evaluate the case to see whether I can proceed or not without having that person's name.
So in this case, what did you decide to do?
I did a quick investigation just to see if I could find any facts that would support it, and I did find evidence, so I did not need to know the name of the person who made the complaint in order to proceed.
So I'm guessing your first step was to verify first that Mr. Tran did have a board license.
Yes, it was. I searched our records and found his account with the board with both the name and the social security number that was provided by the caller.
And then what'd you do?
I investigated the allegations. They were that there was disciplinary action taken by the State Board of Virginia's Cosmetology and Barbering Board. And so I contacted them.
I beg your pardon, I do have to object on this one. What is the basis on that?
I'm sorry?
What is the basis for that? Do you have authentication for that, please?
I'm sorry, I missed your objection.
You're...
Keep on forgetting that. I apologize. Authentication of that information.
I think the question...
I can get to that. That's fine. I contacted the Virginia State Board of Cosmetology and Barbering to investigate whether they had a record of this alleged violation. They pointed me to their public records. I found the documents that I can present. I also asked the person I spoke with on the phone to verify by social security number that the Min Tran I was looking at in their disciplinary records matched the Min Tran in our records. And they did confirm that the social security numbers matched.
So did you receive
So
documents?
the objection's denied.
Did you receive documents from the Virginia board then?
I did. I printed them off of their website. It's on their publicly available information on disciplinary actions.
Okay, so...
Again, I will have an objection as far as authentication on that. Usually these things are done through an affidavit custodian of record.
Okay. Well, I'll just clarify. So, Mr. Mishler, you went to the website, the official website for the Commonwealth of Virginia's Board for Barbers and Cosmetology.
I did.
And when you went there, you were able to search for records regarding Mr. Tran.
Yes,
And you found records on that website.
I did. I was reviewing while still on the phone with the representative from their board.
And did you print them off?
It print them off. And also at that time, I verified that the disciplinary action taken against this individual matched the individual in our records.
You verified that with the person you were speaking to.
I did. They did confirm.
And so the documents that you printed and that we have, I believe, available for the board in Exhibit 2, are they the same as the ones you printed from the website?
It is, yes, the same one that I printed.
Did you alter it in any way?
I did not.
Based on Investigator Mishler's or Compliance Administrator Mishler's testimony, I would ask that Exhibit 2 be admitted into evidence.
Once again, I will reiterate my objection. Authentication, these things usually.
It hasn't been provided to you yet because it's not admitted yet, and I'm asking,
Yeah.
he's objecting that it's not authentic. My response to that, it would be Inspector Mishler testified that he went to their website, he looked up records for a Ming Ngoc Tran, he printed them off just as they were on that website, and he verified with the person he was speaking to that the Social Security number for the Ming Ngoc Tran on their website matched the Social Security number in the board's record. So I would submit that that is more than sufficient authentication of the records.
With all due respect, I would disagree. I think authentication in such a case would require some form of testimony from the individual who verified this and/or an affidavit of custodial record.
There's no such requirement in administrative hearings.
Your objection has been denied and so admitted.
Ms. Bradford, I would ask that you provide Exhibit 2 to all of the board members and Mr. Nelson, please.
And Ms. Reynolds, that's a confirmation that that's not a requirement administrative hearing?
You've ruled on the objection.
Thank you. You would have prevented a ruling on that if that had been a requirement for an administrative hearing, correct?
No.
Okay.
So Inspector Mishler, after you received those documents from the board website, what did you do next?
At this point, after reviewing these documents for Virginia Board for Barbers and Cosmetology, I printed out Mr. Tran's initial application with the Nevada State Board of Cosmetology to see if there were discrepancies in what he had put down that weren't correct now that I had this information from Virginia.
Okay, and well, let's talk about information from Virginia. So what were the documents that you printed?
The document is a final opinion and order it's a informal fact-finding conference. My assumption is that this fact-finding committee heard the case and then made a recommendation to the board as a whole. And this order is the board as a whole ruling to take disciplinary action against Mr. Tran.
Okay, so there's really more than one document in Exhibit 2. Could you
There is.
identify them for the record?
Sure. The first page, the first 3 pages are the final opinion and order from the board. And after that, the following 5 pages is a summary of the informal fact-finding conferences hearing that they had to gather the facts in order to make the recommendation to the full board.
Okay, and if it is easier for the board members, the copies that Ms. Bradford has, I did ask be bait stamped. So I don't know if Mr. Mishler, if that would be helpful for you to have the bait stamped copies or not. I thought it might be easier to refer to pages if we had uniform numbering. So if anybody.
Yeah, do you have another copy or no?
So what was the date of the Virginia board's order?
The final order was effective July 2nd, July 30th, 2007.
So that was the date that the disciplinary action was entered against Mr. Tran, according to these records.
It is, yes.
And what else did you do as part of your investigation?
So I checked Mr. Tran's initial application, we do have a section at the back where it asks, applicants applying for cosmetologist, esthetician, electrologist, instructor, hair designer, or nail tech license must complete the following information and ask a series of yes/no questions. The first one is, have you ever been a defendant in any litigation or administrative proceeding other than as a witness? Mr. Tran marked no, he had not.
Okay. And what was your belief as to the truth of that statement after you reviewed the documents from Virginia?
Well, he was a defendant in an administrative proceeding in Virginia. That's what that order is. It's disciplinary action before an administrative board.
Okay. And what was the second question on that list that you're referring to?
The second question is, has any license issued to you by any public authority been denied, suspended, or revoked? And again, Mr. Tran marked no.
And what was your belief as to the truth of that statement after you reviewed the Virginia board order?
That would not have been a correct statement that he put on his application, because the final opinion is that Mr. Tran's license, which was issued by Commonwealth of Virginia's Board for Barbers and Cosmetology, was revoked.
And what about question number 3? What does that say?
3 reads, have you ever been charged, arrested, or convicted of a misdemeanor, gross misdemeanor, or felony? And again, Mr. Tran marked no.
And what was your belief as to the truth of that statement after reviewing the Virginia board documents?
After reviewing the Virginia board documents, it's clear that they based their disciplinary action on 2 felony convictions, and therefore, since he had pled guilty in 2 previous cases, when he put no, that was not correct. My understanding is the Virginia cases are felonies. I'm not sure. I don't have the case information.
Actually, the characterization doesn't know.
Okay.
Pardon me. The gentleman doesn't know.
Okay. But if you look at question 3, does it cover all types of criminal cases, whether they're felonies, in other words, misdemeanor, gross misdemeanor, or felony?
It does. It wouldn't matter for the sake of the question whether it was a misdemeanor, a gross misdemeanor, or a felony, because he marked no for all 3 of those. Therefore, whichever categorization these prior charges are, it would not be a correct answer for him to have marked no.
Okay. And so then what did you do?
At that point, I spoke with the deputy director and the director and let them know the findings of the investigation, and we agreed to put it on for a hearing to seek the revocation of Mr. Tran's Nevada license.
And if we look at Exhibit 3, can you go through that and tell us what's contained in Exhibit 3?
You haven't given
No, it hasn't been
Exhibit 3 yet.
introduced to the board, but Mr. Mishler has it, and I'd like him to authenticate it before I ask that it be admitted.
Yes. Exhibit 3 is copies of the initial license and application that Mr. Tran submitted when he applied for a Nevada State cosmetology license as a nail tech.
And when did he first apply for licensure?
We received it the 9th of January 2012.
Okay. And are these true and correct documents, or copies, excuse me, true and correct copies of the documents that are contained in Mr. Tran's licensing file at the board?
They are, yes.
And do you see any changes or alterations to them?
Just to take out private information, social security number, date of birth.
Okay. And page numbers have been added at the bottom by me?
Yes.
Based on Inspector Mishler's testimony, I would ask that Exhibit 3 be admitted.
Any objection, Mr. Garcia?
It would be the authentication. Did you prepare these documents yourself?
I
would stick with that, just the authentication, please.
Thank you. So admitted.
Okay, just so I can put a response to the authentication. Inspector Mishler testified that they're true and correct copies of what's contained in the board's file for Mr. Tran's licensing, and so I believe he has sufficiently authenticated them. And Inspector Mishler, I believe there's one more exhibit, and it's Exhibit 4. Have you seen that?
Could she put
Yeah,
3
I'll-
out?
Sorry, please pass 3 to all the board members. I believe it's been admitted, and the board should be able to look at that. I apologize.
It has been. On Exhibit 2, on page 5, the last page, it said, and in the last 2 paragraphs, it says that the facts were both misdemeanors in that second sentence.
Okay. Sorry, I didn't mean to mischaracterize.
No, that's okay, but that's accurate, though, right? Because, I mean, I've admitted this into evidence, and...
You should just look at what the exhibits say, yes.
Okay.
I mean, again, I have not seen the actual criminal cases, so I can't speak to what they were charged as.
Okay.
Have you seen Exhibit 4, Mr. Mishler?
Yes, I have.
And what is it?
It's the 233B letter that I sent out to notify Mr. Tran that we're proceeding with disciplinary action against his license.
Okay, and what is the date of that letter?
That was sent March 3rd, 2016.
And it's signed by you?
It is.
And does Exhibit 4 appear to be a true and correct copy of the letter that you sent?
It is, yes.
Based on Inspector Mishler's testimony, I would ask that Exhibit 4 be admitted.
Sorry, no objections on that one.
Thank you. So admitted. And so on Exhibit 3, there's no mention of having a license anywhere else.
That's not it's not time for you to question
Oh,
me.
okay,
Once I finish with Mr. Mishler, you might ask questions of him.
Okay, thank you.
So, Mr. Mishler, I believe you testified that the application was dated January 9, 2012. When did Mr. Tran first receive his nail technologist license?
My understanding is it was received May 3rd, 2012. That was the initial licensure after testing.
Now, when applicants apply for licensure, and I believe if we look at Exhibit 3, because that's where we have the application, are there areas where they assert that everything provided in the application is true and correct?
There are, yes.
And where is that?
Let me find them all here. Well, on the very first page, it would be NSBC page 0011. Right above where it says please print and his personal information is shown, it says, I hereby make application for certificate of registration and license to engage in the practice of the occupation of cosmetologist and pursuant to the provision of the laws of Nevada, Chapter 644, Statutes of 1931. Request admission to examination to determine my fitness to receive such registration and license. I hereby enclose the prescribed fees and submit the following statements and answers as questions to my qualifications. He's not affirming, but it is a place where he says, I know I'm providing this information to get licensed.
And what are the qualifications for licensure? What do they include?
Basics are you need to pass and graduate from a school with the right number of hours. At this point, do you know what was for mail tax? 600. It would have been 600 hours at the time of his application. In addition to that, you need to take a written and practical test and pass a Nevada law test.
When it says, I request admission to examination to determine my fitness, is part of the fitness, does it include things other than testing?
It does. It's also including good moral character, and that's on page 13 of that application.
And is that also contained in the NRS? Does it require good moral character to be licensed?
It does.
And so if we look at page 13, it looks like there's a certification at the top. Could you read that for us?
Yes, it reads, I do hereby certify and declare that I am of good moral character and temperate habits, that I am not a habitual drunkard, that I am not addicted to the habitual use of morphine or any habit-forming drug, that if I am granted a certificate of registration and license to engage in the occupation for which this application is submitted, I will not advertise by means of knowingly false deceptive statements, that I will not be guilty of gross malpractice, that I will not obtain any practice for which this application is submitted or any branch thereof for money or any other thing of value by fraudulent misrepresentation, that I will not permit my certificate of registration or license to be used when I am not personally, actively, and continuously engaged in the business, that I will not engage in any unfair or unjust practice, method or dealing, that I will not continue in practice if I knowingly have any infectious or contagious disease, that I will display my license in a conspicuous place in my principal office, place of business, or place of employment, that within 30 days after changing my place of business as designated herein, I will notify the Executive Director of the State Board of Cosmetology of my new place of business, and that I will faithfully obey any and all requirements of law and all sanitary or other rules and regulations of the State Board of Cosmetology and the practice of the occupation for which this application is submitted.
And so after reviewing the documents from the Virginia board, did you have a belief as to the truth of Mr. Tran's agreement or certification with the certification in the application?
Yes. For both questions 1, 2, and 3 that follow, he had marked no, when in fact the evidence that I had gotten from the Virginia State Board showed that the answers to all 3 of those should have been a yes.
So then did you believe that perhaps his application was containing fraudulent misrepresentations?
Yes, yes.
And did you also believe Mr. Tran to be of good moral character after reading the Virginia documents?
I did not.
And can you just summarize for the board and for the record what the underlying allegations were in the Virginia board case?
Sure. The Virginia board case hinges on the fact that Mr. Tran had pled guilty to 2 charges, separate incidents of sexual assault against a minor while he was working as a nail tech in a nail salon.
So the assaults occurred in a nail salon according to the facts in the Virginia board documents?
Yes.
And if you look at the bottom of page 13, there's a notary stamp and signature there. Can you tell us what that means?
Yes, that's where the person who is the notary verifies the identity of the person signing before they sign, and they make sure that the person understands that they are taking an oath attesting to the truthfulness of the facts that they're signing to.
Right. So in other words, that's another place where a person is saying, I'm providing true information in this application.
Yes, it is.
What date did you receive the documents from the Virginia board?
I received those on March 3rd.
Okay. And so just so the record's clear, the application that Mr. Tran submitted to the Nevada board, the incident board, was in 2012.
Yes,
And the revocation in Virginia occurred in 2007.
it did.
So from that timeline, as you stated, I think all the answers should have been yes to those 3 questions.
Yes, in 2012, he would have known that he had, in fact, been a defendant in an administrative proceeding. He had been revoked as a licensee, and he had been convicted of either a misdemeanor, a gross misdemeanor, or a felony.
And what were the dates approximately of the criminal convictions?
Just want to double check.
It's on page 5.
So in 2001, April 4th of 2001, he was convicted of 2 counts of sexual abuse, both misdemeanors. Both convictions resulted from incidents that occurred when the victims were receiving nail services at Golden Nails Salon.
Okay, so again, the dates of those criminal convictions were prior to his application date with the Nevada Board?
Yes. I think also something that's important to note is when the Virginia Board took action against his license, they noted not only that the crimes had been committed, but also that he had also incorrectly or fraudulently marked his application with them as well. So my concern was not only did he have it revoked for misrepresenting himself on an application, but then he did it again with us.
Okay. And what else did you think? I mean, were you concerned about the allegations?
Of course, yeah. Both the fact that he misrepresented himself on his initial application with the Nevada State Board, but also the risk that that would put other members of the public in salons in Nevada, just based on his history.
Okay. So you would characterize these as very serious allegations then?
I would, yes.
I have no further questions for Mr. Mishler at this time.
Mr. Garcia?
Thank you, counsel. Mr. Commissioner, I noticed that
You'll probably have to speak up.
I'm not used to this thing at all.
That's quite all right.
I apologize to the members of the board.
It's okay.
Mr. Commissioner, you had stated that the way you found out about this matter to begin with was an anonymous phone call, a tip. Per se.
Yes.
Okay. How common is that?
In fact, that was asked and answered. I asked him at the beginning whether or not receiving anonymous complaints was common or not.
It's quite all right.
I don't see the harm.
It's pretty common. I don't have an exact percentage, but I don't know, 25, 30% are anonymous.
Speaking of complaints, my client's record in Nevada, have there ever been any complaints regarding his professional services in this state?
I did not find any, no.
And the basis of these actions in other states refer to actions in 2001?
Yes.
Okay, so we're talking 15 years, correct?
That's correct.
Pointing to Exhibit 2 that was admitted, there were 3 questions you stated you have problems with the answer of my client. Pardon me. The first question being whether he was in ever in an administrative procedure. Is that correct?
Right. A defendant in any litigation or administrative proceeding.
Now, I was listening to your testimony very carefully. You also stated that he could just be wrong. Is that correct?
I'm sorry?
Did you state that he could just be mistaken or wrong as far as his reply to that answer, that question?
If this had been the first time this had happened, that would be a possibility.
I'm asking about this particular time.
You're asking about this particular
Yes.
time? I don't know. I didn't fill it out.
I think, is there a record of that?
Are you trying to say that staff filled out the application for him?
No, not at all.
Just that he filled it out mistakenly.
Mistakenly, and there was a statement to the effect that it
And
could be wrong.
Is that a possibility, Mr. Mishler? That was the question.
It is a possibility, but it's very unlikely considering that
But it is a possibility.
everything's possible.
Same thing with question number 2. Pardon me. I have to use my records. I apologize. Have you had any license issued to you by a public authority that's been denied, suspended, or revoked? Again, if I recall your testimony originally, was that it could also have been a wrong answer.
I'm going to object. I don't think Mr. Mishler ever said that made any statement like that he might have been wrong. So I think it misstates testimony.
Well, I mean, I stated that his answer is wrong.
Yes. I beg your pardon, I'm sorry.
I mean, the answers are wrong based on the facts. Is that what you're asking?
Correct. No, that you stated that it was wrong.
Well, my question to him was, after reviewing the Virginia documents, what was your belief as to the truth or the accuracy of his answer to the question? And he said it was wrong. So we can have it read back if you like, and that's fine with me.
Yes, I'm fine with that as well. Pointing to that same document, just a little further down, I noticed that Mr. Tran, when applying to take the exam, paid the extra funds for having the test taken in Vietnamese. Do you see that?
I do, yeah.
Okay. So he actually took this exam in the Vietnamese language. Is that correct?
Yes, he did.
Are there any provisions made for an individual to fill out this form in the Vietnamese language so they fully and completely understand the questions that are being asked of them?
No.
Board's indulgence, please. Also listed in Exhibit 2, right behind the application from Nevada Board, I think this is the Bates number NSB 0014. The letter from Massachusetts State Board of Cosmetology Certification. Do you see that?
I do, yeah.
Okay. And there's a provision there that at the time my client applied there was a possibility that they can't verify whether an individual was fluent in English and might need an interpreter. Otherwise, were not required to have interpreters at that time.
Well, there's actually
Final page.
information specifically regarding that in the Virginia decision.
I'm asking you about this one.
What are you asking me about this page?
On this page, is there a provision, almost a disclaimer, that perhaps interpreters were not used in Massachusetts during that period of time that my client had a license in Massachusetts?
It says they were allowed, yes.
Did you see the bottom paragraph?
Yeah,
Board
do you want me to
cannot
read it?
Can you read it from the board cannot?
Sure. The board cannot verify whether a specific license was issued with the aid of an interpreter. All examinations, both practical and written, are nationally certified. Minimum passing score for the written exam is 75. Minimum passing score for the practical is 80.
Thank you. No further questions of Mr. Mishra.
Have a redirect, please.
Please.
Thank you. Inspector Mishler, if you look at the Virginia documents, is there a discussion regarding whether or not Mr. Tran understood some of the words contained in their application?
There was, yeah.
And I believe that's on NSBC 0004.
Yeah, let's start with, let me make sure the page here before I, yes, on 004. It reads, Mr. Tran claims he was confused regarding the meaning of the word conviction and did not understand the question on the application. For several reasons, I find it hard to believe that Mr. Tran understood the straightforward question. Have you ever been convicted in any jurisdiction of any misdemeanor? Further, even though the question tells the potential licensee not to disclose violations that were adjudicated as a minor in the juvenile court system, Tran was 32 years old when he was convicted in circuit court. It goes on to say, according to information in the record from the Massachusetts State Board for Cosmetology, Tran received his license as a result of taking an English-only examination without the benefit of an interpreter. This demonstrates a reasonable command of the English language, as well as a level of intellect capable of understanding and correctly responding to written questions. The question on the board's application is straightforward, easily understandable, and certainly not as difficult as typical exam questions. Moreover, the police reports do not note that Tran had any difficulty understanding English or that the officers had difficulty understanding him. Finally, during the IFF informal fact-finding, it was clear to me that Tran understood the questions being asked. The question on the board's application is no more difficult.
And if we look at the circumstances, I think if you continue down on 005, if you look at, I think it's the fourth paragraph, it refers to Mr. Tran talking to the victims. So I think could you read during the second assault? I think it's in the middle of that paragraph.
It reads, during the second assault.
Is this a redirect, or are you
This has kinda
asking
gone a little-
are you asking a new line of
In
questioning?
an administrative hearing, redirect isn't limited to what was done previously. And Mr. Garcia has opened up whether or not Mr. Tran understands English well enough to properly answer the board's questions on its application. So I'm asking Mr. Mishler to point out for the board and for the record evidence that we have in the exhibits that are before the board
And
that show that
what
Mr. Tran...
specifically in paragraph 4 are you referring to? Because that's a long paragraph, and I'm not going
On
to have
him to
Mr. Mishler read the entire thing. If you could identify where
I
specifically.
said the sentence that starts with during the second assault. It's approximately in the
Okay,
middle
thank
of
you.
that paragraph. So, and if you would stop with breasts, so during the second assault and stop with breasts, I think it's right before I note.
During the second assault, Tran engaged in conversation while giving the victim a manicure. Tran asked the victim how old she was, 16 years old, questions about babysitting and music. After Tran finished polishing the nails and the victim's hands were in the hand dryer, he started massaging her shoulders, then shoved his hands down the victim's shirt.
I think that's enough in that one. I would start to object after that point, starting to get more into.
That's fine, I don't.
Into the lurid.
I mean, it's in the record, so it's public, but I agree that it's not necessarily be read. But does that lead you to...
I don't understand where the English is coming in from this line of questioning, Ms. Bradley. Nothing about that particular sentence says anything about the Mr. Tran being able to comprehend English well.
He had conversations with the victim regarding babysitting and music, asked her how old she was.
It doesn't say what language, though, counsel.
You're right, it doesn't say it, but I'm asking Mr. Mishler what it says. It doesn't say it was discussed in Vietnamese either.
So you want to continue?
I do have one more.
We can come back to it if you'd like. I'll give the board members an opportunity to ask any questions and then give you another opportunity.
Well, I just wanted to make sure. I have no further questions for Inspector Mishler.
Mr.
Okay.
Mishler, I just wanted to quickly ask.
I think Mr. Garcia gets to recross before you ask questions.
Yeah, from the redirect, yes, sorry, yep.
Again, Mr. Mitchell, this report from the Commonwealth of Virginia Board, the Summary of Informal Fact-Finding Conference, Big Stamp 005, that those conversations that you were referring to and read into the record, those don't state what language that was spoken in, does it?
The second one regarding the assault, no, it doesn't specify a language.
Furthermore, as far as what I consider to be the dismissive conclusion by Virginia, they did not at any time indicate that Mr. Tran was made available of a translator who spoke Vietnamese. Am I correct?
During the hearing?
Yes, during the hearing.
No, they did not say he was given an interpreter during the hearing.
Thank you.
Mr. Mishler?
Mr. Leader,
Pardon me?
just 1 second. We have our council has to check on something.
I need to take a 5-minute break because I have a witness coming in for a separate proceeding, and I need to make sure they're still here.
Please. So at this time, it's 12:11, and we'll resume in about 12:16.
Speak English to his lawyer.
Right.
You know what I'm saying? Clearly, he can speak English.
Oh, my. This meeting of the Nevada State Board of Cosmetology is back into session at 12:17. We had completed redirect. And so I wanted to just ask you, Mr. Mishler, that had the applicant, the respondent, checked on that NSBC 0013 in Exhibit 3, had he have checked 1, 2, or 3, the yes in the affirmative, it would not have been a mandatory denial of his application.
No. In that case, if one of those was marked yes, we would ask for the specifics, the facts of whatever one that was marked yes.
And even then, it would be still considered
Yes.
for approval.
Yes, it would.
Certainly checking that box, yes or no, we're looking for the truthfulness, but it's not an indicator of a denial for the application.
That is correct.
And same thing with the child support information. While it may be that the applicant or the respondent inadvertently marked an incorrect box, checking the other two boxes, the remaining boxes, would not have necessarily given him an automatic denial to the application.
That is correct.
Actually, I'm going to object. That's not true.
Oh, okay.
Look carefully at the child support, because you asked about child support.
Yes.
First of all, we didn't talk about that on any of the other questioning, but if you'd like to, it's in there. But actually, by federal law, anybody who says they're not in compliance, so they either have to be not subject to or they have to be in compliance with it. If you indicate that you're not in compliance with the child support order, as a matter of law, the board cannot grant a license.
Where does it say that?
Well, on the bottom there, I mean,
it's
in your NRS 644.
The 190, is that the .190?
I think it's 212 and 214. But regardless, I mean, I'm not sure if that's relevant, the child support. I think that was in the original complaint, but that's not really, I don't think anything that Mr. Mishler's investigation revealed as problematic.
What I was hearing was that there was a pattern of either checking the boxes inadvertently, perhaps due to misunderstanding, or just whether there was a pattern of falsification on the application.
I'm sorry, if I may interject, my main area of practice is family law. Child support order can also have occurred subsequent to the filling out of this application.
Right. And just to clarify, I was only talking about the three that we've already discussed. I haven't.
The other on the page 5.
Correct.
Okay, thank you. Anybody else with any questions?
Yes.
Of Mr. Mishler.
Right.
Okay.
My question to you, Mr. Mishler, is that when the respondent took the exam, did the applicant take the exam, the Nevada State Board exam, as I read it here, in English?
Yes. On his application, he had chosen Vietnamese. That was his attorney had asked me, but in actuality, when he took the exam, he took it in English.
Okay, but if an applicant signs up to take the exam in whatever their original or native language, it appears to me that the applicant passed with like a high score with the exam. But if they ask to take it in their language and they don't, and they still pass, what actually happens then?
Well, if they pass, they get licensed. Now, we see it a couple of different ways in testing. We've seen people who want, like on the initial application, Mr. Tran marked he wanted to take the written test in Vietnamese. I have seen where they come into the testing and they take the entire test in Vietnamese. I've also seen where they take the English test, but they have a Vietnamese translator who's sitting next to them that reads the English, translates it in Vietnamese on the spot, and then they choose the answer in English.
So if they ask to take it in their own language, then they have to have their own interpreter.
Right.
Okay. So he requested, but did he, when he showed up for the exam, the applicant, did he have an interpreter there with him?
I don't show any records that there was an interpreter that assisted him.
That was my question.
I would like to ask a few questions. Mr. Tran?
No.
I mean, Mr. Mishler, did you, when you received the calls from the person that was allegating that there were some problems here, was it a man or a woman?
It was a woman. My suspicion was that it was possible that it was the ex-wife.
That's what it is, because who signed this paper? This person. It's not his signature. I don't know if everybody can see on Exhibit 3, where it says child support information. I'm just allegating, I'm just speculating here. Where it says, the top where you see California Nail, Boston MMA, to my knowledge, it doesn't look like that's his writing, and neither is his signature under child support, because if you turn to the next page, you'll see a signature of applicant is very different than the one dated 1/9/2012.
I understand what you're saying with the date is very different. It seems like somebody else may have filled that part
Yeah,
out.
someone filled this out.
But the signature actually is pretty close to the signature that's on the next page
I
as far as
just
some of
found
the
3 other
characteristics.
signatures from Mr. Tran, and if you look back on the, look at that, I mean, it's clearly not his signature. That's my speculation. That's all I want to include. Also, I wanted,
I'm going to object. I don't know if there's been any evidence about that, and I'm not sure what signature you're referring to.
okay, if you look under child support information, you see,
Uh-huh.
and go to the next page, signature of application.
It's the same.
If you look at the first.
I mean, I'm not a signature expert, but they look pretty
My
close to
uncle-
me.
I'm not authorized at none of this, but my uncle used to work for the FBI, just.
Okay, well,
looking-
if you
so
look
I
at
just
page
got a little bit of
15,
information.
Page 15 looks the same as well. There's a signature on the Social Security card. I mean, we could bring an expert in, I guess,
I'm
but
just saying,
the notary does validate the signature, so I don't know.
and the notary being Deanna Tran, or Von.
Anna Tran, it
Bonnie
looks like.
Tran.
I mean, Ms. Ritchie, I understand what you're talking about with the start of the first letter, how on
Yeah.
not the child support one, but the other one, it's curled under at the start, and on the other one, it sort of goes out instead of in. I understand what
Yeah.
you're talking about.
Yeah.
And looking at most of the other characteristics, both on those 2 signatures and on the Social Security card that we had, there were enough
Well, I believe-
similarities that we just
okay.
didn't pursue it.
I'm just looking at, and also I wanted to ask you as well, on 2001 of April, that was his second conviction, and what state was that in?
My understanding is both were in Virginia,
Both from Virginia?
and I believe he may have had one case pending when the second one happened.
Okay.
And they both got resolved at the same time. So I
Okay.
think he pled guilty to both at the same time in
So
April.
this allegation was this taking place at the same facility?
Yes, both occurred at the same.
So
Golden
were there,
Mills.
with the person that contacted you, were there other people in the nail salon that knew of his past convictions
Here in Nevada or in Virginia?
in Virginia?
I have not been in contact with the salon in Virginia.
Or here in Nevada?
Nobody in
Nobody.
in Nevada here has brought forth any allegations
Yeah.
of misconduct.
Okay. Thank you so much.
So, Mr. Mishler, sorry about that, slaughter your name. So even though this conviction is over 15 years old, the application is current as of 2012.
It is.
So based on what we know, it's my understanding that he was convicted. He knew about being convicted because also he passed his test in English. He took it in English and passed it in English originally in Virginia.
In both Virginia and here.
And-
Actually, I think,
In Virginia, for sure.
well, I know in Massachusetts.
Oh, Massachusetts. Okay. In the past.
Yes.
So he understands English. Mark the boxes wrong under no both times. So I guess it's more of a statement and rhetorical, other than it's not really a question. Just confirming that. Is that correct?
That's my understanding, yes.
Okay, thank you.
Any other questions or comments to Mr. Mishler? Did you ever see a photograph of the Virginia license?
I didn't. I only got the records of their disciplinary action. It did not include either a copy of the license or pictures of him when he sat for the exam.
And did you ever get any photographs of the Massachusetts license?
I did not.
And did he apply for reciprocity?
I believe he did apply through the Nevada board through reciprocity because we have, as part of his application, the certification from Massachusetts. So we would only have that if he gave them, you know, he said, I'm licensed in Massachusetts, here's the proof.
So we don't turn in a license when we apply for reciprocity?
No. You can still be licensed both in Massachusetts and here.
Do we take a Xerox copy of their Massachusetts license?
If they have it, we would, but in most cases, they just say, contact that board and they can give you a certification is all we ask for.
Did you at all look to see if that name could match any other licensee?
It could.
And so how did you differentiate between the respondent and someone else with a similar or exact name?
I did that by using the Social Security number.
Thank you. And then lastly, are you following up on a written complaint, anonymous complaint, or are you following up just on a verbal complaint?
Again, it depends on, like if I got a written anonymous complaint stating a salon had bad sanitation practices, I can only go off of the information they give me because there's nobody to talk to. But when I go to the salon, I can see in person whether there is sanitation problems.
And so,
but in a case where I would need to talk to the person, or the person would need to come here to testify, we just could not proceed without knowing who that person was because we would need them to come.
Okay. And it was always my understanding that the inspection department follows up on written complaints, not on verbal complaints.
We follow up on all complaints that we receive.
All complaints.
Yeah.
Thank you. Mr. Garcia, oh, I'm sorry, are there any other questions, concerns of Mr. Mishler? Thank you.
I would rest at this time.
Thank you. And Mr. Garcia, now is an opportunity for you to present your respondent's case.
Oops,
Thank you.
Yes, Mr. Chan will be the only one I'll be questioning here.
And he's been sworn in.
Mr. Chan, I'm going to show you what's been marked as exhibit, pardon me. I think this one's bait stamped. 13. Counsel, do you want to see if there's some more?
That's fine.
Okay, just, okay. No, sometimes people write on them. Okay. Mr. Tran, could you please explain to this board the amount of English you do actually understand?
Sir, I can't hear you.
Mr. Tran, can you please explain to this board how much English you do understand? Please distinguish between verbal and written. Do you understand the question, sir? Oh, thank you. Can you explain to this board how much English you understand, verbal versus written?
Oh, no, I understand in it maybe 60% or 50-50 because if I learn for the nail, so all the letter or the question, so that I answer now the follow A, B, or C, but different words, so sometimes I don't understand it. So that's why sometimes maybe I misunderstand.
Did you ask for assistance that day?
I just and I never when I come in Nevada, so I never had the problem. So I try to work and help my family. So Anyway, can y'all give me the license back to work for to live? That's the question final. I want to know that.
Looking at,
Your mic's off again. I don't know why. I'm sorry.
very much, council. Eventually, I'll get the hang of this, I'm sure, as soon as I walk out the door. On Exhibit 3 again, Bates Stamp 0013, this is the application. Reading these questions, do you understand them now?
Some word I don't. Some word I don't understand it. So
Mr. Tran, I noticed that in that same application of Exhibit 3, you had requested to take the exam in Vietnamese. Could you explain to the court, to the board why? Could you explain to the board why you asked to take the exam in Vietnamese at one time?
because I get the math Vietnamese language is in this one my second language. It's not my country, but I try to learn it. But it's not possible for I'm understood all the English, so that one I master Vietnamese.
Mr. Tran, since you've been practicing your profession here in Nevada, have you had any complaints to the cosmetology board that you're aware of?
And when I come a test and
no, the complaints.
The
Have you had any complaints here in
about
Nevada?
No.
Okay, thank you.
Bradley, did you have questions of Mr. Tran?
No, I do not. Thank you.
Board members, it seems that Ms. Ritchie would like to get started with questions for Mr. Tran. Maybe just turn on your mic.
Just seems like you're trying to
Really-
engage, let's just say that. But is it my turn to speak now?
Yeah, if,
Wonderful. Okay. So, Mr. Tran, did you sign that? Did you fill that out?
Yes.
Okay, it's page number, it's in Exhibit 3. No, page number 00, yeah. NSBC 0013. Did you fill that out?
Yes.
You did. Do you understand do you understand, can you read 1? Can you read that back to me, 1? Yes, please. Can he read that?
Have you been dependent any? This word I cannot
I understand.
read. Yeah.
Go ahead, just try to do your best.
Or I can speak in the long.
Okay, can I ask you one more to read then?
Yes.
Can you read line number 6?
Have you ever entered a plea or contact to the criminal action?
You checked no.
Because somewhere in here I don't understand this, so that one.
I'm just trying to, I don't know you. I'm just trying to really fill you out. Let's just say that. I understand maybe you don't know all the words, but did you ask anybody or?
Go when I come up figure it out, I confused. So I get mad. I'm not mean, do like that.
Okay, thank you.
I have a comment or a question. On the page 13, the Exhibit 3, the same one where Ms. Ritchie was just referring to, where you checked, you wanted your test in Vietnamese. I have a large population of students that speak bilingual. They're bilingual students. They speak Spanish. And when they're testing their exam, they check the box Spanish, and it has happened before at the state board where they didn't pass the exam and they had to go back. But I think that what I'm trying to get a good understanding is you asked for a different language, but you took it in English and you passed at 84. As an educator myself, that's high. That tells me that your English, you might not speak and understand some things, but that tells me that you speak pretty good English. That's to me.
If I may, you said 84. I think what this form is asking for is 100% comprehension. 84 is not 100%.
Well, I'm going to object because the question wasn't to council, the question was to Mr. Tran.
Okay.
And so I think Mr. Tran needs to answer or not.
No, that's okay. My question to you, Mr. Tran, is when you went to take your exam, because it has happened before, I know, and you asked for it in Vietnamese. When you got to the state board and they gave you the test in English, at that time you could have said, I speak a different language. I need to have the test in my home language, instead of saying, I'll take it in English. You had an option at that time, but you took it in English, and it appears that you understood.
When I filled out for the information in the Vietnamese box, I don't have for or the question or the notebook, because the Vietnamese I try to ask my friend, they don't have it. They say they yet have a book for the English. So that one I try to learn answer and the question, and I just remember and A or B or C answer, because somebody just passed the license. Maybe I ask them this question, you think the A or B or C, so that one I learn from them. So that one I answer for the English. But I try to look for the book Vietnamese, but they don't have it.
When you went to take your exam, they didn't have it in your language when it was English?
No, I asked my friend, yeah.
Oh, okay. So when you went to the state board that day to take your written exam, when they handed you an exam that was English, did you let the tester person know that was in testing that I don't speak good English, I need to have the exam in my language?
Yeah, I must, but they only they have the English, and when it comes to Nevada, I'm not enough for the money for anything, because I live by myself for the car insurance and everything. So I try to look, my friend borrow or the book, and they say you go English easy then for Vietnamese, because some Western the translation, that's the same. That difficult for you answer.
But I do understand.
So that one they say you go English, and I can show you, learn. You see that question, you answer that box. So that one I try to learn from my friend.
But did you take your exam in Minnesota and in Virginia in English?
Yes.
Massachusetts.
In Massachusetts, I'm sorry.
Yes.
So every exam that you've taken for nail technology or manicuring has been in English?
Yes.
Okay.
Mr. Tran, were you licensed in Virginia?
The license in Virginia after happened, so that one I'm to the way for Virginia.
But that was your license in Virginia back in 2000?
Yeah.
It was. Thank you.
So, Mr. Tran, in Exhibit 2 here on page, do I read this one? On page 5. So this is a repetitive situation where the evidence is clear that Tran intentionally failed to disclose his criminal convictions on his application. So back in Massachusetts, you had the same incident where you marked the same boxes after passing your test in English, and they found on their fact-finding investigation that since you could pass your tests in English and you've already been through this same situation back in Massachusetts, why would you do it again? Why would you mark no again? After you've already been through it, you had a $2,500 fine.
Is a $2,500 fine for the civil action, though? Is the $2,500 fine, that was the penalty for the civil action in the circuit court of the county that he was performing services.
Oh, and then it was revocation for marking no.
Oh, okay. Oh, yeah, I see that.
So you've already been through this. You've been the same exact situation, and you did it again. So that's the challenge I have with this whole case.
So, Mr. Tran, I think what Ms. Benaldi is asking is, are you just concerned that you weren't going to be issued a license had you have been honest?
Because the nails, so I love to about art, so that one I just go work for to make the money. So anything, so I don't know about that. So that one I just do nail manicure for to make the money for my life or even my son or my family.
So you knowingly checked the boxes incorrectly because you wanted to work. That's what it sounds like I'm hearing. Is that true?
Because some words, so I don't want to shoot that long, I can speak. I cannot speak the long word, you see. So sometimes people, if I ask what that means, so the whole question, because this one I feel by myself, so that one some word I don't want to shoot, I just confused and I'm mad.
But were you at all just very concerned that you wouldn't get a license if you were honest on the form? And so you specifically checked the wrong boxes to make sure that you got your license? Is that what it was?
Because I love my job, so that when I come, I get mad and I'm honored work with my job. Never have a problem when I come in Nevada. So that's why.
So kind of put the past behind you and move forward? Is that what you were doing? Just trying to make the past and start fresh by checking no's to the answers? Is that the deal?
I think it's kind of ask and answer, to be honest. I think he's just struggling with it. And I hope you notice a lot of your questions are the same.
Okay.
I've known the man for over 2.5 years. Thank you. Well, the man over 2.5 years, I represent him like piddly little tickets, and it's
Can I just ask one more
a challenge
question
at times to
of you,
explain to him what
Mr.
just
Tran?
happened.
How many times, because I know with the language too, I didn't ask that question. How many times did you take the exam? When you were in it was Virginia last, right? That's the last place he was licensed. How many times you took the exam in English? How many times did you take the exam before you passed it?
In Virginia, a long time ago, I don't remember, but at least I think about 2. But in Nevada, I failed about 2-3 times.
So how did you pass it?
I just learning and just ask my friend for the question again, and I just make, because when I make the question and I make, they say correct something.
So who told you to correct some things? Did somebody help you pass the exam?
No, I just go home, when I fail, and I just ask my friend, So I failed 2-3 times. I think the four or the third I passed.
Okay.
Hi, I'm Joanna Tran. I need a question from you. Mr. Tran, how long have you been in the United States?
I come in the United States in 1994, in November.
Do you know there's a lot of Vietnamese-speaking lawyers out there? How come you didn't hire one? You hired him if you don't understand a lot of English. That's just my question. If he's struggling to Mr. Tran, I'm asking Mr. Tran.
Because
if you don't understand it, how come you didn't hire a lawyer that is English and Vietnamese? There's lots out there.
Because when I get a letter, everything, so sometimes I try to look for a Vietnamese lawyer. Some people, I have a problem in the past in Virginia when I have a problem with the Vietnamese. Somewhere I don't understand, I just listen to them. So that when I have a problem before, so that now I have a problem like this. So that one, I try to ask my friend.
But you passed 2 different states, Virginia and Massachusetts, in English.
Yes.
Okay. You've been here since 1994, right?
Yes.
Did you not ever go to school for English? I mean, that's a long time to be here not to
When
understand.
I come in here, my stepdad take me go ZD. I just few months. So and after that, I over 21, so I need to leave. So I go to work in the morning.
All right. Can I ask Chief Chris a question, or is just him right now?
Go ahead. Just ask Mr. Mishler a question, yeah.
Can I ask you a question? Do you have any records of how many times he's passed here in Nevada? He said he's failed 2 or 3 times. Do you have records of that?
I do, yeah. It's on the very last page of his license packet.
And they were all in Vietnamese or just English or Vietnamese? What? Because he stated that he...
It doesn't state on here. This is just a payment page. So
Oh.
all I can see is that he...
How many times... Oh, I'm sorry.
It looks like the first time he took it was the 24th of February of 2012, and he failed, and he paid right then to retake.
Was that in Vietnamese or in English?
It doesn't say. I only have the record of the one that he passed that was in English, because that was the one that's included in the
So he
package.
failed one time.
It appears that he took it 3 times.
He did take it 3 times. I'm not sure what language, except
Okay.
for the very last one that he passed was in English.
All right.
Can I ask a couple questions to you again, Mr. Tran? How many children do you have, and are you married?
Oh, when I come in here, so, I'm not married, but we live together. I have one child.
Are you married right now?
Oh, I live with my girlfriend, but don't have a marriage license.
Thank you.
One more question for you, Mr. Tran. When you went back the last time, well, let me say the first time, you knew that you needed to take your test in your language, right? Did you ever tell State Board that you needed some assistance in taking your exam, that you have a problem speaking English? Did you ever, did they tell you the process that you needed a translator, or, did you say specifically, I know the last time you did, but you took it in English? Because to me, the only problem I can just see that I'm having is you knew that you needed to take the exam in your language, and you took it in English. And you took it in English, and you didn't do a bad job. So, to say that you needed your test to be taken in your language, but you had an option. You had an option to leave. If I'm handed a test and I can't read it or understand it, then I probably would tell them that I don't understand.
Address that. When Mr. Tran was speaking, a couple things that became apparent to me were, I guess, in the Vietnamese community, what they do is they learn by rote. May I address Mr. Mishler?
I'm going to object because I think you're testifying. You can say this in closing argument if you'd like, but I'm not sure that that's appropriate to answering her question that was directed to Mr. Tran.
I'm asking him a question, but it would be a direct question.
Sure, ask Mr. Mishler a question.
Mr. Mishler, are there horn books, manuals like where people study at home for this exam?
There are. The problem, though, is that the word was going to be different on the exam from what's in the books. So it sounded like he was saying that he'd memorized which answer goes with which question from the practice materials.
No, what I'm trying to say is that they start learning the basic patterns of a question. How many questions are there on this exam? I mean, total. And then I assume you select a certain number for the test, maybe 300 total questions are routinely asked, but the test only has X number. Could you answer that for me, please?
I'm not in the testing department. I don't have the specifics. I do know there is a larger bank of questions, and randomly those questions that are given are they're displayed on the exam.
But it's not an inordinate amount. I mean, 200-300.
I think it's only about 100.
Yeah, thank you. I had no.
And it only needs 75% to pass.
So, that being the case, somebody
not 100%.
So somebody would have to learn a pattern of 100 questions.
Well, again, the pattern on the practice materials would not match what was on the exam.
But close enough.
No.
So they're completely different from the sample exam?
The subject matter is the same. Both the wording of the questions and the wording of the answers is different. So while the subject matter dealing with infections is going to be the same, the way the question is worded on the exam and the way the answers are worded is completely different from what would be in practice materials.
Completely, 100% different.
They would have to be, otherwise the test would be invalid because then the answers would already be out in the public.
So how do these folks study for this?
Well, you study the material. You don't memorize which answer goes with which question.
But you did say there are horn books and...
Yes, so that you can, once you've studied, and that's the expectation, is that you've graduated from a school where you taught the material, and then you practice testing with these practice questions to make sure that you actually understand the questions so that, because on a practice, if you're not able to pass a practice test, you would want to study more so that you can pass the actual test.
I'm just trying to relate my law school experience with the certain ones are.
That's why he has to go to school, and when he is in school, they give him all these pamphlets, study guides, and all that. He has those if he went to school. If he didn't go to school, then he wouldn't have them.
But they would be similar.
But every state is the same question.
Oh.
Every single state. It's pretty much the same subject: sanitation, disinfectant, safety. It's all the same in all the states.
Okay, one more last question. And another thing too, Mr. Tran, I'm sure you probably memorized it because a lot of the written exam is procedure. So you've actually was practicing practicing your craft or your technology for many of years. So when you went to apply for your exam, even if it was something that you didn't quite really understand, you pretty much knew the procedure to it. Am I correct? Like the procedure, like the steps. You know how you know the steps to a manicure. You know the steps to safety if you get a blood spill. You know the steps to acrylic nails, right?
Yes.
So that written exam, a lot of it is procedure. Wouldn't you agree? When you took that exam, a lot of those questions they asked you, wasn't it procedure? Wasn't it the steps?
Because that's what I tell you when I learning for all the question in cosmetology in Nevada. I tell my friend help me, and which one the good one, close to the answer. So that one I try to learn look like the question, and I learned that the question answer, but that's it. Something when I go test, I confuse. I just pass. Some question I remember I mad first, and all the question left, so I just confused. I just A or B, C. If I fail, so all the question like that, and maybe I change because I don't know which one I answer the right one. I'm not the perfect one, so that one, some question I know that, so I answer first, and some question I don't know, I just keep, and after that I answer later.
Oh, go right ahead, Ms. No, I just was going to ask if are you done? Okay. So if you had any final question,
I just have a couple
please.
Mr. Tran, are you working right now in a salon?
Before I work, but after that I feel so.
So you're not
bad
working
I'm not
right now?
Work, and after that I get the letter from the board, somebody.
So you're not working right now at all? Where were you working before?
I worked before in Summerlin.
What's the name of the salon? Or can I ask that?
No, you can.
Oh, yeah, where did you work before? What's the name of the salon that you worked before?
I work in a salon, Secret Nail.
In where, Summerlin?
Yeah.
Do you still have your license right now?
I have, but I left at home. I'm not working.
But it's active, right? Still active? It's not revoked or anything? Okay, that's it. Thank you.
Can I ask one more question? Are you current on your child support right now?
Yes, ma'am.
So you're not working right now?
I'm not work, but I just spoke on. I just wait for the case for all your for me the license back to work. So.
But you do have a current license where you could be working right now.
Because my license expires
right
for the end of this year.
It expires on the January 4th, I believe it was.
December.
What is it?
December.
December of, okay, of 2016. So, are you currently looking for a job to work?
Because I just wait for the finish. You allow for us, the license back to work.
So
and I have the money. I just spoke for my son.
So you hired your attorney. I'm just saying, you hired your attorney to defend you.
I need to clarify this.
Okay.
Mr. Tran and I have a relationship of about 2.5 years. I've taken care of a couple of tickets for him. He came to me last week and says, "Hey, I got this problem. Help me." Have I been paid? No. But more importantly, it's a struggle. I think the question was asked, why doesn't he hire a Vietnamese attorney? not too many in this town, okay, that do this, anything related to something like this. So based on our personal relationship, he goes, hey, can you do me a solid? It was kind of along that line.
Is
Well-
he current in his child support payments?
I would have no idea. Yeah, you could ask DAFS.
He said yes, but how,
Are you concerned that he may not be current? in his-
Actually, no, because that would be taken by DSA. I used to work for the DA Family Support Unit. The way that would work is that he would be summoned to a hearing in order to show cause. If, I don't know who mom is here.
well,
or
where
how many
I was
children.
going with this is that if he's going to pay $2,500, correct? Is that what is it? What is the
I don't think we're there yet.
$2,000 per offense, and whether he's paying you or not. My thing is that if he doesn't have a job and, he does have kids somewhere that they need to eat.
Oh, I
So
agree.
I'm just-
I don't know. I truly don't. I can tell you how it works because I used to work for family support for the DA. More likely than not, I would be recommending
But
to
he
him
did-
that he
he
do
did-
a
he
modification.
I object again. I don't know why the child support issue is
Well,
coming up.
I'm
It's not
too-
relevant.
I understand
wanted
that,
to
but
be rude,
moving,
but I didn't
I
understand.
understand that too, but moving forward, we can all agree to disagree, because that's what we're here for. But looking to the future, he loves what he does, whether I disagree or not. I clearly believe that you knew what you were doing. And I'm just looking at long-term about his family and being able to work again, that's all.
So, are there any closing comments?
Have a moment, please.
Please. And is anybody interested in breaking for lunch, or do we want to finish this matter?
We need a break.
Okay.
I need a break.
You need a little break, or can you go another 10 minutes?
This may answer your question a little bit as far as the child support concern.
Actually,
No worries. Okay, here's an active art case, so that the DFS is on it. An art case is a child support collection case. When you can either domesticate a child support order from another state, and or mom can actually come here and say, hey, this is his kid. Or you can fess up to it. There are various ways of establishing paternity. Once that is done, depending on what jurisdiction mom and child is in, they make a determination. Is he dad? Isn't he? And then according to the state and their regulations, they determine what an appropriate amount of child support is. It appears that it's been domesticated because he goes to Flamingo and, Spencer, which is a DA family support court. So basically, he pays a caseworker there, and they keep track. So, there isn't this squirrely thing where people are having receipts all over the place.
And I'm going to object to the board continuing to ask about child support because there's no allegations in the complaint about child support. So I'd ask that you try really hard to stick to the complaint and notice of hearing that's been filed with the board and the allegations we've brought.
But Ms.
If we need
Bradley-
to bring that, we will bring that in the future, but that's
Ms.
not today.
Bradley, you said very clearly that if the child support payments were in arrears, we wouldn't have been able to issue the license.
But that's not before you today, and I'd like you to stick to what's before you today. So I'm objecting and I'm asking that all references to the child support not be considered and that we move off from that topic because it's not before you and you shouldn't be thinking or deciding it.
My interjection to that is you opened the door on it. I don't know how much factor it's going to have one way or the other with the board. to
I
be
didn't
quite
open the
candid.
door on it, they did, and I'm asking them to not.
Well, it was put in our packets, I'm sorry.
It's part of the application, yes, for licensure.
And I'm new, so,
But how do we make the decision at the end if we allow the respondent to keep a license, but then they're in arrears in their child support? I thought we shouldn't have issued the license in the first place.
Child support's not before you today, so please, let's move on to something else.
Okay, well, it's confusing, Ms. Bradley. When you're asking for us to take a look at someone's application who seemingly has made fraudulent claims, it's very confusing to us to isolate out only some of them and not others. So I think that that's why there's some confusion. So perhaps that should have been in the complaint. Any other questions or comments or concerns? Closing arguments.
We would submit that the allegations as contained in the complaint notice of hearing have been proven. Specifically, that Mr. Tran applied for licensure in 2012, was granted a license in 2012, which was well after both a revocation and a criminal proceeding that had been pending against him. To answers regarding questions on the application, he said no, that he'd not been a defendant in an administrative proceeding, which of course the Virginia board proceeding was, and so that was an incorrect, untrue answer. Also, when answering, have you ever been charged, arrested, or convicted of a misdemeanor, gross misdemeanor, or felony? He answered no, and again, the two charges both were criminal cases, they were misdemeanors, and so he should have answered yes. That was untrue and incorrect. When signing his application, he asserted that he was of good moral character and temperate habits. That's contained right on the application, and we would submit that that has been proven. He asserted that he would not obtain practice in cosmetology by fraudulent misrepresentation, and we would submit that, again, providing untrue, incorrect statements to the board in the application is fraudulent misrepresentation. He signed and swore before a notary that he had read the application in the entirety and that he knows the contents thereof, and all statements are true in every aspect. That's why we have a notary sign the application. We want a person to, number one, show their ID to somebody, prove who they are, that they are signing it, and that they are saying everything is true. And so he did that, and he's telling you today that he gave you incorrect information because he didn't understand. We would submit that, again, he used that same argument in Virginia. They didn't find it persuasive, and we would ask that you not find that persuasive either. He said, when asked by Ms. Tran, he said that he had taken English exams both in Massachusetts and Virginia. He was licensed in both of those states. We have information and records that show us that he took the English exam in Nevada. He got a score of 84, which most, I think, if you only speak English and you take it in English, I think most people are pretty happy to score 84. It's well above the passing score. And so, again, that's a pretty high score for someone who doesn't understand. Maybe he did take it 2 other times, but I know we have a lot of English speakers who take it more than once as well. So, to me, scoring 84 is pretty darn good. I don't think I could take any exam in Vietnamese and pass at all. So, obviously, you have to have some understanding. He also lost his license in Virginia, and I guess what concerns me is, number one, he didn't give you true information, and he already lost his license previously for the same kind of conduct. In other words, not being truthful, not telling the board the conduct. So it would seem to me that a person would be more careful perhaps in another state, and maybe if they really truly were not understanding, they would provide correct information. He requested Vietnamese, but again, we have a clear record that he took it in English. What else is very concerning to the state, and one of the reasons we wanted to bring this case, not only was the information provided untrue and incorrect, and as was testified, had it been provided correct information, it would have been looked at. It may not have been an automatic denial, but in this case, I think it would have been, given the conduct. I mean, the underlying conduct is that 2 underage girls were receiving manicures, and both were sexually assaulted by Mr. Tran. That's concerning. It's directly related to the practice of nail technology. It's the board's here to protect the public. This is not something we want to ever have occur in a salon. And so the fact that even though these are 15-year-old convictions, what's concerning is you have 2 with very similar fact patterns, both under 16, both getting a manicure, and both grabbed in their chest area. You know, it's just not okay. And even if it was 15 years ago, the concern the state has is, and I think the Virginia board order even identifies that, they had some concerns that there could have been more instances that were not reported. We don't know that, but certainly having more than one of the same kind of allegation makes you concerned. And again, in Nevada, you know, yes, there's no complaints today, but this is just serious and directly related to the profession. So that's why we're so concerned. We would also say that, remind the board that our burden of proof is not, this isn't a criminal case. The burden of proof is we have a preponderance of the evidence. We have to show that it's more likely than not 4951 that he was incorrect and untrue in his application. I think we've proven that. I think we've more than proven that. I mean, the facts speak for themselves, both the order in Virginia and the application the way it was marked. I believe he's trying to say he didn't understand, but again, I think we have more likely than not evidence presented that he did understand. And I would also remind the board, it doesn't actually say you have to knowingly give incorrect information. This isn't a criminal statute where it has to be like willful or intentional. He gave incorrect information, period. Why he did that maybe is a question for another day for a different kind of proceeding. But he gave incorrect information. He answered these questions untruthfully. He signed the application. He said it was true. He then proceeded to work in Nevada and just didn't tell the board. And again, if your license had been taken in another state, I think that you would be more careful. And as was pointed out in testimony, he came here in 1994. And I'm not saying that you have to have perfect English, but that's 22 years ago. And I would hope that living somewhere for 22 years, you at least have some understanding. And again, if you take licensing exams in 3 states and pass and are licensed in all 3 states, to me that shows that you may know more English than you are appearing to know, at least today. So we would submit that all of the allegations and both the facts and the violations of law have been proven. We believe we've met our burden of preponderance of evidence, and we would ask that the board find that facts 1 through 35 have been proven, and violations of law, the 5 violations listed in the complaint, have also been proven. Thank you.
Mr. Garcia.
No, looking back at today, one of the first things that strikes me is that I've known Tran for about 2.5 years. This is the best English I've ever heard him speak at this point. I think a question was asked of me, how did I become involved? That's why I handled a couple of tickets for him. Tickets. Little citations, not big deals. I've had to explain to him over and over how it works, how it has to be done. You yourselves today ask questions. I asked him to read parts of the questions of the application. He stumbled, he stammered. His grasp of what was being asked of him is questionable at best. That he's been here 22 years and maybe doesn't master the language very well. My grandma was here almost 75 years, and I could list down on one page how much English she spoke. That doesn't mean that she was a contributing member to society or a bad person. Sometimes people become insular in who they hang out with, and it does affect, personally I think it affects her ability to assimilate to society. I know in the nail profession there tends to be a lot of folks from Vietnam, Indochina area. And what I heard from Mr. Tran was these folks tutor and coach each other. There doesn't seem to be that many questions that you really have to master. You learn the pattern. This is done in bar exams. You kind of go, okay, I kind of know what they want. A is not, definitely not right. B is not right, so it's down to C and D. I would have been very interested to see what it would be if it was an extreme, it was a written out answer as opposed to just check a box. Also, again, going to the language issue, you folks asked him questions, and I could see it in your faces you were frustrated because he would start to wander off. You want point A, and he's starting on point C, D, and beyond. This application, he did in 2012, this is 4 years ago, and the one in Virginia, even more so. Like I said, this is the best English I've heard personally heard the man speak, and you could tell he was lost. The man was lost. When an issue was raised, well, you got 84, what percentage was it? 84% out of the test. You're dealing with questions that are limited in nature. You can learn the patterns. And he still had to take it 3 times here. And it appears he had to take it several times when we're talking about Virginia and Massachusetts. There cannot be that many questions as it relates to this profession. You pick it up, you learn it. regarding moral character, and also I would like you to take into account that, yes, he is trying to start his life again. He hasn't been in any kind of trouble of this sort since 2001. Well, like I said, the only reason he knows me is through tickets. As I heard Mr. Commissioner testify, there are no complaints against him here in Nevada. So these whole concerns that you're protecting the public, something may happen, he's gone on 4+ years here without any such incident. It seems like no incident of any sort. And it's true that the that the measure or the standard of evidence preponderance of the evidence. I think there's more than enough to show that there is gray area here as to what this gentleman understood and did not understand. As far as these questions were concerned, you folks asked him yourself to read them, and let's face it, he got lost. He got lost. So you can only imagine what it was 4 years ago when he was answering these questions. Furthermore, I understand that the state has a concern here, and you folks may too. It's my understanding under the remedies by NRS 644-430, you folks have a certain amount of discretion involved here. Should you choose not to immediately just directly reinstate his license or whatever he needs to do to be able to earn a living, perhaps we could also look at some more along the lines of some kind of probationary license where he is supervised, if that is a concern of the state, that somehow he is doing something nefarious in Nevada. Again, he's been here over 4 years with this license, nothing. I think the man should have a chance to redeem himself. That's what he's trying to do. And I think the language barrier is painfully obvious. Painfully obvious. He gets lost. And the questions you asked, anytime you asked him to recite or read off these forms, he got lost. So I don't think it was willful type of obfuscation or any kind of thing of that nature. And just because somebody answers wrong should not disqualify them immediately from being able to earn a living, especially when they have a 4-year record in this state and not a complaint. Thank you.
Thank you. Any questions or comments to either Ms. Bradley or to Mr. Garcia?
Don't ask questions, you deliberate.
Okay. So how about just amongst ourselves? Anybody have any concerns or any questions? I guess the thing that I'm concerned about just personally is, you know, you've got a situation where we're being given facts that happened ago, making the presumption that there's going to be crime in the future. It's like I'm just not quite sure I'm in line with that. I mean, it seems kind of obvious to me that when he moved to Nevada, he went through that application and checked those boxes no, so he could get to work a little bit sooner. I don't know if he was being deliberately criminal in making false claims, but I think he was just thinking that if he answered him in the affirmative, then I think he'd get an automatic denial for his application.
I agree with that, but he still did choose.
Yeah.
So that's a challenge.
I also want to know, how are you reading the instructions for the disinfecting solutions? I mean, that's a real problem for me, that if you're not having a sincere grasp of the English on some questionnaires, how are you grasping warning labels on disinfecting products?
I think my, excuse me, I think my concern is more on the line of, I think Mr. Tran knew that the difference between yes and no, but I also think that he probably said no because he wants a license to work. I'm not sure if we could do this, but maybe we can think about some type of, because you still would have been licensed, I'm sure, with some type of a stipulation if you would have answered yes. You know, the executive director has that right to, I'm sure, make some decisions. But we have to make sure that we're putting out, what we're doing today is setting some type of an example. And we have to be able to put out that they have to be truthful when filling out an application. When a student comes in, a potential student comes into our school, and they sit with me and say, I've done this, X, Y, and Z, and I say yes, and you write a letter to the board. You write a letter explaining what you've done, and things have changed. It was a while back, but then the attentions now is like you said no when you got licensed here in Nevada, when you could have said yes.
I agree with you, Ms. Bramo. It's like it sends the wrong message for us to say, oh, well, you know, I know that you were trying to be truthful, but it really does send a very poor message for us to be able to take a look at your application knowing that you had a chance to right a wrong. And you actually had that several times over the course of the 1999. So, gosh, 16 years, 17 years. It's a long time for you to be able to make some choices that didn't let this follow you any longer. And I really worry that if we allow our applications to have misrepresentations on them and then we make exceptions to that, that just is completely sending the wrong message as far as I'm concerned.
So is there any way today we could maybe possibly, we know that there was some fraudulent claims.
I'm going to interrupt you. At this point in your deliberations, I'm afraid you're trying to skip ahead. What you need to be concerned with were the factual allegations as stated in the complaint proven, as well as the claims for relief, which are the violations of law. Have those been proven? You're not to be thinking about penalty phases at this point.
Excuse me, but that would be an element eventually, would it not? They do have the discretion, even if they find there is some violations. If they do,
if they find a violation, then they will come back and discuss penalty. I just don't want them to skip ahead. You can't assume.
And that's why the proposal we made is some kind of probation with supervision kind of thing.
Nobody other than the board and their board counsel can speak during deliberations.
Have all the board members been able to look through 1 through 35 of the factual allegations? Did any of the board members in those 1 through 35 see anything or read anything that seemed inaccurate? Does anybody have any comment as to the accuracy of the factual allegations? Okay, well then I'm happy to accept a motion to either reject or accept the factual allegations 1 through 35 in this case number CA 2016-012. Is there a motion?
I'll make a motion that we find the facts 1 through 35 that they have been proven, and I don't know if there's anything else to that.
Well, that's
I
fine.
second that motion.
So there has been a motion by Ms. Bonaldi and seconded by Ms. Ritchie that the factual allegations have been proven. Are there any questions or comments or concerns? All those in favor, please say aye.
Aye.
Any opposed? That motion carries. Let the official record show that the factual allegations 1 through 35 have been proven. If we take a look at the violations of the law, we want to match violations of the law with the corresponding factual allegations. There are five claims for relief. We can address those individually, and that's the preference of council, is to address those individually.
You can address them individually, or if someone is ready to make a motion on all 5, it's really up to the board.
Okay. So in the in the claims for relief, the violations of the law, I'm happy to accept a motion that the violations of the law have in fact been proven.
Or not proven.
Or not, yeah, or not. And if they're not, then perhaps we'll then isolate them. So in the first claim for relief, there is the violation of NRS 644-210. In the second claim for relief, there's fraudulent misrepresentation allegation of violation NRS 644.431B. In that third claim of relief, the violation is 644.431C. And in that fourth claim of relief, the violation is NRS 644.431K. And finally, in the fifth violation, I'm sorry, perhaps I don't know what is being alleged as the violation for the fifth claim of relief. Would you be able to please answer that, Ms. Bradley?
At this point, you take the claim for relief as it's been written. It appears that it's tied to NRS 622.080.
Is that, do we govern that particular NRS? I mean, is that relevant to our
Yes.
decision-making today?
Yes.
It is? And are we able to read that? Can we Google that? I mean,
Sure.
does anybody know it off the top of your head? Do the board members who are going to make a vote know what that says? So, yeah, so we would need to read it if you were going to find that violation to be in fact true and correct. Ms. Bradley, you could just read it into record for us.
I think it's on the application too, right?
NRS 622.080 states, in regulating an occupation or profession pursuant to this title, each regulatory body shall carry out and enforce the provisions of this title for the protection and benefit of the public.
And we're saying that that's been violated?
She is saying that by providing false or untrue information in his licensing application and or by failing to disclose his past criminal history and or administrative discipline by the VA board and or by his pattern of criminal activity while performing nail technology services, respondent is a danger to the public as contemplated by NRS 622.080, and the board should discipline respondent in order to protect the public.
Has everybody had the opportunity to take a look at those NRS, or does anybody have a question or concern about them?
I have a question. That particular NRS, is it on our application? That they have to be truthful or they could be,
I think it's a minimal requirement by law stated in our books that they have to have, be of good moral character.
And then what is the NRS 425520? That just happens to be some, what is that? What is that NRS?
Where is it?
It's 425.520. Is this right here on this application?
Exhibit 2. Virginia or Massachusetts?
Oh, it looks like it's an NRS, it says. It's on his application, page 12.
Regarding the child support information.
Oh, right, that's missing.
On the bottom of the application.
Is there a reason why that's missing from the complaint?
This is not the time to
Oh,
question
okay.
what is or is not included in the complaint. You are limited to what has been alleged in the complaint.
All right.
And that is what you must base your decision on.
Okay.
And we're still deliberating at this point? Is that correct?
Or we can
Catherine?
accept a motion to accept each of the violations of the law as true and accurate?
Or not.
Well, it's hard to base your fact-finding information based on the information we have, for me personally, because, so I have to have a minute to really read through these, because I feel that he's definitely, in my opinion, guilty of these things. However, I could understand why he did it, but that doesn't make, just because you understand why somebody does it, doesn't make them not guilty. So, before we take away somebody's ability to make a living, I think it should be seriously considered.
And again, you're presupposing what the penalty would be. Do not do that. You're at this point in deliberations, you are really looking at have the 5 claims for relief been proven or not proven.
I do apologize. I need to contact the deputy city attorney. I have a hearing at 2 o'clock. I can get that continued. That's okay. I
You
just
can
need to
make the
step on
call
momentarily.
from right there if you'd like.
Okay,
What I'd like to say is that on that first violation of the law, it's very, very, very straightforward. In NRS 644.210, which is that first claim for relief, it says the application must be verified by the oath of the applicant. Well, even in this hearing today, we make our own inspection staff and compliance officers take an oath, even though we know that they're being truthful. They've already filled out paperwork. So here's a situation where somebody is checking on number 4. On your factual allegations, you have 4, 5, 6, and I thought that there was another one. Well, there's at least 4, and then this child support, that's the 4th one. There's at least 4 situations where he's not being honest. So right from the very get-go, you can see that that violation of the law is in fact true and accurate based on these factual allegations that we've already seen. When you take a look at the violation of NRS 430, the 1B, it's obtaining by fraudulent misrepresentation. The gentleman knew that he had the opportunity to say yes, despite the fact that it may open the doors for further discussion whether or not he could be licensed in Nevada. It's not an indicator that he would not have received his license. I just think he felt vulnerable by knowing that he needed to earn a living. However, it would have been best to be upfront. Consequently, that second claim for relief is very accurate. We can't have people filling out our forms incorrectly. It doesn't look good for us to allow that. Finally, in the 1C, it's gross malpractice. Well, the gross malpractice may have been his prior behaviors as a licensee in other states, but perhaps giving untrue information is an indicator of gross malpractice because he had the responsibility to inform us that the public may be in danger if he were to be licensed. So perhaps gross malpractice, I don't personally see that as gross malpractice. I see that as filling out your form in error. Purposefully in error. So perhaps that's gross malpractice, since you're doing it purposefully. Finally, on number K, which is the fourth claim, you can take a look at your factual allegations again. It's unfair or unjust practice, which may justify the action. And I just think you're taking a look at numbers 18 and 19 and 20. You're taking a look at 21 and 22 and 23 and 24 and 25. There's actually multiple numbers, 23 and 24. So when we look at the factual allegations, there's actually going to be 37 factual allegations, and we've only found 35 to be accurate. And that's because there's two 23s and 24s, so the numbering system is a little off. However, that being the case, and we've already voted on them, you can just see this pattern of unfair practice. You can't be treating your clientels as victims. It's just horrific. It did not occur in our state, but again, I think it was meant to be concealed. And then finally, I don't know anything about this NRS 622. I'm not a proponent about taking a look at that. I mean, I get it that they're a danger to the public, but these other, it doesn't make any sense to me. I don't know why we're looking at that one. Anybody else have any questions or comments based on those? Does that help? Yeah.
I think moving forward, to look at this long term, he wants to work, he has bills to pay. Yeah, I know. But I just want to say that, and everybody in agreement, that, yeah, we all agree. We're all basically looking at him, and I think he knows that he did that, but he needed to work. But the problem is, and I believe in a society that likes to help people come back into society. I'm not judging him in any way, shape, or form, but it is wrong what he did. But there needs to be, I mean, there's a lot of a list here of things that are coming in pursuit to follow what we are suggesting, correct?
Yeah, I mean, the process will be is for us to go ahead and find, we have to make a motion to find the violations of the law true and accurate.
Yeah.
And then
Or
we'll
not.
have to impose.
Not.
We'll
Or
have
not.
to, or not.
Can we go back to the factual allegations, though? You made a motion that 1 through 35 are proven, but as you just noted, there was an error in the numbering. So really, if they were renumbered, it's 1 through 37. And I think the record, if you're going to find 1 through 37 proven, should be reflected. And I appreciate that you found that error. I just want to make sure we're clear,
Okay.
because when we draft an order, I have to.
Okay, I'll step back to that, but I do want to address Ms. Ritchie's concerns. And again, I don't want to jump ahead, but I can certainly, I'd like to make the request that we get a new application that's filled out properly, regardless of how this whole mess turns out. So let's come back to Ms. Bradley's concern, Ms. Ritchie, and we did take a vote to find the factual allegations 1 through 35, when in fact it's 1 through 37. And so I'm just going to ask if we could please have the person who made the motion to find the factual allegations true and accurate.
Before you do that, this is Rosemary, why don't you actually renumber these allegations where perhaps you
So I would like to just renumber on page 3, lines 14 and 15, making those 36 and 37. All the other numbers will remain the same. Is everybody good with that?
To go back to where they were misnumbered, so on page 3, number 23, 24, and then the new 25 will be respondent asked the victim how old she was.
So they have to be
26
consecutive? You can't just throw them in at the end? I just want to throw them in at the end. So you can take the first two, 23 and 24, and just make them 36 and 37.
I think it's better if we just renumber them so that it flows correctly. And I would also remind the board that the staff believes and therefore alleges. When you find those true, you're finding that those are true statements. And so in an order, they get reworded to say these incidents are, instead of staff believes and therefore alleges. It's brought to you as an allegation. If you find it as true, that then
Right.
becomes a true fact.
That's fine. So I'll just give you a heads up. So line 1423, line 1524, line 17 is 25, line 1926, line 2127, line 2328, line 2529, line 2630, page 4, line 131, line 332, line 633, line 934, line 1135, line 1336, and line 1537. Any questions or concerns about those factual allegations? Is there a motion to accept them as true and accurate, or proven, rather,
As renumbered.
as renumbered? We've already made this motion, so it should be easy.
I'll make a motion to find these factual allegations 1 through 37 renumbered to be true and proven true.
Thank you. Is there a second?
I'll second that.
motion.
And any questions or comments or concerns? All those in favor, please say aye. Aye.
Aye.
Any nays? Let the official record show that the factual allegations have been renumbered and reproven and revoted on and passed. Going back to the violations of the law, is there any other question or comment or a motion to find the violations of the law true and accurate or not?
Apologies, are you going to be doing this individually, each one, or in bulk?
Doesn't seem like we're going to do it. It sounds like we're going to do roll all 5 into one, seemingly.
Rather be done one at a time, but
Do you prefer them separated individually? Okay. Any motion to find the violations of the law proven true and accurate or not? Motion.
I'll make a motion that we find the violation of NRS 644210 true.
Okay, and your first claim of relief, thank you. And you're going to address them individually, or are you going to continue? Just the one? Okay. Is there, just a moment. Is there a second to Ms. Benaldi's motion for first claim of relief?
I'll second.
Thank you. So it was made by Ms. Benaldi and seconded by Ms. Bramo. Any questions, comments, or concerns? All those in favor, please say aye.
Aye.
Any opposed? Let the official record show that the first claim for relief, the violation of the law, has been proven. Second,
I'll make a motion to find the second claim of relief true, which is a violation of NRS 644-4301B.
and that's the fraudulent misrepresentation for obtaining the practice of cosmetology. Any second to that motion?
I'll second that motion.
And so the motion was made by Ms. Benaldi and seconded by Ms. Ritchie. Any questions, comments, or concerns? All those in favor, please say aye.
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 Any opposed? Let the official record show that the second claim for relief, the violation of the law, has been proven true and accurate. The third claim for relief, is there a motion whether or not false or untrue information on the application or disclosing of the criminal history constitutes gross malpractice or not? Is there a motion to that effect?
I'm going to make a motion that we find this third claim for relief, I think the NRS 644-4301C, to be untrue.
Is there a second?
I'll second that motion.
Is there any question, comment, or concern? All those in favor, please say aye.
Aye.
Any opposed? Nay. Just one nay? So let the official record show that the third claim for relief, the violation of the law, has not been proven and will not move forward. Finally, or not finally, next, fourth claim for relief. Is there a motion to find that the respondent engaged in unfair or unjust practice violating NRS 644.431K?
NRS 644.430,
1K.
1K. Deny. Or how do I mean to say it?
Yeah.
It's,
Is that-
I believe we've proven this, yes.
You
True,
have.
true.
So you've made your motion. Is there a
Yes.
second?
I'll second.
Is there any question, comment, or concerns? And so to reiterate that, Ms. Ritchie, that the fourth claim for relief, that violation of the law, is true and accurate. Yes. Seconded by Ms. Bramo. All those in favor, please say aye.
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 Any opposed? That motion carries. Let the official record show that the violation of the law has occurred for NRS 644.431K. Finally, in that fifth claim for relief, in the violation of the law of NRS 622.080, is there a motion to the effect that by providing those false or untrue information that the respondent is a danger to the public in Nevada or in the public in general?
I know I'd like to make a motion, NRS 622080, to be false.
Is there a second?
I'll second.
Is there any question or comment or concern? My only concern is that we've not encountered this to my recollection, and I'm just reluctant to have this NRS being made as part of our decision when I didn't really have access to that in the beginning is all. So perhaps in the future, if that's going to be part of our violations of the law, we should have some training on that particular NRS code.
I don't think we found this, and this is my understanding of this particular fifth claim for relief. I don't think we've had any trouble with Mr. Tran since he's been here, and there's been no reports. This is something that's happened way in his past.
It
Or
did
fourth, I'm sorry.
not appear that we had any reports out of Massachusetts either, which was a subsequent licensing after Virginia also.
I believe it's been 4 years, am I correct? That he's been licensed in the state of Nevada?
Well,
Is that correct?
not every victim reports either, so
But I think it's about failing to disclose.
failing to disclose. Any other questions, comments, or concerns? All those in favor, please say aye.
Aye.
Any opposed? Did you say nay? Yes. Okay. So there is one nay, Ms. Tran. However, just the majority rules for the fifth claim for release, that violation of the law has not been proven. So we do only have the first, second, and fourth. Is that correct? All of you that were following along, taking notes? Okay. So we entered, please.
Oh, I'm sorry. I wanted
I
to
can-
say that I agree with the fifth claim for relief. I agree that Mr. Tran did not disclose. So I should have said true, right? I want to change it. I wanted to say
your
nay.
single vote isn't going to change the
Okay.
decision, though, unless there were some other misunderstandings in the vote. So
Let me clarify, because I want to make sure also. We are saying that on the fifth claim of relief, NRS 622.08, by providing false or untrue information in the licensing application and/or by failing to disclose, we agree to that. Administrative discipline by pattern of criminal activity while performing nail technology services. Respondent is a danger to the public, as this is what I'm having a hard time with. There's two issues here. I think that's what we're all having an issue with on this one.
Well, we voted that the respondent, if he were to be licensed or keep his license in Nevada, that his criminal behavior is so far in the past that he may not be a danger to the public?
No, that's not what's going on here.
We could have the record read back to us. That's what my understanding of the vote was.
Did find that one not proven. The note that I have, it was 5 in favor of not being proven, 1 against. It sounds like Ms. Bramo would change it to 4 in favor of it not being proven and 2 against.
So then now it sounds like we have 3. Because
So
he
I-
is-
I'm not going to clarify the 2.
So, but both of you are saying is that in failing to disclose properly on his application, he is a danger to the public?
Yes.
Okay, so we should,
Failure to, right.
so do we make a vote to throw out that last
I think what
one?
you need to do is do a new vote and have everybody raise their hands so that Mr. Nelson can get an accurate vote in the record, and then you'll decide what to do.
Okay, so let the official record show that we are taking a second vote. Do we have to cancel the first vote in some capacity?
Well, I'm not a lawyer, but I just want to say one thing here. When I'm reading this, when it gets to respondent is a danger to the public, can we read NRS 622.080? Can you, one more time, please. I would appreciate it. Thank you.
It sort of says exactly what's written, which is a pattern of criminal behavior. It makes them, by not disclosing his past criminal history and or administrative discipline, he has a pattern of criminal behavior, and that makes him a danger.
Past tense or current? That seems to be ambiguous.
It's just past behaviors.
Okay, but the way it's put is as though he is now or will be in the future. It sounds ambiguous to me. It truly does.
Okay.
You ready? Here's 622.080 again. In regulating an occupation or profession pursuant to this title, each regulatory body shall carry out and enforce the provisions of this title for the protection and benefit of the public. That is NRS 622.080.
That you've all had the chance to hear that, and we are going to take a revote. Ms. Reynolds, I had asked if there was a formal procedure for retracting our prior vote, or do we just say that we're doing it?
Why don't you have, I'm not sure the reason for having a revote.
I think that there was some confusion for 2 of the members when they voted that they did not like their decision. So how about if I do this to speed it along? How about if I just ask for a motion to ask for a revote on the 5th claim for relief violation of the law? Is there a motion to that effect? Is there a motion to have a revote?
I motion that.
Okay.
I second that.
And so, is there any question, comments, or concerns? All those in favor of revoting for that 5th claim for relief in the violation of the law, please say aye.
Aye.
Any opposed? Nay. Let the official record show that we are going to throw out that prior vote. Is there a motion for the 5th claim for relief for the finding the violation of the law true and accurate?
I make a motion to find the violation NRS 622.080 true.
Is there a second?
I second that.
Is there any question, comment, or concern?
To be clear,
Yes.
you are stating that the 5th claim for relief, as stated in the complaint, is proven.
That is correct. And so when we compare those to the factual allegations, we want to make sure that by failing to disclose past history in their factual allegations number 4, 5, and 6 perhaps makes the respondent a danger to the public. We also want to point out that in factual allegations 19, 20, 21, 22, 23, 24, 25, 26, 27, that makes the respondent a danger to the public based on those factual allegations.
Pardon me, are you going on a maybe or is? Because it sounds very ambiguous.
Tell me again.
Is that a maybe? He is a danger to the society, or is?
They haven't decided yet. They're talking about voting on it, and he's saying those are the facts that would support that if they make that
Sounds
finding.
very ambiguous. It's just like we've already had a couple of votes on this. I think we're all trying to struggle through
the
this one.
actual violation of the law says that the respondent is a danger to the public. So if I said may be a danger to the public, I'm clarifying that to quote the fifth claim for relief, that the respondent is a danger to the public. Finally, your factual allegations that support the fifth claim for relief is that items number 36, factual allegation 36, and also factual allegation 33, and factual allegation number 35, which is an amended 35, by the way. It appears to be 33. So to try to match up those factual allegations to that violation of the law, that's how those would roughly match up for me. Any questions, comments, or concerns? There is a motion on the table. All those in favor, please say aye.
Aye.
Any opposed?
Nay.
Nay. And so the two nays are Ms. Bonaldi and Mr. Leader, but the majority rules. So that fifth claim for relief, that violation of the law has been proven. And now we move on to the disciplinary stage. So is there a recommended disciplinary action?
Yes, the staff does have a recommendation. As the board may recall, you found factual allegation 35 true, which means that you found that the respondent is not of good moral character, which is required for licensure. Board staff would request that Mr. Tran's license be revoked pursuant to NRS 622A.410 sub 1. We would ask that the revocation be for 5 years. What that means is after 5 years, he can reapply for licensure. Just to remind the board, it's a minimum of 1 year for revocation, a maximum of 10. So we're picking a middle spot of 5 years. So we would ask that that revocation be done. We would also ask for a fine of $800 per violation. There were 4 proven, so that would be a fine of $3,200. And then we would ask for costs pursuant to NRS 622-410 not to exceed $750. I don't have an exact tally, but I'm hoping $750 would cover the board's costs, at least from my office. So that would be our recommendation. I would also note for the board that the max fine you can charge is $2,000 per violation. So we are close to the halfway mark, a little bit less with regard to the fine, and then right exactly in the middle on the revocation, and then asking for the board's costs.
So we've all heard the recommendation. I just wanted to kind of ask is when do we stop penalizing somebody for a crime that they've committed? I mean, it seems like he's been punished once before by the state that punished him once before. So, I mean, like, how long do we continue punishing people?
As long as they continue to
I think
break the law.
Mr. Garcia has a comment. Normally, when I make a recommendation for discipline, the respondent gets to address it, and then the board decides.
So I'll address that concern in just a quick moment. I'm just asking the board, how long do we punish people for? I mean, are we teaching a lesson, or are we? So So you're saying that
It's
by
a-
not disclosing properly, that we're not perpetuating the punishment, he is himself. The respondent is perpetuating his own punishment by not turning it around and being truthful.
Correct.
Okay.
It's a sexual assault.
Yeah, I get it.
Okay, it's
For sure.
Pardon me. Yes, my understanding of the remedies section, NRS 644.3430, is that there is quite a bit of discretion folks can use. Well, the first point I did want to bring up, these are penalties that were done very close back to back and are over 15 years old. When does this guy stop being punished? I used to come across this a lot when I was a law clerk.
But you actually just heard the answer. And
Okay,
that
well,
is,
this is called shooting fish in a barrel day. Is what
no,
used to call
we
it a law
just
clerk.
asked that question and you just heard the answer, which is you have to continue to be honest and truthful on the application. The respondent has to himself stop the non-disclosure of important information.
Well, if I might pose this to you, though, there's a difference between being
Mr.
wrong and being
Garcia,
untruthful.
He
is
should
my
be
understanding.
addressing my recommended discipline, so we shouldn't be having a discussion. I recommended what I recommended. I think he wants to argue in mitigation, so there really shouldn't be a dialogue. He should tell you why what I said maybe is improper.
So you're asking for leniency.
I'm asking for certain forms of leniency. Yes, I'm not asking for him to go scot-free, by no means. However, it should be taken into account that part of your discretion is you can form some kind of probation and you monitor him. For 4 years he's been in this state, nary a complaint. I mean, when does it end? Truthfully, you heard him read those questions. He was stumbling and bumbling. He did not understand. There's a difference between being untruthful, which requires a certain element of at least trying to deceive somebody, and being wrong. If we're going by that standard, he was untruthful when he took the test because he only got 84%. He missed 16 questions. Now, was he wrong or was he untruthful? What I'm asking for is that he be allowed, under strict supervision, that's fine, but that he be allowed to earn a living, prove himself, which he has for 4 years plus. And yes, this man, when he deals with government agencies, he definitely needs somebody that speaks English, Vietnamese. Like I said, my relationship with him is about 2.5 years for tickets. And the battles I had, or just to have him wrap his brain around what he would have to do, was actually quite laborious. Glad to do it. He's my client. I want to make sure he does the right thing. But you could tell there's this thing, and I see it in immigrants sometimes. They'll say, yeah. They're looking at you. They're saying, yeah, but their eyes are saying, I don't really understand what you're telling me. And there's elements of this involved here. You guys saw it today when you had him read it, and you could tell that he was getting lost.
So did you have a recommendation?
Yes, I did.
Okay.
Mine's is some form of probationary licensure that he be checked on as the board sees a fair and a reasonable amount of time. I think you had mentioned probably reapplying with the correct application thing. I think that's legit. That's fair, is to have a good starting point at ground zero and move forward. I think any kind of revocation, I think considering the level of confusion the gentleman exhibited today on the questions you asked is excessive. 5 years, the man's not going to earn a living 5 years. This is what he's been doing since 99 or something, so it's like going on over 15, almost 20 years. As to the fines and fees, the man is allowed to try to defend himself. So piling on a whole bunch of other fines and fees on top of that is an I see in criminal cases too. And it's like, well, is he allowed to defend himself or not? And is this like additional punishment or not just because he defends himself? I think the probationary period, supervision, definitely has to check in with somebody or somebody check in with him, monitoring of his record to make sure that he is doing what he is supposed to be doing in the state of Nevada, both professionally and any other requirements you think he needs as far as moral characters and so forth would be a fair outcome. As you can tell, even you folks struggled with some of these.
Thank you. Mr. Landry, do we have a system in place to monitor licensees?
We do not.
Is that something that is in our budget?
It's not in the budget. What we do is we'd assign an inspector, and they would devote more time to that particular person and spend more time visiting that particular shop.
That's not considered targeting?
Nope. It's at the action of the board.
Questions, comments, or concerns?
I'd like to make a motion.
Please.
Just from all this, I really, I can see so many different directions this could go. However, he's wrong. We all know he's wrong. He has been here in the state of Nevada for 4 years, trying to make a living, but right now is not employed. It's just, I don't understand that. But my motion is to suspend your license for 1 year, assess a penalty of $2,000 per true accusation that we all voted on. That would be a total of $8,000. Supervised from Ms. Meschler annually. And finally, if you ever get a violation of any sort for past violations, that will revoke your license indefinitely.
I just have a correction. Legally, you cannot suspend for 1 year. You could do 364 days. A suspension can't be more than a year.
Thank you.
And you also cannot revoke someone's license indefinitely.
Can we put a limit of years on that then?
Yeah, well, you can't really,
'Cause I don't
you
know
have
about
to
legal.
wait until.
It would come back to the board at that time. But
Oh,
the law
okay.
says the max 10 years on a revocation, and it's a minimum of 1 year, and if it would be 364-day suspension,
Okay.
what you said.
Okay, thank
So
you.
I just wanted to reiterate the motion. There's a suspension of 364 days, the $2,000 penalty or $2,000 fine for the each of the claims of relief except number 4. Is that what I'm to understand? That number 4 was not found true? It was number 3. Pardon me. Thank you. And so that gives a total of $8,000. Mr. Mischler would be doing monthly monitoring. Did I hear that?
Annually.
Annually?
By Mr. Meschler.
You're talking about after the suspension, right?
Okay. And that no other violations can occur?
Correct.
And any costs?
No, she didn't say anything about costs, I don't think.
Oh, yeah, yes, I said he's going to have a penalty of $8,000
Well,
for
those are
times
the
he's-
those are the fines, but the costs, like
Oh.
for Sarah's time not to exceed 750 was her
I think the
recommendation.
violation of $8,000 is,
So the board is clear. Fines go to the general fund. So if you fine someone, you don't get any benefit yourself. It's a sanction. But if you take a cost, you actually get to put it back into your budget to help pay the bill that my office will
For
send you.
legal,
Okay.
legal services.
so 800 for each occurrence.
No, the
And
maximum is 750.
I thought it was 800.
Yeah, I think what Ms. Bradley is saying, though, is that we're not also want to return money back to the licensees for the costs associated to have Sarah here. So what she's saying is that the fines can go ahead and be the amount that you said, which was the 2,000.
Yes.
But then but the costs associated
And that's
to
fine.
the
I just didn't
hearing.
know where it was applied. Again, I'm new, I apologize. But I just wanted to know, I just thought that the funds would be for, I don't know how none of that works.
It doesn't matter.
I'm just trying to do the right thing, that's all.
Yeah. And so what would you like to make your motion regarding costs?
$8,000, how?
Costs.
Cost. Plus the. Correct.
$800 that
Plus
she said.
800.
Yeah,
Okay.
because I'm only 12 months.
Perfect. Okay. Is
Wait,
there a second?
I have a question.
There has to be a second first.
Oh, I'm sorry.
You can just second it and then ask your
Oh,
question.
I second it, sorry.
And then now ask your question.
Suspension on the license, meaning he can't work for the next 364 days?
He
is that what-
cannot work doing nails for 364 days.
Okay, so I thought it was a probation. It's
Just
not-
for nail, and that he can,
How would he pay for the fines if he's not working?
well, he's not working now, and that's why
That was my other question.
not
Was-
working now, so he can get a job
my-
somewhere. There's a lot of
that's my
jobs.
other question. Can I ask him a question? Can I ask Mr. Tran a question or no?
Please.
No, I can't. Okay.
Well, I have a couple of suggestions too. No, the motion's on the table, so we can talk about it. Is that correct?
Yeah, yes.
I think he needs to have an English as a second language course brought in. I'd like to see that adjusted. And I personally think we should monitor him versus for a complete year, 364 days of monitoring with no broken laws, no violations, and then absolutely fine him per the violations found and the cost of the board. But I personally think that's a little aggressive to completely shut him down for a year.
So
I
I,
will-
just want to be clear. So we're suspending him for a year. So after 1 year, he's able to go
Do
back
nail
to
business, correct.
the manicures.
He's not
So in
working
1
now in the
year-
nail industry.
Okay.
Mhm.
And how do he do that? Do he, the staff would know how to, his license suspended? How would we know if he's going to work or not? I mean, how do you do that?
Well, I guess this kind of
License-
goes back to what I was saying in the
So did he
beginning.
reapply after a year for a new license or what?
Yeah, it's
Oh,
like,
okay.
Yeah, he would just go back and reapply again, and then he would then
make sure that everything's
know what
true.
you're checking.
Okay. I just want to understand that I'm agreeing. Okay. Okay. I got it.
I think also I would like to see some monitoring for Mr. Tran. I would like to see Mr. Tran placed on probation with the fees that the state board has assessed. Mr. Landry stated that the inspection could go out, multiple times. I guess it wouldn't be like profiling or anything. He wouldn't have a problem. I'm sure he wouldn't have a problem with that. But my only problem is we've already found him guilty. And he knows that, where the board stands with that. But in order for him to make a living, and whatever reason, if there's no reason, we've already found him guilty. I just personally think in order for him to pay the fines, he needs to work and be able to take care of his family and under some supervision. Like we said earlier, I mean, how do we expect a person to move on from the past? You know that you were wrong. As a board, I'm not quite so sure if this, I just don't want to take a livelihood from someone, and this is this means to make a living, but there should be some type of consequence, which is like, probation. Very well, you haven't done anything wrong, but who says that we are? We all a step away from doing something that's not, savory.
Ms. Ritchie, would you be willing to amend your motion from suspension to probation for 364 days?
I just believe that this is going to send a clear message that, and believe me, I'm all for trying to figure a solution, help of any sort, and I just truly believe that he's committed a crime, and we all can agree that he's been here for 4 years, but he's not working right now in the industry. And it's just sending a message that we're really lenient. I don't know. I'm just having a hard time with that because we're not talking about what he did years ago, but he did commit those crimes years ago. He was convicted of them.
I think it's preferable that the board members just deliberate amongst themselves.
I'm sorry. I just believe that there should be 364 days he cannot work in the industry. Only because, and it's not that he's not being able to provide, he can go get a job. There's jobs. Do you have a clientele, Mr. Tran?
I don't think you're supposed to ask questions.
Do you have a clientele? I know, but I'm just saying,
Well, there is a motion on the table. There has been a second. The motion was to suspend the license for 364 days, to have $2,000 for each of the claims of violations of the law, to have Mr. Mishler monitor I don't know how he would be monitoring somebody who's suspended. That doesn't really make any sense.
I think if we monitored him, this is a good idea to stipulate he must notify the executive director by email of the salon he's working at, or if he stops working there, So we know exactly where he's at.
Yeah, and I did say annually, like he can submit an e-form to Mr. Mishler. This is where I'm working, this is where my place of employment. Give him the responsibility. Let him be accountable.
Right.
You need to be accountable, Mr. Tran.
Yeah, I think if he's notifying people and we're monitoring him on a regular basis, I think probation would be effective. And also, if he would take an English as a second language class, so we wouldn't be back here, would be helpful. And then assessing these costs for the board and then penalizing him. It'll take him 280 manicures if he's charging $3 to pay for his fines. I mean, that's a lot of manicures. It's a long time. It's a big penalty. It's not.
So
It's not apples and apples.
It can be made in a vote, or would you be willing to suspend, or
What about lowering the cost? Because I do believe that this is clearly not a good message to send, that you can do this and you're not held accountable. I just disagree. Maybe we can lower the fine, because you're saying it'll take how many manicures, but Mr. Tran doesn't even have a clientele. Well,
The way they work is they have certain people lined
I
up.
know we all know the way it works.
So I assume if he's out for any significant period of time, those people are lost.
I'm going to object to any comments.
So so Ms. Ritchie, I think what I'm hearing is that our vote may get passed, because I'm hearing one side of the room saying that a probation will enable the respondent to continue to work towards lowering his debt, the debt of the fines. So I guess I'm just going to have to ask you if you would just reconsider your motion to, instead of being a suspension, to be a probation, and perhaps you would be willing to go from the 2,000 to something that was a little more workable. So maybe it's only 140 manicures to pay it off. I don't know. I'm just asking. You can certainly say no, and we could take the vote and see where it goes.
Are we allowed to ask for him to take a class like English as a second language? Can we make that a requirement or not?
I personally wouldn't make that recommendation, Ms. Benaldi, because I just think that it's sending, again, perhaps it's sending the wrong message that, we do allow folks to take tests in other languages. We want to encourage people to have a dynamic language arsenal so they can appeal to a very diverse client base.
Yes.
I don't personally believe that the language barrier was the reason for non-disclosure of inaccurate information.
Can I ask if Gary, are you allowed to make recommendation?
He did.
Can he say it one more time? I know but I just want to hear, please. So everybody's clear. Because I'm not thinking everybody is clear.
Well, I think the recommendation was for revocation.
It was a 5-year revocation period. It was a $3,200 fine, which equated to $800 for each claim for relief, and the cost of the hearing not to exceed $750. That's what the recommendation was.
That's correct.
Correct. There were 5 claims, and there were only 4, so 4 times.
3,200 sounds reasonable.
Okay, but we have a motion on the table, so do you want to rescind your motion and just start again? You want to just rescind it? Say that?
I would like to rescind my motion.
And then let me have would you mind rescinding the second?
Yeah, there you go.
I second that.
Okay, so now we don't have a motion on the table, so you might start again if you wanted to propose a different option.
I would like to propose, in due respects with Mr. Laundrie, the way, just think that, I'm going to pass and let somebody else do this.
No problem. Yeah, not a big deal. Yeah. Anybody else want to give it a stab?
Actually, I would.
Please.
So what I would like to see come out of this is probation for that year. I'd also like to see the implementation of the $800 per
Violation?
violation. No. So in total, the 3,200. And also, I don't believe it's within our jurisdiction to mandate someone to take ESL classes, but I think it would be to your benefit if we can maybe help you connect with those resources just for your personal enrichment in order to ensure that maybe in the future a situation like this does not arise again. But again, I don't think we can enforce it, but I think we should, if you're open to it, allow us to maybe connect you with those resources available.
Any costs?
$750. The
And-
maximum is $750, correct? For the cost?
It can be any amount, but it's generally based on her actual costs, and she said that they were approximately $750.
I would probably defer to that then,
Okay, the 750. And then there was also in the prior motion, there was a monitoring just to ensure that during the probationary period, that there was perhaps some additional support that staff or the compliance officer or inspection department could give. Are you amenable to that?
How do you monitor?
I think it's
Hold
just
him
making
accountable.
more inspections.
Okay, with that, I didn't give it much thought, but.
You're not into it?
And it was notifying, he has to notify the board if he moves.
So you know that's already in the law. They
Yeah,
have
that's
30 days when
days.
they move locations to let
Okay,
the
but
board
he's got to
know.
adhere to it. And also, he can have no broken laws. That's,
Okay, then yes, definitely the implementation of what you just mentioned.
Okay. And so is there a second?
I'll second.
Okay, so there is a motion on the table, and there's from Mr. Baltazar and then a second from Ms. Bonaldi. Is there any question or comment or discussion? So,
The only comment I have is we want to make sure that the staff keeps in contact periodically with Mr. Tran.
perfect, okay. Anything else? So just
just
to
wanna-
restate the motion, it's a probation for a period of 364 days, $800 for
He said 1 year.
365.
Isn't that what it is? 364 days?
Well, no, the suspension was 364 because that's less than 1 year, but I think he
Okay,
said a
well,
1 year
however many
probation.
days are in a year, on a leap year or a nod year, however many days, 1 year is fine. $800 per violation of the law with a total of $3,200 with a recommendation for pursuing ESL classes with some staff support with a $750 cost associated with no additional violations of the law during your probationary period.
Would have to ask that the board needs to say the cost, the time frame for payment, that needs to be included in the order. So how long does he have to pay the fine and the cost?
My recommendation for that is within 90 days, because I'll be quite frank with you, when we see those accounts receivables and we can see them in our meeting, when it gets over 90 days, it looks suspiciously like we're not going to collect.
I agree too.
Is that the entire amount, the 800
That would be
times
the
4?
cost
The
of 750.
Okay, because we're all discussing right now, he's not working. Hopefully, this will all clear itself up. Thank you.
Thank you. Any recommendations on the cost being paid within 90 days? And
Only for the cost, right, for the 750, but the 800 per relief is going to be due when?
well, the treasurer will collect that.
You have to have the time frame for both the fine and the cost,
That's
because
the 90.
otherwise we can't send it to collection because they don't know when it's past due. So if it's 90 for both, that's fine. If you want to do longer for the fine, that's fine. I only need to know so the order can include it.
90 days. Now, so I think it should be 90 days. Yes, because that shows more good moral character. So,
Doesn't have a job right now.
well, why can't he find a job? I mean, he's
he's got a license, there's a lot of
My
places.
recommendation would be to have the costs paid within 90 days and to have the $3,200 violations or the fees, the fines paid within a year, within the probationary year. That would be my recommendation. That gives him a full year to work to pay off those fines. That goes to the state so they can manage that if they're having a problem. But our costs should be reimbursed to our licensees within 3 months. That would be my recommendation.
And I'm sorry, Mr. President, I just had to ask. Practically, that may cause a problem for the staff just because his license is set to expire in December, and normally we don't renew while they have outstanding
So
fines.
then make my
approving-
recommendation would be to have those fines paid before renewal.
Thank you.
But the costs to be paid within 90 days. That would be my recommendation. So someone made the motion, it was Mr. Balthazar?
Yeah, I seconded that.
And so would you like to include that into your motion?
Yes, I'd like to include.
And Ms. Benaldi, that
Yes,
works
I'll
for your second? Do you need to have that repeated back to you? Okay, perfect. So all those or any other questions, comments, or concerns?
Can you repeat?
Repeat that
Yes,
whole,
please. Yeah.
that whole kit and
Yes,
caboodle?
yes.
No problem. Probation for the licensee for a period of 1 year. $800 per violation for a total of $3,200 to be paid before the license renews. There's a recommendation for ESL. There's a $750 cost associated to today, paid within 90 days. And there are to be no further violations to the licensee, for the licensee. And did I miss anything?
Could I request one clarification on the cost? Because he expires in December, so can we say before renewal or not later than, say, December 31st, just in case he doesn't renew right away? I don't know. I just want to make sure we have a clear date that those.
Well, I think that's his birth date of December. So it's not the 31st, it's the renewal of his license on.
Well, the way it was said, and I just was before renewal, meaning he'll expire and he can't renew until it's paid, but he could wait. And so I just wanted to have a set date if
So
that's
what is the
possible.
renewal date?
Yeah, I think it's
So December 16th.
16? So that's the date.
So they're due by December 16th. Okay,
is
that's all I
correct.
wanted to clarify.
No.
$750 needs to be paid by 90 days.
Mr. Baltzar, this was your motion. Is that the intent of your motion?
Yes, it is. I'm sorry. I'm just jotting notes.
To the birth date?
Yes.
Okay.
I'll second that.
On or before the birth date. And that was the intention of your motion, or to the second, rather? And everybody clearly understands the deadlines? All those in favor, please say aye.
Aye.
Any opposed? Let the official record show exactly what we've discussed. You will be receiving an order from Ms. Bradley detailing this, the outcome of today. Mr. Tran, we want to wish you every success. Please stay out of trouble. And when you do fill out forms in the future, be as accurate as possible. Try not to let the language barriers interfere with honesty. You're welcome. You're able to continue working, so work hard and pay this off. You got to stay out of trouble. You cannot do that again. Sexual assaults are not what we're looking for from our licensees at all, ever. Please don't repeat your behaviors again. Please do not.
Thank you so much. Thank you.
Break for Mr. Nelson at 2:30. We'll resume in about 40 minutes, 30 minutes, 20 minutes. No, you have to leave by 4:30. That's the thing.
Did we break for lunch?
I
guys.
I just saw that you were keeping company with others instead of us, but that's okay. We're just limited time. All right. The Nevada State Board of Cosmetology meeting is back in session at 3:12. We are picking up with agenda item 17, a presentation by Ms. McCormick. We had asked that you come back to this meeting to do the presentation from our prior meeting. We had run out of time on our prior meeting, and so this time we're just still asking if we could be expedient with the presentation. Not that we're not interested, but there's a lot of business to cover. We've had, when you're ready. I don't think you need to swear in because there's no decisions to be made, but maybe just press your mic button.
All right. Good afternoon, ladies and gentlemen of the board. Thank you for letting me return to present to you our protocols for eyelash extensions for the state of Nevada. Just a quick recap. My name is Tia Luttrell McCormick, and I'm the Vice President of the National Eyelash Education and Safety Association, also known as NESA. So I put a handout. I'll be working with the PowerPoint, but based on request, I'm going to skip around the PowerPoint to try to expedite my time before you. So you should have a handout here. And if you don't, we can get more copies, but we're going to start with the proposed health and safety standards for eyelash extension application services. But before we get into that, I wanted to explain how we formed these. Oh, thanks. That's going to make it a lot easier. I wanted to talk to you about how we came to narrowing down what we felt were the most important procedures that needed to exist in the rules. And although some things are just general to aesthetics as it pertains to infection and safety control, there are some things that are very specific to the service of eyelash extensions and tools and implements that we believe need to have standards of how they should be cleaned and disinfected, and how the work areas around where they perform should look like, and very specific things such as storage of the lashes. These things are not just a matter of choice. They are definitely in the best interest of the public. It's a safety, it is definitely a safety concern. So before we start talking about the protocols for extensions, we want to take a moment to explain that there are so many different types of extensions at this point. The lash industry has experienced a huge boom in the last 4 years. There used to be strip lashes, and that used to be considered widely a professional service. You'd have them applied at MAC or, get them applied before a wedding. So it was considered more of a professional service. And now those are available at every Walgreens, CVS, Walmart. People can get strip lashes and the glue, and they can do them from home. So it bears to just discuss quickly what are eyelash extensions, and the truth is it's all of the above. But we are experiencing a lot of questions as people want to form specialty licenses or deregulate altogether. What is the scope of an esthetician or cosmetologist's, what is their scope when it comes to eyelash extensions if they didn't learn a specific form of eyelash extension application in school? And we have come to the agreement as an association that we want to champion licensed individuals. So we don't want to create more barriers for them
We don't want to punish a growing field like aesthetics with more specialty licenses, permit fees, hoops to jump through just to perform it. What we want to do is create a standard that can be spread across the U.S. and that eyelash extension professionals, no matter where they learn their skill or no matter how long they've been doing it, have basic protocols and standards that they need to adhere to. So I want to just read a preamble of sorts, I guess. This is a letter that was written from Miss Leslie Rosti, who could not be here today, but had this to say, asked me to say this on her behalf. It says, Nevada board members, I am thrilled that you are being forward-thinking in the arena of eyelash extensions and are working with NISA as you move forward. As most of you know, I am dedicated to proper infection control in the profession of beauty, and I've worked with NISA as they lead the charge on the regulation of eyelash extensions. They have asked me to collaborate with them in writing infection control standards for this practice. I have made the following recommendations as a starting point for including this specialty practice in cosmetology board rules. While many things, such as definitions, are the same in general cosmetology, there are many items unique to extension, such as handling of lashes, eye pads, and adhesive use. Given that this procedure is done very close to the eye, using sharp instruments, tweezers, and adhesives, the need for infection control rules seems self-evident. If it becomes necessary to reduce the volume of rules, I'm happy to prioritize and reduce the volume of these recommendations. Please let me know if you have any questions about my recommendations, and know that I am thrilled that this is finally being discussed in real time in an active state like Nevada. Below, she met with us on occasion and went through each step of the eyelash extension application process, noted the things that were already in general rules, and then made her own recommendations based on tools that are not in general rules, or perhaps the way that we perform the service that needs further definition. So if you skip to the last page of this packet, we have taken her recommendations on the first 2 pages, and we've combined them with existing standards for the state of Texas, the only state that has a specialty license for eyelash extensions. The person who was behind that, her name was Sophie Mercy, and she has since definitely thrown her support behind NISA to help us get these standards established and adopted everywhere. So the short list of the standards for health and safety that are specific to eyelash extension application services are as follows. A licensee offering the eyelash extension application service shall wash his or her hands with soap and water prior to performing any service on a client. B, equipment, implements, and materials shall be properly cleaned and disinfected prior to providing service. C, chairs and beds, including headrests, shall be cleaned and disinfected after providing services to each client. The chair and bed shall be made of or covered in a non-porous material that can be disinfected. After each client, the following implements shall be cleaned and disinfected: tweezers, nasal aspirators, or electric eyelash dryer, and other items used for a similar purpose. When eyelash extensions first started, we didn't have any way to dry the lashes, so they adopted nasal aspirators as their form of air. That evolved into similar to a fish tank pump, and now we have nanomisters. So there's several items that they could be using during that portion of the service. 4, The following implements are single-use items and shall be discarded in a trash receptacle after use. Disposable gloves, tissue, disposable wipes, fabric strips, surgical tape, iPads, extensions, cotton swabs, face mask, brushes, extension pads, and other items used for a similar purpose. F, the following items that are used during services shall be replaced with clean items for each client. Disposable and terry cloth towels, hair caps, headbands, brushes, gowns, spatulas that contact skin or products from multi-use containers. G, a licensee shall use only properly labeled semi-permanent glue and semi-permanent glue remover that must be used according to the manufacturer's instructions. And H, extensions must be stored in a sealed bag or covered container and shall be kept in a clean, dry, debris-free storage area. So what I just read are our proposed standards. We would like to see them added to the guidelines. We'd like to see it specifically state eyelash extension application, for people to be able to reference. Currently, we're not asking people to complete any form of competency to show that they learned infection or safety control during the training of their choice. We don't have anything in place. We don't place those barriers in front of them. We're allowing them to just explore this amazing service. But no matter what they choose to do or what type of extension they choose to apply, the standards should exist as a point of reference. And we definitely want to make sure that people who maybe don't know anything about infection control and safety can't use that as an excuse to harm the public. Do you have any questions?
I guess my only question is I hope you have a willingness to work with our regulatory review staff. So as we go into regulatory review for the next legislative session, that you offer this input to the law committee. I think we called it a law committee review or something like that. And I'd love to have you really introduce some of these. I know it's on paper, but I certainly would like you to be an active participant in that committee.
Hi. I think this is a wonderful idea because I get lash extensions myself.
Thank you.
But I'm still kind of trying to figure out how do we implement this as a board into the procedures of the licensees. Because it seems to me that they're independent. Most of them are independent contractors. So how will the board actually regulate these procedures that your organization have in place that you're asking us to pretty much help you enforce? Is what it sounds like.
It is, and it's a matter of it being there that you shouldn't have your lashes exposed. So if you're being inspected and an inspector sees that you have lashes out that have dust or debris, just know that if you're performing this service, that is a standard, that you are not supposed to have that. And it's establishing those standards that I believe are very broad. I don't believe that this places a burden on anyone to go get educated or go back to school. It just simply exists. It exists because we use our state guide as a reference point. What can we do? What can't we do? What's our scope of service? And it should be in there because we are definitely not regulating where people get trained. So it's just a matter of those things that are public health concerns exist within the standards so that if someone is being inspected, we have a point of reference as to why it's a violation.
Okay, I totally agree with the continuing of education as an educator. I totally agree. I just wanted us to kind of, as a board, to keep in mind that there has to be some type of way that we're going to be able to regulate the cosmetologists or aesthetics licensees that perform these services, because I know as far as an inspection goes, I'm not quite sure if they're going to be, if they do inspect while they're inside the private rooms with the clients. I'm not sure.
Well, I would just say some of, I think, what you've proposed is already in the law, as far as like extensions must be stored in a sealed bag or covered container. That's already required under NAC 644345. And then I know like washing hands before dealing with clients is part of the practice. So at least some of it, I think, is things people should be doing. And I guess my answer, how do we enforce it? I think the board could decide to amend its regulations and maybe add this to them. And then it's a matter of, you know, board staff goes out and what they see here that they can actually see with their eyes, they can verify that way. And then if a complaint comes in and someone's harmed, we say, well, how do you do it? Are you following this? And I know it's unfortunate, but a lot of that practical stuff I don't think we can see until there's a problem.
And one of the things we'll do is, rather than putting this into the law, because I think the law covers the scope of services adequately, we're going to take and build this into the regulations where we can have more control over what goes on and it can be changed out easier. So we'll take these and roll those into the regulations, and those are easier to pass than say, a law where you have to explain everything and go into great detail with a large group, with all the assembly people and the senators. When it's in the regulations, we just go before the Legislative Commission, which is only about 14 of the group, and you explain to them. So I've always found it's working a lot easier when you go before the Legislative Commission than before the legislature.
Well, what happens also too is if this gets adapted, then the hairdresser, the stylist are going to say, well, their whole thing is going to be, why is this happening? Why do I have to have gloves on? I'm just saying. I'm totally with you. I believe in this. I think it needs to be there. But how it's going to get there, how it's going to arrive there is a whole different level. But the backlash of it is with hairstylists that have color or using formaldehyde. I'm just speaking out of something else right now, but it kind of relates to how we're going to regulate everything. We can't. You know what I mean? So if a hair, you know, a eyelash technician that just does eyelashes, for me to tell her you can only, I don't know if it's the same where you have to use, you can't use latex gloves, you can only use, where was I reading?
No,
that?
it actually is just advising them of
okay.
when you're using latex
Yeah,
gloves.
I just want to be clear that, you know, because sometimes you do something and it opens up another whole can of worms. That's all.
I understand, and you know, we've been very mindful of backlash. We've been like working hard at looking at every angle to make sure that we're not creating a hardship for people who are already licensed. So this is actually the best case scenario. We're not asking them to acquire a different license. We're not saying, hey, we want you to get a permit now, so come pay for that. We're not saying, hey, we need proof of your training, which they may or may not have. Some are self-taught. And we're definitely not saying, you know, you have to do things this way. We're simply saying you learned wherever you learned. You have that right as a licensed person.
Yeah, but are you asking us to regulate?
I'm asking for it to exist as a standard, and if someone has dirty implements, I would expect that they know that it's not supposed to be on their tweezers if they're performing eyelash extensions. And if someone has gel pads, I would expect to not see them taped on the side of their tray or see things that should be disposable not. And those things have not been spelled out specific to this. And so if they need to be enforced, then those are things that are health concerns. They should be enforced.
Yeah, I understand.
But are you going to
like,
offer training?
Yeah.
Training for?
You know, like if just to say, Gary, I mean, Mr. Landry, I'm just saying if an individual was cited because maybe some infection or something, some client got some infection or burned or something like that.
And it happens.
And that individual come before the board and they were self-taught. So now are we going to impose some type of fine to this individual when there's no type of training or classes that exist that they can attend?
Well, actually, there's a lot of classes that exist on, you know, what we're asking them to do. They should have learned how to properly disinfect stuff, and they should know those things. But what we're not
have iPads taped here and there, and they have all these things. So
right. So you're asking what are the consequences for them? Is that?
Well, I mean, if there are some consequences, I mean, you know, how do we impose a fine or or any type of penalty to someone that has never had the formal training. So if your company could possibly come maybe twice a year to maybe the state board office and put it on the website, that we are here in Nevada in this particular location, and we're going to be demonstrating on how to do this particular, any type of, whatever company you decide to use as far as your lashes. But there should be some type of procedure to show people what to do and what to not, because people do what they do. A lot of them are learning it off YouTube, and they're getting paid for it.
Which is exactly why we're trying to get, and I understand what you're saying, and yes, we would be more than happy to do above what we do now. I mean, from webinars to, social events, we bring lash artists together several times a year. But I think it just adds to the point that if people are getting fined for things they didn't know they weren't supposed to be doing, it's a teaching point. And somewhere in there, they should have established or acquired that skill, and they haven't. But we're not going to know who those people are if we don't have a standard out there.
And I think if I'm correct, that was something that we had talked about in regulations in the past, indicating something about keeping practice limited to areas you're competent in. Because I think there's multiple types of, new products and things like that. And I know we've had testimony before the board before where somebody used, I think, a new product and they hadn't read the directions, that kind of stuff. We want to make sure people are following the directions, using things as they should be. So I think that's also an area we were thinking of trying to work into.
Well, right now, when you're going to renew your test, you have to take a test on sanitary for pedicure procedures, manicuring procedures. So are you saying that you'd like to see some sort of test, because if we're going to go there, then we're going to, you know what I mean?
I haven't recommended a test only because we were talking about the hardship on people who have not, that was one of the big concerns that you just stated, was the barriers that we're placing in front of people and over-regulating. So right now, we don't see the need for a test because we haven't put any standards in place that help us identify the areas that need improvement in the state. So the standards will help us on a lot of levels, better assess what needs to happen before we over-regulate something that, people are making their living doing, and we definitely don't want to inhibit commerce in any way.
Yeah, and I thank you for coming here and presenting this. I appreciate that.
Thank you. Thank you for your time.
And we thank you for yours. We appreciate you coming back. Our law does specifically regulate eyelashes for estheticians and then cosmetologists. So are we finding in our inspection that non-licensees are performing eyelash extensions?
I can speak to that a little. As far as our inspection team, we haven't seen unlicensed people or people practicing outside of the scope of their license. For the most part, what we're seeing are sanitation violations.
Okay.
I know Ms. McCormick came and spoke to our inspectors so that all the inspectors would know what to look for in the eyelash extension field as far as things that would be violations.
That's great.
And that way our inspectors can educate when we see it in the field and address them properly. Things like lashes needed to be in closed containers and implements need to be sanitized every time.
Yeah.
And, just proper, we just were able to find out what the common pitfalls were, and now we can educate on it.
Okay, that's great. Thank you for talking to our inspection staff. I appreciate you guys taking the time to coordinate that training effort. It means a great deal to me.
Well, thank you. All right. Thanks, everyone.
Thank you so much.
We're going to kind of back up just a little bit to item 12A. Item 12A is the cosmetology school located in the Women's Correctional Facility. The board will consider adopting the cosmetology school as it was presented, and there was quite a bit of information in your packet, so I know we're just going to get a brief overview. But Gwen, if now is an opportunity for you to just do a short presentation to kind of acquaint us with your packet.
Thank you. To Mr. President and the members of the board and staff, I just kind of wanted to go over what we're going to be presenting today here. I remember about maybe a year ago, I came before the board with one of the wardens at the correctional center, they were had reached out to our institution looking for a cosmetology program in the women's correction facility. We sat long hours during the, I think it was like the law committee changes, and we went before legislation in October. Well, it was passed. I'm not quite sure what day it was passed, but I know October 1st, the new regulations were in place where the board had the right to waive variances only for cosmetology schools located in the correctional center, far as variance for equipment and square footage. So what I'm asking for today from the board, in the packet, it shows that I did the application for Expertise Cosmetology. The registration fee was paid. Where it has here about the actual equipment is what we're asking for a variance for today. Required is 25 workstations. We'll have 6 workstations. The space is located in the Women's Correctional Center at Smiley Road. And the space was allocated by the NDOC. So it's not like a space that or trailer or anything that we're putting on the lot or on the property there. It's inside the Women's Correctional Facility. And it's not a real big room. It's a couple hundred square foot, but then we have to build it out to look like a cosmetology classroom / school. But there are 2 salons located in the Women's Correctional Facility already presently. And I was considering using some of those, either one of those 2 salons for practical, because they actually do hair services there now. So we need to get them licensed and ready to work. The shampoo bowls, we're going to do everything on that side, what Expertise will provide against what was required. And what I'm asking the board today is to waive the required to what we will be providing in that space located there. And hopefully in long term, we can get a bigger space, if applicable, and we have more of the requirements, and then the amount of students. I don't think, I'm not sure if there was a student count, but we will be training actually 12 students, 6 in the morning and 6 in the afternoon.
Bramo, I think that we knew going into this that there were going to be some changes to some of the requirements versus what could ultimately be the outcome. I just wanted to interrupt you just quickly. When on your application it says if the public is served, are you serving the public, or are they inmates?
They're all inmates.
And what about for the officers, correctional officers? Will they be allowed to have a service, or?
Well, we haven't gotten to that point yet.
Oh, okay.
I'm sure. Well, right now we're just at the stage where we're ready to open. If the approval today, and we should be hopefully, we have an opening date, which I can share at another time. I have instructors that's been trained by NDOC at Casa Grande, is where they actually do all their training for the volunteers. They call them volunteers that'll be going inside the correctional center to work. They have really tight security and rules and regulations that we have to follow. The individuals will be, the applicants will actually be picked. I will sit on the selection, but they're picked by NDOC, and they're picked by merits. The individuals that have no type of merits taken from them from the time that they were there, and they're going to be the individuals that's close to a year to 2, I think within like a 2-year period of being released. They'll get some early release time for successfully completing the program.
Before we get too into this matter, I was hoping we could just do a couple things just for the record. I know, Ms. Ramo, you're the owner of Expertise Salon, correct?
The Expertise Cosmetology Institute.
Okay, so you're obviously speaking to the board today as the owner of that establishment and not as a board member.
No.
And so the record should reflect that Ms. Bramo will abstain from this matter, given her position, and that she's the one really requesting this variance. I just want to make sure that was clear.
Okay.
Can I ask a few questions?
Yes, you sure can.
Well, I'm excited about this, number one. But just a few questions here. How long is an average person incarcerated there for? Do you have any idea what that might be?
Well, I believe it's a minimum to medium security. I'm not quite sure, but they do have a few individuals that I kind of asked that question before. That's been there maybe 15 years, around 15 years, but they have it's a short term. They have some short term and a few long term.
That's short term and long term.
Mm-hmm.
And then what happens to a student after they're released? How would they acquire if they didn't finish their cosmetology yet?
Well, actually, we've mapped out with the assistant warden. I'm working closely with her, and we've actually mapped out applicants that will be actually completed within a 2-year period. And if they're not completed within that 2-year period, and they get an early release, then they'll complete at our location on Stella Lake.
And then thirdly, what other educational opportunities are there? What exists there right now?
I know for a fact that there's not a whole lot of opportunities there for women. I think they have maybe a culinary arts, and they're looking into like a veterinarian program, but I'm not quite sure if there's any other programs there, as far as like, I know counseling and things like that, but actual programs where they will leave with a license, I don't know of any.
That's wonderful. I commend you. Thank you.
So just looking, got a couple buttons on. Just looking at your layout here, can you kind of go over that with me? What is the actual square footage that you're looking at?
Well, the room was really small because we were looking for space, and we were anticipating on taking a trailer out, and it was just going to be a lot of red tape with the state. So the NDOC found a space that they designated that they weren't using. It's roughly around maybe 300 square foot. So it's a small classroom, and the way that we're designing it, you can kind of look at the first, both of these sheets, they were done by an architect, so because they wanted everything to scale pretty much. We're going to have 2 shampoo bowls, 2 dryers. There's a counter bar that goes to an L shape where they'll be actually doing practical mannequin work. Classroom tables and chairs, there'll be a whiteboard, and all the other equipment that's required by the state.
And are we requiring you have a sink in there to wash their hands? Are you guys going to use a shampoo bowl for this?
Well, we only have room for 2, so I asked we just have the 2 shampoo bowls instead of the sink, because we're not going to actually be performing if we're going to perform services, we're going to be looking to perform them in the salons that they already have. They have 2 salons already located inside there.
Oh, I see. Okay, thank you.
And one thing.
There's 2 salons that are already, and so you're going in as a school?
Yes.
Yes. Thank you.
But the salons are not owned. They're just there for the
One thing I want to point out to the board members is that the variance that's being requested is not on everything where the required and expertise will provide. It's on these items. Where there's 25 workstations, they're going to provide 6. Where the shampoo bowls, that's typically 7, they're going to be providing 2. 5 hair dryers, they're going to be providing 2. 2 facial chairs, 0 facial mannequins, and the 8 nail stations with 2 nail stations. Those are the variances that they're asking for. Everything else, they're providing. They have a whole list. If you look on the next page in their application, they have a whole list of detergent and facials and all the other equipment that they would need to perform those services. They're going to provide all of that. The areas that they're asking for variances on or on those few items. That's what they're asking for the variance on.
And to me, this just seems like a no-brainer. I mean, we just really want to help these ladies find a vocational career once they're not incarcerated. We've already had this presentation about a year ago that said that they were interested. I'm glad, did they approach you or you stepped up to the plate?
Approach me.
Wow, that's great.
We're excited about it.
Yeah, totally.
But we've always, in the past, years ago, have always networked with the Women's Correctional Center, just going in, talking to the young ladies about when they're released, you know, that where we're located, and if they're interested in the cosmetology program. But across the country, they have cosmetology schools on the state and federal level. Before we agreed to this, we did a lot of research, and I also toured in Ohio, in Columbus Women's Reformatory. They have probably about a 4,000 square foot cosmetology institution there on their campus there, and they actually license the individuals before they leave, so they'll be ready to work. And once they're released, they'll be released to Casa Grande here in Las Vegas. And Casa Grande is a transitional housing where they actually help them, find not just jobs, but making sure they connect with their families, providing the resources they need to be successful.
And so, Mr. Landry, I guess my only question would be is, do we have a kind of a clear path that's going to help these women overcome the good moral character law that perhaps might interfere with their willingness to become a licensee?
Yes, since they're chosen by the NDOC, they're going to be the ones who have shown that they're not going to return to a life of crime. So the good moral character part of it, I can overlook that and get them to where they're tested and get them licensed. And then as they get out of prison and approach the workforce, we'll be working with the NDOC and figuring out how do they get launched to where they can work in a salon, and what salons, how often, all of that. This is very much going to be a test case, because six chairs in the morning, 6 chairs in the afternoon, you're not talking about a whole lot of students coming out of that. So when they do come out, we can provide some additional attention to them and get them back in the workforce. But I don't see this as a problem. It will be an experiment. It's going to be a lot of us working with Gwen and expertise on making sure that everything is being done and everything is being followed properly.
Excellent.
And this is going to be a first for the state of Nevada. This is the first time that the state of Nevada has made provisions to have a cosmetology school in any correctional center.
One other question I had on the supplies needed. I've never been to a correctional facility, so I don't really quite know only other than watching in the movies. But under the first aid kits and the paper clips, I'm wondering, are those allowed in a correctional facility? I don't know.
Everything that's on this list of approval has been approved by the state.
Yeah, but I mean, what I'm saying is the people that are incarcerated right now, can they have paper clips on them at any time?
But NDOC has approved this.
Already.
Oh.
The prison has already approved the list.
Okay.
Everything had to go from the curriculum to the workbooks to every single thing that's going into the institution has been approved by the State Department of Corrections.
Okay. That was my question.
We're your last stop.
Yes.
I've worked with the Colorado Department of Corrections, because my brother-in-law used to be the CFO for the department, and they have, you wouldn't believe how they map out every piece of equipment and have a place for it, and it has to be there before you're going to leave that room. It's anything that's got a sharp edge, anything that could cause damage to anyone, they will know exactly where it is.
So, Ms. Bramo, I think before you were to testify, because we're taking a vote, I should have had Mr. Nelson give you your oath to testify. And so I just want to affirm that you've told the truth during this
The truth, the whole truth,
proceeding.
nothing but the truth.
Thank you. That will suffice. Are there any other questions or concerns of Mr.
No, but the additional comment, John Davis, to Ms. Ritchie was, during our classes and everything of us going to the different prisons. If you bring 2 paper clips in, you are going to have to turn in 2 paper clips. All of the shears and the different things that will be utilized are all in lock cabinets with spaces that have already been drawn for them.
I understand, but I was just asking because I just watched the movies.
Right.
I want to make sure if I have a friend going to prison that they're protected. No.
Thank you, Mr. Davis. Any other questions or concerns? I'd like to offer or to ask for a motion whether or not the
I would like to make a motion for approval. I think this is a way of giving back to our community and to our women that are incarcerated that deserve a second chance.
And I would include in your motion to approve the variances that are being requested on the sheet that's submitted with the packet.
And so you are including that?
Yes, I'm including that.
Is there a second?
I'll second that.
There's been a motion and a second. Are there any questions, comments, or concerns? So if I'm to understand this correctly, Mr. Landry, we are approving both the proposed cosmetology school as well as the modified list of what is it called?
Items needed to perform.
Yeah. So it's both. And why did we need to approve the school itself?
Because that's what the law states. The law states that the board will approve any cosmetology school that is opened in a women's correctional or in a correctional facility.
Oh, okay, thank you. Thanks for that clarification. Any final comments, Ms. Brimo?
No.
Any other concerns or questions, discussion? All those in favor, please say aye.
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 Any nays? And so if the public record could show that there's one abstention, Ms. Brimo's abstention. Otherwise, that passes. And good luck. Let the official record show that there will be a school at the Women's Correctional Center. Mr. Landry, you had indicated that there were 4 or 5 items that needed to be kind of pushed before we, so
20.
Just taking a look at the time, did you have a preference for one over another?
Yes, 20, 21, and 22. If we can get to all 3, that would be great. If we can get to at least the first 2, because that's the budget and our future board location.
20 and 21 and 22. So if everyone could please just head on over to item number 20. I don't know why I don't have 20. What is it? I don't have that. Oh, maybe it's. Okay.
I'm assuming I need to be sworn in.
You need to be sworn in?
I'm going to be testifying, so I'm assuming I need to be sworn in before I get started.
Really? Okay. Yeah, do that.
One of the things that we are looking at as we go on, we're about 18 months from having to be in a new facility because our board current lease ends in February of 2018. And so as part of that, we wanted to look at some future locations and what we might do. We've identified four different scenarios on doing something and are presenting it in this packet. The first thing is to continue the lease where we are now. Second thing would be to sign a new lease. The third would be to purchase a building. And the fourth would be to purchase a lot and then put a building on it. And in those scenarios, we've considered quite a few things, where the location is now, where the locations of available lots are and available buildings for lease and for sale, and start looking at them and figure out something that we could put together and buy. We do have reserve funds. We do have a good cash flow coming into the agency. So we have those things that we can work with. Under scenario one, the continued lease of where we are, we don't think is too great an option. It's in the wrong space. We're in a very poorly populated area as far as licensees, and it doesn't have a great facility for us to be able to continue on. We would be potentially taking up less space than where we are now, and so we gave it an overall grade of C+ in that particular scenario. Signing a new lease, we're looking in the southwest portion of Las Vegas and looking at a couple of different buildings. In the packet, I think you have some of the buildings we've looked at that are for lease, not necessarily to propose these as ones to be leased, but these are typical of the buildings you'd find in the scenarios that we're considering. And for that, we could choose space that's the right size, we can get in the right location, and then be thoroughly fitted for the growth now and in the future. And we gave that signing of a new lease an overall grade of A+ at the current time. That may change as the cost of real estate continues to go up, and if the prices continue to go up for leases, we may have to revise that overall rating. The third is to purchase a building, and that would be to purchase an existing building that could be used for board facilities. We have found a couple of different buildings in the 6,000 to 9,000 square foot capability, which would be what we would need to service the size of our staff. And we looked at two in particular, one on Durango Courtyard offices for about $1.5 million, and another one on Fort Apache Road South at $1.3 million or $1.39 million. And both of those we thought would provide the adequate square footage and also give us the right facilities. But again, this isn't for right now. This is, when we're coming up for lease, we'd have to approach them at the proper time. So even though they're available now, there'll be other buildings that'll be available, and those are the ones we'll be considering. And we gave that an overall grade of A+ because the location is good, the facilities are properly sized, and they would make a great office for the agency. The last thing that we considered would be buying a lot and putting a building on it. In that particular area in the southwest part of Las Vegas, we only found one lot that seemed adequate, and that's in 5525 Redwood Street, and provides adequate space to build up to a 9,000 square foot. Could be actually put a 12,000 square foot building, but could put up to 9,000 square feet in building. That particular location, the lot would be something we would buy, and then we'd go back later with building plans and build a building. That would be a grade of A because there's some variability for building and the cost of building, and we're not sure exactly what that would be, so we're still investigating that. What we wanted to do with the board today is just bring these before you, have you take a look at the different buildings that we've looked at, and then give us some direction or guidance on this is what we're looking for, this is the direction we want you to head, and then we'll bring back at a later board meeting when it's time for you to consider an actual offer on a particular building. And we'll work with some of the different developers and all that have these buildings for sale and try and get them priced appropriately. So that's where we are now.
Mr. Landry, are we going to be partnering with any other board, like the Massage Board or the Taxi Cab Authority or anything?
That we're looking at also. As soon as you give me some direction to go, I'll know what size building I need to go for, and then I'm going to start talking to the directors of those agencies. The problem we face in this particular area, for whatever reason, most of the boards have their headquarters in the Reno area instead of Las Vegas. And I think that's a big mistake because all their licensees are in Las Vegas, obviously, from the population. So that even though they have needs, most of their needs are in Reno. I think that's going to change over the next several years because everyone's going to locate and headquarter their buildings in Las Vegas and have a branch office in Reno. But currently, all the smaller boards, our size and smaller, are all pretty much in Reno. There's very few that are located in Las Vegas.
Are you considering at all like a sublet of an office space to them so they could begin to have an office in this southern market?
We would, and we first approach the boards that have inspectors because those are the easiest ones, where they share an inspection team with us, and those are the ones we're going to go after first. So those boards that are providing inspections, we'll try and hook up with them and see if we can get them to agree with us. The first thing is just to figure out, do these look plausible to you? Do they look feasible? And if we have a good offer, a good mix that we could go with, do you want us to bring it to you or not?
So can I ask some questions of Andrew here?
Sure.
So when looking at a lease versus a purchase, the cost of insurance on owning your own building goes up significantly. Also, that way out as far as the ROI goes, how are we looking at that? How is real estate now versus a couple years ago? Are we in an up market?
Andrew Helms, Chief Financial Officer, for the record. Basically, right now we just need approval to go in a direction. So to even speak with a bank, to even look at mortgage and calculate the numbers, we just need the approval to even get to that point and then kind of calculate out, okay, what can we do?
Well, it's a pretty big difference between renting and buying, so
Correct.
we can't give you one or the other without the numbers for a budget. So I'm confused.
Yeah, we're looking for, if you say, look at buying a building, look at leasing a building, and come bring us the alternatives, that's what we're going to do.
That's
So-
what I like.
So
Well said.
That's what
I
we're
have a
trying to do, is
question.
get the board to tell us what direction you want to head in, because right now, we have plenty of time. 18 months is a good long time to find something, but you'd be surprised how quickly we're going to be 6 months from having to move and saying, we haven't started looking yet. And we don't want to be in that situation. We don't want to be in the same building we're in now, and we want to look proactively as quickly as we can.
I have a question.
Go ahead.
Okay, my question, I think it could be for Andrew. I'm all for owning your own building, but the question that I have is, who would guarantee, because it's an agency and it's a state agency, with the banks and financing, somebody has to be a guarantor for the loan.
And that's, Andrew Helms, that's pretty much what we're trying to figure out now, is what will the banks even give us? We know that, just speaking informally with Morgan Stanley, that we're approved for a liquidity access line. So it's similar to a loan, but it's not really a loan. It's more of, it's secured by our investments with Morgan Stanley. So that's one option. But as far as like those finer details, we can't move forward with any banks until we actually get approval from the board to investigate. So that's kind of where we're at now.
I know PERS has purchased their own building, and they're
Well,
one of the only state entities that have.
There are rules about purchasing, and I think other state agencies are a little different because they're covered by the general fund. But I would have to look at, I don't know off the top of my head, but I know there are rules about what the state can do in finance, So we'd have to look into that. I'm not sure. But yeah, PERS, I mean, the state buys buildings all of the time, but they're not normally boards that are separate from the general fund. So I think this board has a little more freedom because you have your own money to kind of spend. The question I'm not sure about is, can the board legally get a mortgage? And that I don't know, because there are some Nevada constitutional requirements about taking debt as a state. And so that's what I'm wondering about.
Well, you have 18 months left. By the time you acquire a property and you decide to move forward, you realize you would be pushing that. So the other thing you have to take in consideration is, if you rent a building now, this one right here, I almost rented it 6 months ago, this one. Upstairs, it's 12,843 square feet, and you need 9,500 square feet. Here's another thing you have to look at. Even in my own business, I can buy buildings or I choose to rent them. And the reasoning why at the end of the day is sometimes it can work into your favor. I understand that, Andrew, but long term, how long have we been into State Board right now? How long has that office been there? 30 years? How long?
We haven't been there for 30 years. We've only been there
I know.
for probably 12 or less years.
But I would say, I thought Mr. Gibno
Yeah.
moved there.
That's been there, listen, I've been here for 28 years. It's been there. Yes, they just moved is all they did. But here's my point. When you buy a building, where are you going to be in 30 years with location?
And that's why we want to look at all possibilities. So what we need from the board is for you to vote and tell us, you look to lease, you go look to buy, come bring us the alternatives, and we can decide then, because that's what we're going to do, is we're going to bring you
I think at
some
this
choices.
point, you're kind of behind the ball. And I don't know, would you agree, Mr. Helms? 18 months out to buy a building, to get funded?
Honestly, I don't have the experience to purchase a commercial building as far as the timeline goes, but I would think that if we get approval now, we can enter discussions as soon as next week with banks and other lending institutions to investigate what our options are, as well as discuss with legal counsel if it's possible.
I just wanted to put that out there about how long it really does physically take to do what you're about to do.
So do you need a vote, or you need just direction?
Just a vote, and if you'd like to have us investigate leasing a new place and potentially buying a new place and bring those back to you as two alternatives, that's what we would do.
I would like to see the state board own their own building. We could have had that building there paid for.
Yeah.
Mr. Landry, I like the idea of having like a professional services incubator type of space where you can partner with other health regulatory agencies and be able to offer them space in terms of the inspection departments and maybe even some clerical that they would inadvertently need to do in the southern market. It's my preference to have lease space just because I feel like we're either going to outgrow it or we're going to underutilize it, which it seems like during your tenure, you've had to find ways to utilize the boardroom. And then it expanded the way that the testing worked out. So I feel like you did a good job of taking what I would consider kind of dead space and making it kind of useful. And my only concern with being in a purchase building or in a build-to-suit kind of building situation is that maybe it doesn't allow for the growth of what is ultimately the vision. And I don't know if that's your vision to have a professional services type of incubator environment, but it seems like I think that there were hundreds of boards. So it seems like we could network with it.
It could be a really good investment because if your interest rates are really low, you might be able to acquire a piece of property and actually have less rent, but you have to take into consideration all the other factors like insurance and this and that. But
you also have to calculate in their risk, because you remember when everybody bought, what happened? Fell out.
Oh, it's true. That's what I'm saying. Where are we at? Where was it 2 years ago? Where is it going? Are we in an upward swing?
What
I'm
is
sure
your
they'll take that all into
preference?
consideration.
My preference is to get a lease or a buy, and I'll figure out the differences between the two and present that back to the board. Because that's the thing that I would suggest is we have to look at buildings we can lease, look at buildings we can buy, weigh the two of them, and then I'll present, here's what it is, here's the risk, here's if we grow and combine, if we're getting bigger, this is what we would need, and we may not be able to do it on a buy. We may have to do a lease, get it for 5 years, and then look to buy, or maybe lease for 10 years. So those are the type of things we want to work out. But we do need a decision by the board so that we can get with the banks and start looking at all the different factors.
Can we present a motion now?
Any other question, comments?
Well,
or
and just one
concerns?
last thing is, can we put them on alert that maybe we can go to month until we have a day?
I'm sure that we can probably swing a couple of months, but
I've done it for my people, at least for me. So
especially where we are now, because there's open space. They haven't leased all the building out yet. So it's not, I don't think our building's not in a hot property. I don't think we're going to get a lot of people in there. So I don't think it'll be that big a deal. But I just don't want to be faced with doing that. I want to have a decision. I want to have something signed, and I want to be ready to go.
I think I want to ask you one question. As of we are today at 10 after 4, aren't you glad that we don't own that building we're in right now?
Definitely, I would have never moved there in the first place.
We still could have sold it.
But we were in the middle of town for everyone.
All right, so if there is a motion on the providing direction to Mr. Landry and staff to pursue I guess relocating our office is really how that kind of gets summed up.
I'd
And
like to
it's-
make a motion. Sorry, Alex. It's
No,
time to go.
please.
I'd like to make a motion to instruct Mr. Landry to bring us back both lease and buy proposal, and as soon as possible.
I would second that motion.
Any other questions, comments, or concerns? I guess my only comment would be that I'm more motivated to lease the space, whether it's in a 5 or 10-year increment. The idea of building the space, I would want to kind of ensure that we're being more cooperative with other boards, other professional service boards, and at least having some type of written communication that says that they either would or would not want to occupy some of our space.
Can I share some information on this one property right here? Did you view the building inside? So it's going to need some TI dollars, tenant improvement dollars. So did they say how much they were going to give you? Because I did an LOI on it. That's why I'm wondering.
This is just showing you buildings that are available. We haven't done any investigation.
This is a great building.
Because until we get direction from you, we can't move forward. That's the one thing. We didn't want to go too far, so we looked at buildings and saw some possibilities, but we have not investigated any of them.
So who does the negotiation part of the lease? Would that be our chief financial officer? Who would do the LOI?
It'll probably be Andrew, Adam, and myself, all three working against the other tenant, or against the building owner, I should say.
Yeah. Okay.
So there's a motion on the table. Anybody need that reiterated? And there was a second. There was a second, right? Okay.
Yes, I second it.
Thank you. All those in favor, please say aye.
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 Any opposed? That motion passes, so let the official record show that, Mr. Landry, you're instructed to come do that comparison for purchase versus lease.
Okay, and I'd quickly move to budget approval, because unless we approve the budget, we can't start next year in July 1.
Okay.
And on item 21, budget approval, in the budget summary, I've kind of gone through each item and put what's there as far as application fees, examination fees, board fine income, license fees, inspection fees, new revenue income, operating expenses, salaries, in-state travel, all the things that had any kind of changes, and tried to explain them, as well as out-of-state travel. And the projected net increase in unrestricted net assets for fiscal year 2017, July 1 of 2016 through June 30th of 2017, is $5,700. So we're net positive $5,700 when you don't consider the excluding depreciation. So willing to take any questions. Andrew's here to take questions, and we can answer as needed.
One of my questions it was for the new board members, and there will be additional new board members coming up, and then at the mid next year. It was always my intention that new board members should always try to make at least one NIC meeting. And that's kind of been put back on the back burner. And so in the budgeting, I'd at least like new board members to be able to turn down the request to attend them. But attending the NIC meetings, you can meet board members from other state boards of cosmetology, and you may find it to be enlightening or helpful. So for me, when it comes to the proposed budget, I just would like to see an allowance made for new board members to always be given the option of attending that national meeting.
We have one board member budgeted to attend, but we can add additional members to the mix.
It always is very difficult to compliment the hardworking staff, and yet at the same time want to pull back on wages and salaries. I know that I can feel the daggers, so it's one of the most challenging of discussion points. But we continue to receive the audits, the annual audits that discuss that salaries are increasing. And so I just to bring your attention to focus on how we can solve that problem. We used to be able to charge for that extra test fee, which offset some of those salary increases, but we reduced that second time test price, and so we don't offset it as much. We're also going to run into a situation where once we have the 4-year licensing, we're going to end up having a big wad of money that gets thrown out over 48 months. And so I just want the board to be aware of those 3 or 4 situations that the auditors are pointing out that salaries do comprise a huge portion of our budget, an increasingly large portion. How are we doing on saving in the board meetings? I mean, now that we've been able to teleconference our meetings, have we seen a saving in the expenses associated to board meetings?
Not a great deal. It's a fixed expense, but it is very low, and we have utilized that space better because now we've converted the boardroom to a testing room, and we're well ahead of schedule on testing. I think you can talk to Gwen and talk to the other the other school owners and talk to them about scheduling, and that has really accelerated. We don't have any delays. There's no one that's complaining about, oh, it takes me 3 months to get tested or 2 months. It's all within a couple of weeks. So that's really helped out from the service level in getting the testing done and getting the people licensed as quick as possible.
Off the record, I just want to let you know, I've had so many people tell me, God, the state board has really come away, Debbie, getting their tests, being able, I just want to commend you for that.
I just have something to say about technology. I think it's really great, and I applaud you as well as Debbie. But I think there comes a point where, like these tablets, $20,000 down the drain. I mean, that's just not acceptable. I don't like to waste money. I think that if we're going to spend it, it should be effective. But you can't just buy every new gadget that comes along. At just some point, we're going to have some sort of line on that. But other than that, I think the budget looks good. So.
And on technology, we've tried to put together a schedule where we're going to do replacement so that it's not a surprise. And that's one thing we've got built in. We're not replacing any of the desktops because they're not brand new, maybe 2 years old. But by the time they get to be 3 to 5 years old, they'll be in a replacement schedule. So we're going to start replacing those as they come due. And when we replace them, we won't necessarily pull them out and get rid of them, because we can upgrade them to Windows 10 and continue using them maybe in the testing room or things like that where you don't need as much processing power. But our plans are to go from where we are now to the future is going to be to probably get rid of desktops, not use them as much, have a portable device, either a laptop or even a tablet, and move to all tablets.
That's great.
Were we able to sell board member tablets on the secondary market?
No, we're using them in our office now and testing them out for dealing with the front desk. So we're looking at putting in a card reader so that we can read cards and take the payments with that and not have to go back and forth to the desk like we do now. That's an unfortunate situation that we're in now, is that you have to go to the front, help the person, go back to your desk, type it all in, and then go back to help them. We're going to try and do it all on the tablet. So that's one of the things we're working on now. We should have the tablets all pretty much done in the end of June, early July timeframe, and then we'll start implementing them and start rolling that out. So it'll be easier to work with the tablets and working with the people at the front desk.
And with new board members coming on in 2017, when was your intention to do a board retreat?
We're going to probably do the board retreat the same as we did this year in February. We'll look at, because we're going to have 2 new board members next year, and we may have like a mini retreat and just focus on them, depending on whether they're going to be in Reno or Las Vegas. If they're in Las Vegas, we'll just have it in our office. If it's in Reno and Las Vegas, I'll probably have to go both places. Maybe Adam and Andrew accompany me where we can go a full day and just let them know everything everything they need to know in a day. Probably with one-on-one training, probably wouldn't take a whole day. It'd probably be about a 5-hour session.
So it'd still be my preference to allow more than one board member to go to the NIC. Based on this budget, you're only allowing the one. Any other questions, comments, or concerns regarding the fiscal budget for 2016-17? I'll accept a motion to either reject it or approve it.
I'll make a motion to accept this budget for 2017.
I'll second that motion.
Any questions, comments, or discussions? All those in favor, please say aye.
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 Any opposed? That was unanimous, Mr. Landry.
Thank you, and we will make sure that as we go forward, we're looking to crank down on the amount of cost and cut out as much cost as possible with the new software.
Thank you. Mr. Landry, were there other, we have about 10 minutes. Did you have a specific?
Yeah. I mean, what I would suggest, Mr. President, and I don't know what board members think, but that perhaps we consider a phone meeting or something to do the regulation agenda item as well as the BDR, just because those will need to be submitted if we're going to go forward on them. Otherwise, we're waiting, I think, 2 years or something. But you may want to go through 23 if you can quickly, and then, yeah, comments 24, comments by the public, and then adjournment. I think we probably just have time for 23 through 26 right now. And then the BDR, which is number 22, and then the regulations is number 13. And I know maybe you don't want to do all of the regulations, or maybe you want to do some of them, I don't know. But the thing is we have until July 1st, actually June 30th, to submit regulations, or we have to wait until 2 years after, after session, I'm lying, it's not 2 years, it's 1.
I would rather not do it on the phone. I'd rather have a get-together, because I think there's some very serious things that we need to discuss about that. So another board meeting, maybe
Well, I mean, some of those
emergency
are
board
to
meeting.
say that it's illegal to do prostitution, for example, in salons. So, I mean, some of them we're just hoping we don't have to wait a year to have.
But some of them are just kind of,
Then maybe we should separate them out. I mean, I'm not opposed to that. I just didn't want to wait on some of the ones that I hope we all can agree to. And then the bill draft request, I know Mr. Landry needs to have that relatively soon.
well, can we get together? Can we have
Mr.
another
Landry?
board meeting?
Thank you, Ms. Minaldi. Mr. Landry, last time we did that special meeting, was it a lot of effort to coordinate that? Because, I mean, I know it was kind of perfunctory, but.
It depends on if everyone has to be in the same spot. If we can do it by video conference.
It seemed like we
That's
did the
pretty
last one by video conference. There were some, I think, in fact, you were down in Vegas, weren't you? And we
Yes.
were up in the north. So if that wasn't a lot of effort to put that together, maybe we could just repeat that planning.
And just do the bill draft request and then the regulations.
Or
Just do those
whatever
two.
items you wanted to make sure that we got through from this meeting that we're not able to attend to.
Just watch your time.
And so are you sort of thinking that that would happen over the next 2 to 3 weeks?
Yes, I'd get and coordinate with Monica, and we'll find out what dates are available for both rooms. And whenever we have dates secured, then we'll get something put together, because the agenda has to be put out 3 days before the meeting. So, time is ticking to get the thing together.
And possibly the lease buy option. We could talk about that when you get there. That'll be quick. That'll
Yeah.
speed that up.
That sounds great. So in the last 5 minutes remaining, are there additional comments by board members that you'd like to see on a future agenda item, as a future agenda item?
I have a comment. When I was looking through the bill draft request, I just kind of felt like as a board, there were some things that we can probably, or we should probably consider. And I'm just kind of, because I'm education oriented, I just think that I did some research I want to share. And I researched all the states that had CEUs for a cosmetologist. So there's some changes that we want to make as a board, and I think that we should put that on the agenda. It could be minimal, but it's some type of additional training in your field.
I agree.
Along with the sanitation exam that they have to take.
I agree. In fact, that's one of the comments that I have, is taking a look at NRS 644.325, subsection 5, which is the person must complete at least 4 hours of instruction relating to infection control in a professional course or seminar approved by the board. And so I definitely agree with examining CEUs, and I'd like to see that on a subsequent agenda. I also, I don't mean to interrupt you, Ms. Bramo. Were you?
No, I'm
okay. I also wanted to take a look at NAC 644.372 and perhaps have the board research that, or have staff research that, and maybe perhaps provide us with some additional information. So when we're making the BDRs, or the bill draft requests, or I guess it's the regulatory changes, that we're comprehensive and we're not just listing that one item, formaldehyde or whatever it was, methacrylic thing. I'd like to just be a little bit more comprehensive. If we're going to be sending something to LCB, maybe we could make sure it's real thorough. So that was an NAC. Any other comments by board members for additional items? And then, of course, the items that we didn't attend to today. So perhaps that would be a little longer than a perfunctory meeting like the last one was. Okay. We don't need a motion for that. So comments by the public. We've had several members up in the north. Is there any comment from anybody in our northern office or northern meeting that would like to make any comments to the board? We have about 3 minutes remaining, so if you have something you want to say, please stand up and do so. Boy, somebody's doing it.
Hello, my name is Kai Stanton. I'm a current licensed cosmetologist as well as a licensed instructor. I would like to speak regarding the classes for licensed instructors. I'm actually currently working on a curriculum to help support licensed cosmetologists, from creative training and teaching methods all the way through hands-on how to capture attention, going over information on different learning types, keeping your class motivated through visual trainings, as well as going over information regarding infection control, the current information on how social media is affecting the licensed Cosmo, and various other information that has helped me in the current classroom. So I would like to submit that hopefully way before next meeting, so that can be thought and also hopefully put together with the standards that are, it sounds like coming together. That's the direction that the board is looking at regarding the CEU accreditations, classes with a strong meaning that can affect our students positively in the career.
Oh, thank you very much. Will you please make sure that Charlene has your contact information?
Yes, sir. I'm very interested in doing so, and I would love to be a part of that team to head off the educational part for the CEU accreditations for the licensed instructors. I am more than willing to do any extra training that is required by the board to make sure that all standards are met across the board.
Thank you very much, Ms. Stanton. I appreciate you taking the time.
Yes, sir.
And any other comments? We have about 30 seconds remaining. That was good. She was quick. I like it. And absent that, this meeting of the Nevada State Board of Cosmetology is concluded at 4:30.
I guess this isn't your last week.